involuntary manslaughter, there's probably sufficient for that. It's the involuntary manslaughter we are certain.
That's good. And I would point us to Yo.
You're the first one in, Kiera. We had to do this for Miss Lely.
I sent you each a working copy of something.
Just starting.
Having in mind, even if you read through it, there are certain struggles that I'm having to make sure I tweak this right. And some of it is there's some confusion in the law, but we'll go forward. We're here in the matter of State versus Joseph Palazzo, 21 CR 8967. Mr. Palazzo is present with his attorneys, Ms. Jansen, Ms. Johnson, and the state is present through Ms. George and Ms. Adams. We're here to discuss proposed jury instructions. The court has received proposed instructions from the defense back in November. And the state's response yesterday, seeking to tweak some of them and remove some of them. And I guess one question I have for the state is obviously your revisions or requests to deny were made before you heard Mr. Palazzo's testimony. So the first question is, are you still seeking to have no instruction on voluntary manslaughter?
No, Judge, I think that our appellate folks think that the voluntary manslaughter, there's probably sufficient for that. It's the involuntary manslaughter we are certain.
That's good. And I would point us to Yo and Delisle and Belaski, all of which, Yo and Delisle particularly, did not seem to have an extraordinary amount of support for it. And the Supreme Court was still pretty clear we needed to instruct it. My next question is this. It has always, the absence of great provocation language has always been addressed in second-degree murder cases. The language of the court has been broader than that. But in Yo, maybe paragraph 23, it talks about that a finding of premeditation and deliberation necessarily precludes a finding of great provocation. I don't know whether I read that to mean you don't give it in the first because it's already embedded in the definition, particularly of deliberation, or whether you still give it in first degree. And I couldn't find, I don't know if you have it back in your files, Ms. Jantz, from when Jerry Schwartz tried the case, but I'm wondering if you know what the language of the first degree was.
I don't, Judge, but I did speak to Attorney Saxman. She's the one who was the appellate attorney on Molaski, because we've talked about how there's no rational, logical distinction between first and second degree in terms of the passion provocation instruction. And that the only reason it wasn't addressed in Belaski is because he was only charged with second degree, not first degree. In Yo, he was charged with first degree. And I have in front of me, murder and manslaughter are both lesser included offenses of murder in the first degree. So I think that there is, and that also refers to Delisle. Voluntary manslaughter is an intentional killing committed under extenuating circumstances that would mitigate, not justify the killing, such as provocation that would cause a reasonable person to lose control. And there's no distinction between degrees of murder. So I think it's appropriate in both the first and second degree.
So you don't think it's necessarily included I almost wonder if it's better done as a subset of the deliberation instruction. It's awkward to me to think, since Yo speaks directly of the fact that if you find premeditation and deliberation, you're necessarily not finding great provocation. It would almost seem it's best to include as a subset of those rather than a separate element, because it doesn't make any sense as a separate element when they're addressed through premeditation and deliberation, as opposed to second degree, which it's the intent element that it is understandably a separate element.
So my one goal is to make it as clear and not confusing to the jury as possible. In both, our understanding of the law is that in both first and second degree, the burden is on the state to prove beyond a reasonable doubt the absence of passion or provocation. So even if the state were able to prove all the other elements of first degree murder, they still also have to prove the absence of passion or provocation in order to convict on first degree.
No, I appreciate that, but since
where
we
to
know
put it?
from Yo that you necessarily are concluding that if you find that's premeditated and deliberate, it seems to me it's better as a subset of, I'm not saying you're not entitled to those words. I think you are, given, and that's what I've been going around in my head for days, actually, because I wasn't quite sure what the Supreme Court meant in paragraph 23, I think it is, of Yo. But because one way you could read it is you don't have to do that because it's already kind of in the premeditation deliberation language, so necessarily they're finding it. But I think it's better given the case law and given the fact, this was first introduced in State v. Hatcher,
I've got that.
which I had a lot of familiarity with when it came out. I did. And in that case, Judge Katz actually directed a verdict on the first degree. So it never reached that and only let the jury consider second degree. But that's where the language came
That
from.
is where the language in Hatch, paragraph 7 and 8, where passion or provocation is implicated, the court must instruct the jury that to establish murder, the state must prove beyond a reasonable doubt that the accused did not kill under influence of passion or provocation. It sounds to me that the court is struggling with where to put this language.
A little bit. Now, at first I was wondering whether to put it at all. You'll see I put language which I'm not very happy with, which I said probably have to work on. Ms. George, Ms. Adams, your thoughts about whether it needs to be included in the first degree instruction?
Well, I tend to agree with the court that you can't have both. If one of our essential elements is premeditation, deliberation, those are our elements. Those are what they need to find. And if they do, they have already discounted any provocation. And if they don't, then they go into the second degree where that instruction would be.
I'm wondering, though, whether the defense is at least allowed some clarification that you can't have a finding if the state as part of that must prove beyond a reasonable doubt an absence of great provocation, because that would be inconsistent with deliberation. That's what the Supreme Court has said. I'm not sure I think that necessarily follows, but it is what the law says, and they've said it a number of times. So I'm not. You don't have to push me on that, Ms. Jantz. It's an interesting question, though.
So, and just, I hear the court, you're already there, but we discussed at length whether it should apply to first degree in addition to second. And the case law makes no distinction, and it shouldn't. It
Well,
is.
case law hasn't really
Has
dealt
not-
with it.
That's right. So it is something the state has to prove with respect to first degree murder as well as second degree murder, that there was an absence of passion or provocation.
I guess the question I have for you is, in cases I've seen of first degree, it's always just got the language regarding premeditation, what premeditation and what deliberation means. And those definitions at least seek to say that sudden impulse, and if it's done under sudden impulse or without thoughtful deliberation, they haven't proven it. And does that not cover it to some extent?
I don't think.
Well, to some extent it does, but does it
No,
cover it?
Because I think the language from Hatcher is what we need. That the state must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation. The burden's on the state, and beyond a reasonable doubt. And that's, if I know it's not a statutory element, but it's been added through case law, that is an additional, I don't even want to use the element, you word element. It's an additional thing the state has to prove in order to get a conviction for murder.
Isn't Hatcher second degree?
Yeah, they're all second degree cases. That's why,
That's,
except for Yo, and I don't have the instruction in Yo as to what, but my educated guess is that it wasn't included in there. I mean, there was no manslaughter instruction in Yo, which was considered error but harmless in the case.
was it?
But I don't know what the first degree instruction was.
I don't know this instruction, Judge, but I'm just looking. Was there testimony about it?
It's not. I mean, I had something to do with Yo too, and I don't remember that specific issue coming up. And I don't see it in any of the reported decisions.
So I'm looking at Yo and distinguishing between first and second degree. I'm looking at paragraph 15 and 16, and it says, without more, though, we would still reverse appellant's conviction if the jury had chosen to convict him.
Right, of second.
Second degree. So, but they convicted him of first degree.
Right, but that's what I'm saying. It because they necessarily find that a finding of premeditation and deliberation negates the great provocation. So the inference I drew from that is that those instructions on that were sufficient, and at least at that point, there's argument to be made that it's not as clear as it should be if we've got the absence of great provocation, which is better suited in the second degree. It makes more sense there just because it's an intent issue, and we're saying, yes, it's intent for second, but yeah, if there's great provocation, that intent, it's reduced to the manslaughter. But that's only in the context of second, because first degree precludes, given the finding of premeditation and deliberation.
Well, we still think that it should be included in the instructions regarding first degree. I understand the court's distinction on the issue of intent, but I think it goes directly to whether there was premeditation and deliberation.
Yeah, there are cases out of other states that kind of go both ways. California's, but it's a 1931 case, seems to support that it should be in there. Other jurisdictions, not quite as clear. All right. Um,
Does the court want us to go through page by page?
Yeah, I wanted to bring that one up first because that to me is the most, that and the involuntary question are probably, I do think there's a voluntary, I was concluding a voluntary manslaughter instruction was appropriate. This is an interesting case. Might have been more appropriate through what Mr. Filazzo says in his interview than it was in what he said on the stand, although because there wasn't really a connection made between past conduct at either on the night of the incident or preceding the incident in his testimony that led to the shooting under the testimony that he gave yesterday. When I thought further, I said, well, I guess a jury could think that something, he thought a gun was coming out and she was saying things and there's great provocation, but not sufficient for self-defense. So even on the state testimony yesterday, I think that it probably has to be given, and maybe even more directly, given a jury's ability to make that distinction if they wish to.
I'm
On the voluntary.
Yeah, I did ask Attorney Johnson in our office, who I think did the Yo appeal, if she has the instructions. She's looking for them now. She thinks she
Okay.
does. So we want to go through the rest.
That would be great. Thank you.
Get them.
That would be great. And why don't we do you both have in front of you what I sent?
Yes, I do.
Yes, Judge, we do.
You'll see there's some yellowed parts too.
On page 1?
Not on page 1. I'm getting back to page 1.
Okay.
I was on a different page. All right. So page 1, let me just say what I did do, which I don't usually do. I don't usually do the charge on page 1. I usually do it before I do the elements of the crime. But both of you asked for it there, so I put it in there again. And I added, Mr. Palazzo has pleaded not guilty to the charge. State didn't request it, but the defense did. So if you want it there, that's fine. Any objection to page 1?
No.
No, Judge.
Okay. Page 2.
No objections.
No objection on page 2.
All right. Page 3, and I'll just note for you, Ms. Jantz, I think I moved the reasonable doubt instruction from where you put it to where I usually put it, which is closer to when I'm reading the elements of the crime.
That's fine.
Okay. So this is the evidence and circumstantial evidence piece. And Ms. George, I did not include your last sentence regarding Mr. Filazzo, but I just didn't think it was necessary on the circumstantial evidence.
I have no objection to page 3.
Into page 4, let's do the whole circumstantial evidence.
Yes, that's 3.
No objection.
All right. Page 4, credibility of witnesses.
No objection.
Let me just take a quick look. Looking at the reasonableness of the testimony of the witness considered in the light of all evidence in the case. And I think that is ambiguous and maybe confusing. I don't know that
Me too.
we did. Ms. Johnson's telling me that we had it, so I'm going to leave it alone.
It was in
That was
your
us.
instruction.
Okay.
So no
Let me
objection,
just
or
finish.
is there?
I'm not finished reading.
What's that?
Just one more second, Judge, please.
Yep. Remember, there's a fan going on in here, so try and keep your voice up.
Oh, okay. That's fine. Page 4 is fine.
All right, no objection to page 4 from either party. We'll move on to page 5. Are you still reviewing page 5?
Yes, so
Okay.
your yellow highlighted.
In 5?
On 6.
Oh, we're
I
on
think
6.
that's on 6.
Oh, 5 is fine.
Okay.
I apologize. I was on 6.
So the yellow highlighted is in the model instruction. I didn't know if it was particularly relevant in this case. It did not seem that that's where you were going, but it is in the model instruction, and usually the primary basis for why statements would or would not be found to be involuntary. But does the state want it in? I'll start with you.
Yeah, I think that the one above it, Judges, covers it. There's no evidence of any of that in this case, so I don't think it's necessary.
I tend to agree, which is why I put it in yellow. And I thought you also might not want it because it might focus too directly on something that may not be your strong point.
So I don't agree that it's necessary to have the sentence that begins, if you find Mr. Ferlazzo would not have made statements, ending, person accused of a crime that are, I don't think any of this is necessary. However, the court did not include what we asked for, which is that you may also, so what we asked for is if you find Joseph Ferlazzo would not have made the statements, but for some threat of harm or punishment or promise of leniency, then you may find the statements not voluntary. The sentence that we asked for was you may also find the statements not voluntary if you find Joseph Ferlazzo was not thinking clearly and rationally because of his mental and physical condition.
Yeah, that's not the law.
Well,
So, and in fact, State v. O'Neill, I think, was cited in Judge Griffin's opinion, and it says specifically that's not sufficient.
one second.
So there's got to be some police involvement in this. If it was also always just being, first of all, I don't know what rational necessarily means in that regard. I mean, if you found that he was in a psychotic state, that might be basis, but I think it's way too broad to suggest that if you find that he wasn't or wasn't thinking clearly,
Well, then if,
That's just not a standard of voluntariness
So-
that the Supreme Court's ever supported.
if that's the case, I do object to the court's ruling, but I then would ask that you remove everything that's in
All right.
yellow highlight.
I think that makes sense. We'll remove that. Right, let me do it right now from mine. And it really is the remainder of the model instruction, I think, without that part. Anything else on page, there's only the number of witnesses, the other thing on page 6.
No, Judge.
Did you have, Sarah, what about your stipulation concerning the pillow that you sent, didn't you email us this morning about changing that stip?
What does that have to do with 6? Is it on there?
No, it's not in here, but
Yeah, stipulations in the next.
yeah. So Judge,
Yeah,
you have in yellow highlight, add gun/bullets.
well, it just, we said we were going to give everything to them.
Right.
We're not
Not
giving
to
them
include
everything.
gun bullets.
So I wanted to know how we wanted to,
I guess,
Yep.
Judge, from my perspective, the bullets are the only thing I don't think should go into the jury.
you want the gun to go in, but not the bullets or magazine.
Yeah, I mean, I think that part of our argument is that when Mr. Filazzo admitted that the silencer is on it.
I don't mind, I don't, at the time you said both, but I understand the difference. I don't want anybody to have the ability to do anything harmful
Agreed,
with the
yes.
gun.
I absolutely don't think the magazine or any of the bullets should go in.
Okay.
I do think the gun should.
All right, so you're asking that so then we still have to deal with that. I don't suspect they're going to really care about the bullets.
No.
The PowerPoint, on the other hand, do you have an exhibit other than that screen shoots the PowerPoint or otherwise has it in documentary form? Do we have that? Or
PowerPoint?
the one that,
Yeah, the court has that on a thumb drive. I don't have it as a PDF because they're movies,
yeah,
so I don't.
yeah, typically we play those in the courtroom.
Yeah.
So that's all that, I'd probably add
I
that,
assumed, yeah.
okay? That there are 2 exhibits, the PowerPoint from, what was her name?
Carrie Fiore,
Fiore, right.
and then the interview would also, I assume, come back out.
Yep. But they will be getting the transcript of the interview.
Yes.
Yeah, I mean, there's a number of audio recordings that were admitted. Cody, the second one in the cell, all of that, they'd have to come into the courtroom,
Sounds like it.
okay? So we'll kind of tweak that a little bit more and get it back to you. Anything about the rest of page 7?
Do you want to tell them about the
So
stip?
Judge, we do have the corrected stipulation, and I don't know if the court wants us to just swap them out. but we can do that.
Unless you have an objection to it, we'll just note the number, the exhibit number, and add that it's corrected in light of the fact that the exhibit was introduced in evidence.
There's actually, I don't know, we sent 2 to defense this morning. There was another one that while the court was reading it, we noticed an error, so.
Well, there were a couple of times when you had the fact, in
Oh,
the,
I don't know that we fixed that.
I tried not to read both the facts, but
So I don't think it needs to be included in this. I think we can just swap them out.
But that would, unless
fine.
that seems to be a ministerial
Housekeeping.
and not a substantive issue, so we'll do that.
Nothing else on that page then, Judge.
All right, and just make sure we do this. You know what I should, after this, Ms. Jentz, make sure I ask you if you have any further motions in the case. Okay? And I do, for the record, I understand that the evidence is now closed. Is that right?
That's correct, Judge. Yes.
Okay. So if you have any additional motions, we'll take them up after we do the charge, okay? 8.
I know. That's not what he's talking. I know. He's talking about
And on this, Ms. Jantz, it's the model instruction on burden of proof, but I wondered if you wanted,
Oh, I'm still on personal knowledge of juror.
oh, okay, okay. All right.
I guess, did we have this? Personal knowledge. I don't know whether he had it. The sentence, the last sentence in the first paragraph, you may use knowledge and experience which you possess as intelligent persons.
As
Uh,
intelligent persons.
So I would just say you possess in weighing the evidence. I don't like this.
We don't want to presume anything.
Correct.
I think she'd like to get rid of
Intelligent.
as
persons.
intelligent persons. Any objection to that, Ms. George?
Seems harsh, but no, I don't have any objection. No,
It
that's fine.
seems,
That's fine. That's fine. I don't think it's, again, it's not a substantive change. We'd certainly not like them to use knowledge they possess, though, as unintelligent persons.
you can't,
We'd rather, I think it highlights the fact that you should really be thoughtful in that knowledge as opposed to rash or speculative.
that's completely different. And their intelligence level is what it is. To presume they're all.
If you want that out, we'll just take it out.
I mean, if you want to say something about giving care, and I think you do later on, or already have, careful and thoughtful consideration. I don't think we need to repeat that.
Really, I think the whole point of this paragraph is to get to the next paragraph, which is don't consider things that are outside of, don't use special knowledge to address things that no one else would have
Right.
access to. So we'll just remove as intelligent persons, given the request by the defense and the lack of objection from the state. And move on to page 8, or the rest of page 8, I should say.
No objection.
In this regard, Ms. Jantz, I was going to ask you, it is part of the model instruction on burden of proof to have or to testify in his own behalf. He is not required to call any witnesses or to testify in his own behalf. Do you want that to remain in that phrase?
Yes.
Okay, and it will.
Y'all, let me pause this real quick just to let y'all know, so that it's totally clear. What they're doing is they are arguing what they want to tell the jury. The jury's going to use what they tell them is the law to apply the facts, to apply what they heard during a trial to the law. So you can't just tell the jury, hey, do you think he did it? Like, they need to know what the law says, and they need to know how to apply it. That's why these two sides are going at each other. They're trying to get the law, the instructions most favorable to their own side, so that when the jury applies what they heard during the trial, it'll be more likely to go in their way. So the jury, to you, Miss Lely, they can't just go hash it out, because there has to be an actual law or set of laws or tests or what have you for them to apply the facts to. They can't just make it up. So that's what they're talking about here.
I'm sorry?
Again, sorry. No, it's not how to apply the law. It is what is the law. So they are trying to come up with what is the law for this case. Do y'all understand? What? Yeah. Now, so that might imply also how to apply the law, but they're trying to come to a conclusion as to what to tell the jury the law is in this case. And I know it sounds weird. It seems like something you would do before, but as you can see with this NYSL trial, they're doing it after. They're saying, what should we tell the jury basically is the law, so that they can take all of this stuff that they just heard and apply all the stuff they just heard to what? Well, this is the law that we're going to tell them. So it kind of seems weird a little bit, but to do it after, but this is how we do it.
Thank you. Are we still reviewing page 8?
Yep. So, Stacy, where in our instructions, page 2, reasoning? So, it looks like we didn't include it in our submission, but I have had it included in other cases that jurors doubt they need not articulate it, and they need not, it need not be the same as another juror's. I can draft up some language that I think I have some earlier cases, but I would like them to know that they don't all have to have the
So
same.
what I suggest, rather than arguing about it, neither of us know what language you're
Yeah, yeah.
proposing.
I'll
So
give you
if
something.
you have language that you
I
think
will
has
give
been
you
used in other cases that you think is supported, you should write it up
I
and
will.
get it to us. Okay, so why don't we skip over, unless there's anything else about the reasonable doubt charge that you object to. It sounds like you may wish the court to consider adding something.
I do want it added, but I'll draft it and send it to everyone.
All right. I do know this is consistent with what you submitted, right?
Yeah.
All right. We should move on to 9. And I have in mind in page 9, you're wanting something about, which we're not fully dealing with yet, something regarding absence of great provocation and sudden passion. Or heat of passion, not sudden passion. Well, it is really the same, I think, for pre-deliberation. Are you still on 9, Or
Oh,
you,
no, I'm sorry, I was on to 10.
so
I'm good on
9,
9, except for burden of
whether
proof.
it's, okay. So 10, you'll see I put in brackets, something about an inefficient intervening cause would be an unexpected. Is that something really at issue in this case, and do we include that sentence?
I don't think we need it.
Ms. George?
Well, in brackets, a killing may be, which one are you talking
The
about?
first one.
First essential element, right?
Where it talks about death in a
Efficient intervening.
natural and continuous sequence
I don't think we
unbroken
need
by,
it.
what?
I don't think we need it. It's
Ms.
not a
Ms.
fact in this
George?
case.
I mean, it's part of the model instruction, I'll include it unless both sides.
We don't need that, Judge.
Okay, and we'll. You'll see I added a bracketed statement with regard to the term unlawful, which is not in the model instruction, but it seemed to connect the killing with the self-defense charge.
And is supported by the case law.
Fine, Judge.
Okay, and then we'll leave that in under 4. Anything else on page 10?
No.
No, Judge.
I'm sorry, did you answer, Ms. Jantz? I didn't hear.
I said no.
Okay, thank you. We're putting that in the bracket. We'll come out and we'll move to page 11.
Just a typo. Page 11, in the last sentence in the 5th essential element, the state must have proven that he actually thought about killing Ms. Ferlazzo before he's missing.
Thank you. And I would just ignore what I've put in so far. I don't think it would be, either party would like it very much. I think I do want to wait a little longer to see if we get something on you, but I think I would work on that. But it would be the court's intention, to the extent it adds something on great provocation, that it do so there and not as an element of the crime, because I just have not seen it. But I would probably include that it has to be absent beyond a reasonable doubt.
Thank you. That's.
I mean, I'll just connect the concepts.
Yeah.
That would be,
So what I'm asking for is what's in Hatcher, where passion or provocation is implicated, the court must instruct the jury that to establish murder, the state must prove beyond a reasonable doubt the accused did not kill under the influence of passion or provocation. That's a quote from Hatcher, paragraph 7 and 8. That's my request.
yeah, I think passion or provocation is too, the term is much, I don't think that's actually right. And I think they suggested that Judge Katz didn't quite get it right in how he did it. You know, it wasn't as artful as it could have been. I think the terms have to be much more consistent with what the instruction is regarding voluntary manslaughter, that the provocation has to be great and reasonable under there's language that I think you have to put in. Otherwise,
So,
any passion, someone enraged, for example, might have great passion and might feel provoked. But that doesn't mean it's justified as to reduce from first degree. And they might, in that rage, say, I'm going to kill somebody and this is how I'm going to do it. So I think we have to be careful to make sure that we narrow it sufficiently that folks understand that it has to be consistent with the terms in voluntary.
I understand. I'm looking at Belaski. It doesn't say great provocation. It says adequate provocation.
I'm going to look more at the model instruction, try and keep things consistent, because if we don't do that, we get mixed definitions and that's confusing, I think, to the jury.
Well,
But I mean, why don't you wait until you actually
Okay.
see the
Yeah,
language?
yeah,
Yeah, there'll be plenty of time to
thought-
object or to speak further on what I've done. I'm acknowledging I haven't gotten it right here. And the state will have the same opportunity to weigh in. I'm sure the state wants to look at Yo first if you've got it. And
She hasn't located it yet.
yeah. Okay. I think so. It seemed to me that self-defense was better put after first than it
Yes.
is at the end. You put it at the end, but it seems that's where you're considering it. If the court's considering second or manslaughter, it means it's really rejected self-defense, right?
I agree, Judge.
Any objection to it being there, Ms. George? Then you can read what we put to see. You'll see it's not what you requested, Ms. Jantz. The subjective objective thing,
Well,
I just, well, why don't you read it? And then you can make your record or try to convince me of something more.
where's the court directing me to look?
I'm sorry?
Where am I looking for the standard for self-defense?
It's all through page 12 and 13.
Okay, 12 and 13.
Yeah, yeah.
Oh, okay. Sorry.
And actually ends on 14.
Stacy, where's our self-defense?
Okay, 14.
Page 12 and 213.
So I do object to this, Judge. I do think the case law supports subjective and objective standard. I'm looking at Wheelock. And there it is. And the quote, let me see if it's in here. A jury must assess the reasonableness of a defendant's apprehension, taking into account not only the circumstances with which he's confronted, but his individual attributes as well.
Right, so
and
my,
if you have that.
the statement we have is when assessing the reasonableness of Mr. Filazzo's fear, you may consider the individual characteristics of Mr. Filazzo and Ms. Filazzo, such as their respective size, gender, age, physical condition, strength, stamina, courage, assertiveness. I guess we could,
So you're
and,
talking,
and other personal characteristics, I guess we could add.
well, yes, because size, gender, age, physical condition, strength, stamina are all physical, not emotional or any
Well,
other kind of.
courage and assertiveness are
Courage
more
and
emotional.
assertiveness,
We have that.
we had that. It's fine if we had it.
You had that exact language, right? I mean, the reason you have it is because it's modeled jury instruction.
Yeah,
I
I agree, but.
I'm trying not to get overly
I don't-
creative.
I think citing all of these physics, size, age, gender, physical strength, the issue is his perception of the circumstances.
And the reasonableness of it, not his perception, it's the reasonableness of his
reasonable person,
perception and
given
the
his-
accuracy of his perception.
Given his, who he is.
All right, y'all. Miss Lily thinks that watching day two would be better. This is a 6-hour day. Miss Lily, do you have a particular part of the day? We watched much of this yesterday. I guess it's the detective who interviewed him.
Therapy has always been such a
Oh, great. Y'all give me a second. Let me get back to mine.
Case law
Let me
clearly
get to my other
supports
channel.
that based on his psychological.
Well, if you have another term you want to include in the such as clause, why don't you think about that?
All right,
But I didn't see, frankly, obviously I'll state the obvious. There was no expert testimony here regarding Mr.
Okay. This looks to be the go to where they find him in the store. Okay. Is that a video? All right, that's an hour from now. Let's start right here then. Just turn the volume up, by the way. Jury's coming in. So they'll be finding him in the store here.
Please be seated.
I guess this is it in about 15 minutes. So we'll start here.
Jury is all present and accounted for. We'll proceed after our morning break. Ms. George.
I see him at the store here in about 15 minutes. So we'll just lead up to
Detective
that.
Sergeant Voris, what is the approximate total time that you spoke to Mr. Ferlazzo on the 19th?
I believe it was about 3 hours.
And at the end of the audio that we just heard, it appeared that you asked Mr. Ferlazzo if he was willing to sign a sworn statement form.
Yes, ma'am.
And I'm showing you which been marked as states 129. Is that the form you were going over with him?
Yes, ma'am.
Move to admit states 129.
Any objection?
no objection, thank you.
Exhibit 129, states 129 is admitted without objection.
Is this the form that I just showed you?
Yes.
Screen. And so in the audio, in the down the right corner there, is that where Mr. Ferlazzo signed?
Yes.
I think this
When
is
you
the
asked him if he had-
detective.
Was willing to sign this? Did he make any indications that what he told you wasn't truthful?
No, he did not.
Before moving on, the individual that you spoke with and that's on the video with you, is he in the courtroom today?
Yes, he is.
Identified as Joseph Ferlazzo?
Yes, he's at the table, blue shirt, black tie.
Thank you. Judge, the state would ask that The record reflect Mr. Ferlazzo has been identified.
Reflected.
Have you interviewed individuals related to homicide cases prior to this one?
Yes.
Do you approximately, you know how many approximately you were the case officer on?
At that time, I believe it was around 10, maybe, approximately.
And have you done others since?
Yes, since then, I've been assisted or been the lead on about 50 homicide cases throughout Vermont. I would say the lead on 15 of them.
And in your experience, is it common for people to appear tired or stressed during those interviews?
Yes,
Have people declined to speak with you during those interviews?
yes, they have.
Have people told you that they don't feel comfortable speaking with you
Yes,
or that they aren't in the right state of mind to provide an accurate statement?
maybe not in those exact words, but people have declined to speak with me for a variety of reasons.
Did Mr. Ferlazzo ever make any such statements during the time you spoke to him?
Never.
He did make a few statements about his mind not being right. Did that concern you in a way that made you question his ability to give a statement?
It didn't concern me from my standpoint because Mr. Ferlazzo was articulate. He was responsive to my questions. He said he wanted to talk like very early on. There was no concern about his ability to interact and converse with me.
And after you concluded the interview with him or with anybody, what's the sort of next steps you take in an investigation?
So I call it like check and verify. So when someone tells us something, we try to prove it right or prove it accurate and see if there's other evidence that supports what we're being told.
Actually, before we move on to that, I'm going to show you what's been marked as States 13. You recognize this?
Yes, I do.
Can you tell the jury what that is?
This is a sketch that Mr. Ferlazzo drew during our interview.
Is that a fair and accurate depiction of what he drew?
Yes, ma'am.
State would move for State 13.
Any objection?
Any objection?
Oh, I'm sorry. No objection.
States 13 is admitted without objection.
And is this that sketch?
Yes.
Okay, so it's a little bit small, but can you kind of describe to the jury what it is?
So it's the sketch during the interview when Seth and I, or Detective Sergeant Richardson and I, were talking about the layout of the camper van with Mr. Ferlazzo. He drew the sketch. It's kind of maybe appears upside down on the screen, but the bed is at the top. And then he depicted a couch, a closet, the bathroom, and he depicted the location where Emily currently was at the time of the interview.
Okay, thank you. Okay, so the check and verify, is that what you called it?
Yes.
Okay, so in this case, did you, after you interviewed Mr. Ferlazzo, did you work to confirm or deny things that he'd made in his
Yes.
statements that he'd made? And were you able, during the course of your investigation, were you able to verify any of the statements that he made?
Yes, we were.
And specifically starting with the location of the incident, were you able to confirm?
Yes. We spoke with his sister, Nikki, and she provided information that was consistent with what Joe provided us. Emily's geolocation data was consistent with being at Bolton Friday evening.
And he told you that the homicide had occurred while Emily was in bed. Were you able to verify that?
Yes.
Okay, and how were you able to verify that?
The physical evidence is consistent with that. The the pillow from the bed sheets, the bed itself.
And what about where he shot her on her body?
Yes, that was confirmed during autopsy.
Okay. And he made statements about firearms located in the van.
Yes,
Were you able to verify that?
yes, there were firearms located in the van.
How many firearms were located in the van?
I believe it was 2 handguns and 3 long guns.
Can you describe what a long gun is?
Like a rifle. I think there was like a short-barreled rifle, a shotgun, and another rifle, and then 2 handguns.
Did he tell you during your interview that Emily owned any of those guns?
No, he did not.
Did he tell you that Emily had a gun?
No, he did not.
Did he tell you that Emily slept with a gun under her pillow?
No, he did not.
Did he tell you that Emily possessed or used a gun at any point?
No, he did not.
May we approach?
Yes.
And Judge, actually, I'm going to start with a stipulation. Did you confirm where Mr. Ferlazzo was the following morning?
Yes.
Where did you confirm that he was?
We obtained video of him out to breakfast at Maxie's in Waterbury, Vermont.
Judge, if the court could read stipulation states number 117.
All right, there's no objection to the admission of one.
No objection, Judge.
Okay, stipulation number 2, members of the jury, the state and defendant Joseph Ferlazzo have agreed that you may find certain facts. This is called a stipulation. A member of the Vermont State Police collected surveillance video and a purchase receipt from Maxie's restaurant in Waterbury, Vermont from the morning of October 16, 2021. That surveillance video and a copy of the receipt was added to the case file and reviewed by Detective James Horace. The authenticity of the surveillance video and purchase receipt is not being challenged. Chain of custody of the surveillance video and purchase receipt is also not being challenged. As with any evidence in this case, in this trial, you must decide what weight you will give this stipulation. And that's admitted as states 117.
I'm going to show you what has been marked as states 14 and 15. recognize these?
Yes, I do.
Can you tell the jury what they are?
15 is the receipt from Maxis from October 16th, and 14 is a screenshot from the video from Maxis.
State would move to admit.
Any objections?
No objection.
14 and 15 are admitted without objection.
Detective Sergeant Voris, is this the screenshot from the surveillance?
Yes,
Can you just tell the jury sort of what they're looking at?
this is inside Maxis restaurant in Waterbury, and Mr. Ferlazzo is in the kind of in the middle, maybe upper left side of the screen near the door.
And is this the receipt from the breakfast that morning?
Yes.
Were you able to confirm where Mr. Ferlazzo went Saturday night with his sister?
Yes.
Where was that?
The Twigs Restaurant in St. Albans, Vermont.
Judge, the state would ask the court to read stipulation number 3, states 118.
Any objections?
No, Judge.
States 118 is admitted. I'll read stipulation number 3. Members of the jury, the state and defendant Joseph Palazzo have agreed that you may find certain facts. Spell the stipulation. A member of the Vermont State Police collected surveillance video from Twigs Restaurant in St. Albans, Vermont from the evening of October 16, 2021. That surveillance video was added to the case file and reviewed by Detective James Forrest. The authenticity of the surveillance video is not being challenged. Chain of custody of the surveillance video is also not being challenged. As with any evidence in this trial, you must decide what weight you will give this stipulation. State 118 is in.
Did you provide still shots from, surveillance videos from inside of Twigs?
Yes.
And did we have 2 different angles of that?
Yes.
Have you reviewed them prior to your testimony today?
Yes, I have.
Okay. The state would move to admit states 16 and 17.
No objection.
States 16 and 17 are admitted without objection.
Does that clip just show Mr. Ferlazzo in Twigs?
Yes.
Is this also inside of Twigs?
Yes, it is.
Were you able to, did you ever locate Emily's stuff that Mr. Ferlazzo indicated he'd thrown away?
We did not.
And that was her phone and her wallet,
And her glasses, yes.
glasses. And did VSP, members of VSP attempt to find these items?
Yes, we did. We were unsuccessful.
And you were looking, how long after he allegedly threw these things out were you looking for them?
So we had several detectives and troopers that were assisting in the investigation starting, on the 19th, which were several days after this all occurred.
Right, okay. Were you able to confirm whether or not he gave his sister a tattoo?
Yes, we did confirm that happened.
And at some point during the interview, were investigators able to locate Emily's body?
Yes,
And was she located where Mr. Filazzo said she would be?
yes, she was in the bathroom area of the camper van.
Was her body in the condition that Mr. Filazzo said it would be?
Yes, it was.
Did you locate the saw that Mr. Filazzo said he used?
Members of the crime scene search team located it in the camper van in the area where he said it was behind the driver's seat.
Was there anything you learned after the investigation that Mr. Filazzo did not tell you during the interview?
Yes.
What was that?
I learned after Emily's autopsy that she also sustained stab wounds.
During your investigation, were you able to determine how tall Mr. Filazzo is
Yes,
and how much he weighed?
yes.
And what was that?
I determined that through his DMV records.
And what is his height and what did he weigh?
It was 6 feet tall and approximately 200 pounds.
Did that seem consistent with your interactions with him?
Yes.
As part of the investigation, did you seek a warrant for call detail records for the phone number and physical phone belonging to Mr. Filazzo?
Yes, we had, there were separate search warrants for his phone number, a search warrant for Emily's phone number, and a search warrant for Joseph's physical cell phone.
And did you receive those records in return?
Yes, we received records for both phone numbers and for, the cell phone went to TI, our technology unit.
Okay. Did you review the records?
So the call detail records or the records associated with the cell phone carrier. So Joseph's phone number was 802. I think it was AT&T, and Emily's phone number started with 603 area code. Those carrier records I looked at briefly, but ultimately are analyzed by our technology unit. And then I did look at the data that came off of his phone myself.
Okay. Judge, stipulation number 4 states 119.
What is it,
Any
Sarah?
objection?
What is it?
Any objection to 119?
No, thank you. No, Judge, no objection.
Stipulation number 4, members of the jury, the state and defendant Joseph Filazzo have agreed that you may find certain facts. This is called a stipulation. Vermont State Police searched a red Jeep Wrangler belonging to Joseph Filazzo pursuant to a search warrant on October 19th, 2021. During that search, an iPhone belonging to Joseph Filazzo was collected by Detective Sergeant Aaron McNeil. The iPhone was tagged as item, quote, Jeep number 2, end of quote, / quote, item 14, end of quote, and delivered to the Vermont State Police Technology Investigation Unit, in parentheses, TIU, end of parentheses. The iPhone was in the same condition upon arrival at the TIU as it was when collected from the Jeep during the search on October 19th, 2021. An extraction was done of Joseph Filazzo's iPhone, in parentheses, AKA, quote, item 14, end of quote, in the paragraph by Detective Eric Jollymore and added to the case file. That extraction was done in accordance with his training, and the authenticity of that extraction is not being challenged. Chain of custody of the iPhone belonging to Mr. Filazzo is not being challenged. As with any evidence in this trial, you must decide what weight you will give this stipulation. Page 1.
after the technology unit extracts that data and sends that portable case to you, how does that portable case look from your end?
So I received the case from the technology unit. We call it a portable case. It's on, in this circumstance, it was on a hard drive, like a portable hard drive. And I plug it into the computer. I can open the program on my desktop, and then I can review the data that was on the device.
Okay. And is that program pretty user-friendly?
Extremely user-friendly, yes.
Is there any training provided in order to use it?
There's no training required to like read a portable case. I have taken training to create portable cases and to extract cell phones myself. I didn't do that in this case, but the portable case it's very user-friendly.
Okay. So were you able to review any text messages from Mr. Ferlazzo's phone to Emily's phone between the time she was killed and the time she was located?
Yes.
Were there any messages sent from Emily's phone to Joseph's phone during that time period?
No, all of the messages were sent from Joseph's phone to Emily.
I'm going to show you what's marked as Exhibit B. 4 pages. Do you recognize this?
Yes, I do.
And can you tell the jury what this is?
These are the messages that were observed, from Joseph's phone within that portable case that were sent to Emily's phone number.
It's to admit.
Any objection to
No objection.
18 is admitted.
She's talking.
Detective Sergeant Forrest, can you just read the messages to the jury and the date and time they were sent?
Yes. October 16th, 2021 at 1:09 and 58 seconds PM, message sent, babe. On October 16th, 2021 at 1:20:49 PM, message sent, what are you doing? Talk to me, please. On October 16th, 2021 at 1:52:47 PM, the message was sent that read, where are you, lovey? I wanted to ride with you today. On October 16th, 2021 at 2:02:18 PM, the message was sent that read, I'm at the Langs, call me. On October 16th, 2021 at 2:02:47 PM, message sent, the tranny on the bus is smoking with a emoji. On October 16th, 2021 at 2:57:18 PM, message was sent, whatever, I'm going to spend time with Nikki while I can, call me. On October 16th, 2021 at 8:09:48 PM, WTF, babe. On October 17th, 2021 at 8:45:24 AM, message read, good morning, Bubby. I miss you. Please call me. Nikki just messaged me. You want to meet up in Burlington for some snacks and whatnot. On October 17th, 2021 at 2:03:02 PM, the message read, hello, question mark, question mark. On October 17th, 2021 at 8 PM, the message was sent that read, please M, pick up. On October 17th, 2021 at 8:12:12 PM, message 2 emojis were sent. On October 18th, 2021 at 12:05:48 AM, the message read, this is far enough. Get your ass home. I gotta go back to NH. Are you coming back? On October 18th, 2021 at 12:05:48 AM, I believe that's the same message I just read. on October 18th, 2021 at 1:05:36 a.m. Random question, where is the extension cord? I want to plug the fan in. October 18th, 2021 at 9:06:19 a.m. Good morning, baby, with an emoji. On October 18th, 2021 at 10:25:51 a.m. You're an asshole. I don't deserve this shit.
Is that all of the messages that were sent?
I believe so, yes.
Ms. Janice, any cross?
Yes, thank you, Judge. Morning, Detective Sergeant Voris.
Good morning.
On October 19th, the day Mr. Ferlazzo was interrogated by you and Detective Richardson, Spencer Lemons had already contacted the police through the 911 call and relayed to the police information that he had saying that Mr. Ferlazzo admitted to killing Emily. Isn't that right?
Yes,
And on October 19th, police were actively looking for Mr. Ferlazzo, correct?
yes,
And Amy Nolan, who was at that time a member of the Vermont State Police, by happenstance encountered him in St. Albans and in Maple Fields. Is that also correct?
yes,
And she drove him in her truck back to the St. Albans Barracks of Vermont State Police, correct?
yes,
From the time that he arrived at the Vermont State Police Barracks in St. Albans, he was never outside the presence of someone from law enforcement, correct?
I believe there were times where he was alone, like in the interview room, by himself. At points during the interaction.
Was he under observation through a two-way mirror at times when he was alone in the interview room?
That room doesn't have a two-way mirror. No,
Does not.
no, it does not.
Okay. Okay. At any point, was he free to leave?
He was probably not free to leave.
So we can agree that he was in custody during the time he was at the Vermont State Police Barracks, right?
Yes.
Okay, thank you. So how long did you say you have been with the Vermont State Police?
Since January of 2014.
And prior to that, your law enforcement experience was what?
I have no prior law enforcement.
All right, y'all. We're gonna fast forward. We're trying to find the sweet spot that Miss Lely keeps talking about. So, is this the guy, Miss Lely? This guy here? Is this the guy that you think is really good? Go to the lady detective.
Raise your right hand, please. Solemnly affirm that the evidence you shall give relative to the cause now under consideration.
Y'all need to give me some
shall be the
feedback
whole
now.
truth and nothing but the truth as contains and penalties.
This guy?
Yes.
All right, well, not seeing any chat, so.
Good afternoon.
afternoon.
Good morning. Can you state your name and spell your last name, please?
Seth Richardson, Richardson.
Okay. And how are you employed?
Currently employed by the Vermont State Police.
2021.
And how did you become involved?
Detective Lieutenant John
This
Paul
guy we're
Schmidt asked
talking
me to
about,
respond to the St. Albans
3 hour
barracks,
mark doesn't, the
and
3 hour
said
mark.
there was a
is
missing
just
person
a,
complaint
fire.
that was suspicious in nature.
3 hour mark.
And upon
Right.
arrival at the barracks,
This
were you
is a
given a
3 hour
specific
mark.
task?
We have a
I was given a
fire
couple tasks.
thing or whatever.
One was to sit in on the interview with Joseph.
This is a 3 hour
Ferlazzo.
mark.
Okay.
Okay. So here's a 3 hour mark. And that lasts all the way up until 3 hours and 40 minutes practically. So can't be the 3 hour mark. lady detective. This lady, maybe you're talking about this lady here.
So if you can keep your voice up so the jurors in the back can
This
hear
must
you,
be us.
that would be appreciated. Can you just start by telling us your name and spelling your last name? Actually, in your case, can you spell your first name as well?
Certainly. It's Amy, spelled Aimee. Last name Nolan, Nolan.
Okay. And did you formally work for Vermont State Police?
I did.
Okay. And are you now retired?
I am.
When did you retire?
October of 2023.
So-
Can parties approach for 1 minute?
And the team specializes in processing the crime scene, collecting evidence.
Okay. Approximately how many crime scenes and death investigations have you participated in?
Well over 150.
And in mid-October, October 15th or 16th of 2021, were you made aware of an investigation related to Emily Ferlazzo?
I was not notified until the morning of October 19th.
Okay. So prior to that, you were not involved in the case?
No.
Okay. And what information were you provided on October 19th?
I received a call from Major Crimes Unit Supervisor. One of the lieutenants advised that there was a new case requesting my presence at the St. Albans Barracks for a briefing later that morning.
And did you in fact attend that briefing?
I did.
And what further information did you learn?
Excuse me. At that point, I learned that the state police was notified the prior day of a missing person, Emily Ferlazzo, that there were some suspicious circumstances surrounding that, that Mr. Ferlazzo, Emily's husband, had told a friend that he had killed her, and that the state police had seized a camper van as well as a Jeep that belonged to Mr. Ferlazzo.
Okay. And so what was your sort of plan or task for the day?
Initially, there was a lot of waiting around, learning new information as it was found. The search warrant was being worked on to be able to search the van and the Jeep. So I took it upon myself to sort of scour the internet, social media pages for both Emily and Joseph Ferlazzo, trying to find acquaintances that we might be able to interview, seeing if anyone had posted any comments or anything we could learn about Emily's potential whereabouts.
And at some point, did you take a break to go get food?
I had had lunch, but to be honest, I'd had enough coffee that morning, so I decided to go to the store, knowing it was going to be a late night. I wanted an energy drink and some snacks for the team once they got there. So I believe it was around 2 p.m. I did leave the barracks and go to a local convenience store.
Okay. And what was that convenience store called?
Maple Fields?
Okay. And that was in St. Albans?
Yes.
Right. And who did you go there with?
One of the other team members that had arrived at the barracks, Brandon Gallant.
Okay. And who drove?
I did.
What did you drive? What vehicle did you drive?
I drove my state-issued cruiser, if you will.
Okay. And can you describe that vehicle?
Sure. It's an F-150 truck with an extra cab and an extended bed on it. So it's a rather large vehicle.
Okay. How many seats are in the vehicle?
Technically seating for 6. It was a bench seat in the front and a bench seat in the back. But my back seat was full of equipment. And then in the front seat, I usually kept the center console folded down for like a drink holder, things like that. So Most comfortably 2, impossibly 3.
Okay. And is there a secure area of this vehicle like many police cruisers?
No,
So the entire inside of it is accessible?
open, correct.
Does it have any sort of Vermont State Police insignia on it?
No, completely unmarked.
What were you wearing that day?
I was wearing my crime scene uniform, which is a pair of cargo style, I'd say tan pants, a green polo shirt with the state police emblem, and it said CSST on it. But that was covered with a plain black fleece. So I didn't have any obvious markings
Okay.
of the state police on my person that day.
You weren't wearing a state trooper uniform that we've all
No,
seen?
I was not.
Okay. How far away is the Maple Fields from the St. Albans Barracks?
It's approximately a mile down the road.
So can you tell the jury what happened when you pulled into the Maple Fields?
Sure. Due to the size of the truck, it wasn't practical to park in sort of a normal parking spot, if you will. The back end of the vehicle would stick out several feet. So I often chose to park, not in a parking spot, along a parking lot edge or something like that. So as I pulled in to the entrance to the store, I had my eye on a spot where I wanted to park sort of parallel to the road. Well away from parking spots. I noticed a male was just sort of nonchalantly walking right where I wanted to park. So I was, I can't remember if I muttered it or if I just thought under my breath, like, oh my gosh, hurry up. That's where I want to park. So I sort of slowly, crawled behind the person until they diagonally cut across and went into the store.
And so once you entered the store, where did you immediately go?
Right to the back of the store where the coolers are located. That's where the energy drinks were.
Okay. And as you're walking towards the back of the store, did you notice anything?
I noticed that same male, I had sort of given him a nickname in my head of Hoodie because he was wearing his hood up. It was chilly that morning. And I noticed that same male that I had waited to move out of my way so I could park was also at the coolers. He had walked right to the back of the store as well.
Okay. And what was he doing?
He was getting a drink out of the cooler and sort of stepping back from the cooler at that time.
Did you recognize the male?
When he closed the door to the cooler and he turned around and we made eye contact, I was like, wait, I know this person. In that moment, I couldn't figure out where or why. My brain was still trying to catch up with me. But I knew I recognized him.
Okay. And did you ultimately determine how you recognized him?
Yeah, so he walked to the right and then turned to walk up to one of the aisles towards the front of the store. And he turned and looked at me again. And we locked eyes again. And at that point, I recognized that it was Joseph Ferlazzo.
Okay. And how did you recognize him? What have you seen?
So I had spent, like I said, a lot of that morning sort of scouring through social media. I had seen dozens of pictures of Mr. Ferlazzo as well as Emily. And then also our public information officer for the state police was at the barracks that morning. He was preparing a press release that he was getting ready to put out with photos, which included Mr. Ferlazzo. And he had asked me to proofread that for him just before I went to the store. So it was like another look at Mr. Ferlazzo's face right before I left.
Okay. And where did that mail go?
Up to the front of the store to the cash register area.
Okay. And so what was the next thing you did with that information?
I told Brandon that's Joseph Ferlazzo. He's heading out of the store. I'm going to follow him.
Okay. And are you aware that this interaction with Mr. Ferlazzo was recorded?
Yes.
And how was it recorded?
Through the Maple Field surveillance video system.
Okay. And have you reviewed those?
I have seen those videos, yes.
Judge, I have a stipulation. States 120, stipulation number 5.
So I was told my voice was not quite loud enough last time, perhaps for some of you, so I'm going to read a little louder this time. Stipulation number 5, Members of the jury, the state and defendant Joseph Palazzo have agreed that you may find certain facts. This is called a stipulation. A member of the Vermont State Police collected surveillance video from the Maple Fields gas station in St. Albans, Vermont from October 19, 2021. That surveillance video was added to the case file and reviewed by Detective Sergeant Amy Nolan. The authenticity of the surveillance video is not being challenged. Chain of custody of the surveillance video is also not being challenged. As with any evidence in this trial, you must decide what weight you will give this stipulation. And that's Exhibit States 120, and no objection to that being admitted.
No objection.
Admitted without objection.
Well. Do a quick technical check. Judge, the state would next move to admit States 23, which is the first Maple Fields video.
No objection.
States 23 is admitted without objection. No objection. Go back to States 23 is admitted without objection.
Thank you, Judge. Sorry about that. At some point in the video, you appear to look at your phone. Can you just tell the jury what you're doing?
Yes, I feel like my body language is pretty clear at the moment that I recognize him. And I turn back around, I take my phone out, I say something to the trooper I was with, and I take my phone out because I'm looking for that press release to show the picture to Brandon and to sort of confirm my suspicions that it was Joseph Ferlazzo.
Okay. And is there another angle of this same sort of interaction within Maple Fields?
There is.
Judge, the state would move to admit States 24, second Maple Fields video.
No objection.
Case 24 is admitted without objection.
So after seeing who you believe to be Mr. Ferlazzo in the Maple Fields, did you in fact follow him outside?
I did.
Okay. And did you approach him outside?
I followed behind him. He was walking along the front of the store.
Okay. And what did you do? What was your interaction?
I said, Joseph, and the male kept walking, no acknowledgement. So then I said something to the effect of, hey, state police, can you stop for a second? I just need to talk to you.
And did the male stop?
He did.
Okay. And what did you do? Once the individual stopped, did they stop and actually turn around to face you and interact with you?
He did turn around and then took a very long, almost exaggerated drink of his energy drink, just looking at me, sort of the proverbial deer in the headlight look. It seemed to me, based on my training and experience, it was almost as if he were trying to figure out, fight, flight, freeze, what do I do?
Okay. And what did you say to him?
I said, Joseph, it's you, right? Are you okay?
Okay. And what did he do in reply?
He took his drink down and his body language sort of deflated. And he said, no, I'm not okay.
And what do you mean? Can you describe what you mean by his body language deflated?
Sure. As he was looking at me taking that drink, he seemed, quite tense. Again, sort of deer in the headlights. Do I run? Do I freeze? Do I fight? And he just sort of relaxed, if you will. Like I visibly saw his shoulders drop and his head kind of dropped a little bit. And he just said, no, I'm not okay.
Okay. How far away from you was he when you first said state police?
Probably 10 feet, approximately.
All right. And what did you, after he said, no, I'm not okay, how did you respond to that?
I said, well, there's a lot of people looking for you and looking for Emily, and we're just trying to figure out where Emily is and what's going on. Her family's very worried about her.
And what was his response?
Let's go.
He said, let's go. Okay. And so what did you do?
I said, go where? And he said, wherever you're taking me. And I said, I'm not taking you anywhere. You're not under arrest. But if you want to come with me, I'll give you a ride to the barracks and we can get a detective just to talk to you.
Okay. And did he agree to that?
He did.
And did you bring him in your vehicle?
We started to walk back across the parking lot towards my truck, yes. And stopped about halfway across the parking lot.
Okay. And why did you stop halfway across?
There was a moment where I thought Mr. Ferlazzo might pass out. He seemed a little unsteady on his feet. I said, you're okay. I asked his permission. I said, if it's okay, I want to just put my hand on your shoulder. And I did. And I said, I got you. I said, you're okay. I'll get you to the barracks and you can talk to somebody.
Okay. Did he make any statements or respond to that in any
No.
particular way? Okay. And so did you bring him back to the barracks?
I did. The other thing that we did sort of in that halfway point was I asked him and explained before I could give him a ride. It was our sort of protocol that we had to pat somebody down for weapons before I could allow him in my cruiser with me. And also because I don't have a typical cruiser with what they call the cage in the back to separate the officer from a person that they've picked up for some reason. So he said that was fine. He indicated he had no weapons. So I patted him down real quick. And then I got into the driver's seat and Brandon walked him across to the passenger seat.
Did Brandon also get in the car?
He did not.
Okay. Was that because there wasn't any room?
Yeah, I told him I would come back and pick him up.
Okay.
I didn't think we needed to sit three across the front seat.
Okay. So it was just you and Mr. Ferlazzo in the ride back to the barracks.
Correct.
And did you speak to him during that time about Emily?
Not about Emily. I asked him, like I said, it was cold that day. I asked him, are you cold? He said he was. I turned the heat up. I said, have you been out all night? Based on the interactions that I knew had occurred the night before, he said he had. I asked him if he, was thirsty, if he was hungry. He said he was. And so again, I told him, I turned the heat up and I told him I would get him something to eat once we got back to the barracks.
How long were you in the truck with Mr. Ferlazzo?
Less than 5 minutes, probably.
Right. Did you see anything on the way to the barracks that sparked a conversation?
Yes, there was. So at one point in the video, as I start to walk towards the front of the store, I turned to Brandon and I told him to call dispatch to let them know what was happening. So that message had gotten relayed and there was a trooper coming to the store, lights and sirens.
Okay. And did Mr. Ferlazzo say anything related to that?
He didn't. I sort of chuckled and said, I think they're looking for us. I said, but we're good, right? And we continued on and I placed a call to my lieutenant at that time.
And could Mr. Ferlazzo hear that conversation with your lieutenant?
Yes.
Okay. Did you make any other calls during that time?
I also actually, let me back up. Before calling my lieutenant, I got on the radio to dispatch and I clarified, I am in the truck with Mr. Ferlazzo. All units can stand down. I'm headed to the barracks.
Do you have a recollection of what time you arrived at the barracks?
I would say it was probably, if this interaction was around 2, as I remember, I would say probably 2:15.
Okay.
Approximately.
And when you arrived at the barracks, where did you park?
I drove around to the backside of the barracks, into the gated parking area of the barracks.
Okay. And did Joseph get out of the car?
I can't remember. I think I walked around to his side of the truck and opened the door for him, if I recall correctly.
Okay. And did you ultimately get him into the police barracks?
Yes, the station commander of the barracks was outside waiting for us, and together we walked inside the building, yes.
Okay. Did he still have the drink that he'd bought at Maple Fields?
At that point, I believe he did, yes.
But did you had said earlier you told him you would get him some food and drinks. Did you do that?
Eventually, yes. After a short period of waiting for an interview and a detective to be ready for Mr. Ferlazzo, as this was obviously not planned, I returned back to the store and got a sandwich and some chips.
Okay. At any point in your interactions with Mr. Ferlazzo, did you ask him any questions about Emily?
I did not.
Okay. And is the person that you identified in Maple Fields as Mr. Ferlazzo and brought back to the barracks, is he in the courtroom today?
He is.
Can you just describe to the jury what he's wearing?
Certainly. He's sitting at the defendant's table wearing tan pants, a light gray shirt, and a black tie.
The state would request that the record reflect that's Mr. Ferlazzo.
They're directed.
Is it your understanding that he was then interviewed by Detective Sergeant Boris?
Yes.
Okay. And were you told at some point after what he indicated had happened to Emily?
In stages, yes.
Okay. And so did you become involved in this case in a sort of different capacity at some point?
Certainly, what I was there for initially, and that was in the role of crime scene search team.
Okay. What was the first thing you did related to that role?
Based on Mr. Ferlazzo's statement, where there had been an altercation, my first assignment, if you will, was to photograph Mr. Ferlazzo to see if we could detect any marks, bruises, scratches, anything like that.
Okay. And the jury has seen the interview room and this process happening.
Okay.
When you first went into the interview room to do this, did Mr. Ferlazzo indicate remembering you or give any indication that he remembered you?
Yes.
And did he remember you by name?
I don't recall if he remembered me by name.
Okay. And so did you in fact take photographs of his condition?
I did. I also collected what we call buccal swabs to get a DNA sample from Mr. Ferlazzo.
Okay. And Your Honor, the state would seek to admit states 25 through 36.
Okay.
Renew my earlier objections.
Objections as earlier noted, but they'll be admitted over objection. 25 through 36.
We're just going to go through the photographs. If you can just explain briefly what each one is.
Certainly. So this is what we would call an overview photograph of Mr. Ferlazzo. And because you can't really capture someone unless you're standing really far away, we take them in segments. So upper body, mid, and then lower body. Mr. Ferlazzo's hands, front and back. This is Mr. Ferlazzo's upper body. It was explained to him that we would like to take photographs without his clothes on, but not completely naked, again, looking for marks or bruises. Was also offered to him, if I recall, being a female, if he wasn't comfortable. I did have another trooper with me that could take those photographs. So this is the upper, I would say, torso of Mr. Ferlazzo. And face and upper chest, mid chest and abdomen, upper legs, the backside of his legs, and front of his lower legs. This is a side, sort of more close-up photograph of his left side of his head and face. Full body back, upper back, I should say.
And did you note any injuries or observe any injuries or marks on his body?
There was one mark, and I remember asking him if, that was an injury or perhaps a birthmark. It was really hard to tell. I believe it was on the left side of the back of his head, sort of right in his hairline. So it was hard to detect. Other than that, I did not see any marks on his body.
Or bruises?
No.
Okay. And you did already state that you collected the DNA swabs?
Yes.
Do you recall, were those swabs from the cheek titled item 1A
Yes,
or 1? And were they brought to the lab for testing?
they were.
Did you also supervise the collection of evidence from the van in question?
I did.
And have you reviewed all of the photographs taken of the van?
I have.
Judge, the state first has a stipulation, number 6, states 121.
Yep. No objection, Ms. Johnson.
I'm here now. No objection. Thank you.
Stipulation number 6, members of the jury, the state and defendant, Joseph Palazzo, have agreed that you may find certain facts. This is called a stipulation. Members of the crime scene search team, in parentheses, CSST, end of parentheses, collected, tagged, photographed, and processed pieces of evidence during the search of the camper van pursuant to a valid search warrant. CSST supervisors Amy Nolan and Aaron McNeil oversaw the collection, tagging, photographing, and processing of all evidence collected from the camper van. These items were ultimately stored at the Vermont State Police Barracks in Williston. These items were the same condition upon arrival at the barracks as they were when collected from the camper van during the searches on October 19th, 2021 and October 20th, 2021. Chain of custody is not being challenged as it relates to these items. As with any evidence in this trial, you must decide what weight you will give this stipulation. And that's State's Exhibit 2121, admitted without objection.
Thank you, Judge. And the state would first move to admit states 37, 38, and 39.
No objection.
Exhibits 37 through 39 are admitted without objection.
Detective Sergeant Nolan, can you tell the jury what this photo is?
Certainly, this is a view of the right side, or if you're looking at the van from the front, the left side of the van that Mr. Ferlazzo and Emily were traveling in.
So these double doors on the right side here is the entrance
Correct.
in this one?
This is the driver's side of the vehicle.
And this
The rear.
Okay. Judge, the state would next move for states 40 through 75.
Okay, do you want to first give us 37 through 39 of you?
Yes.
I'll take them first. Any objection to 40 through 78?
No objection. Thank you.
Or exhibits 40 through 78 are admitted without objection.
So we're gonna, the next group of photographs is from the inside of the van at the time of the search. What was the authority to search the van at the time?
We had a search warrant.
Okay. So I'm gonna show you first states 40. Can you tell the jury what this is showing?
Sure. This is a photo of the entrance and the steps up into the van. What you're seeing is, I believe, like a bug net or mosquito net over the door once the double door was opened. It's hard to see up there, but you're looking to where the driver's seat would be. And there was a curtain up over the driver's door for privacy over the driver's window.
Can you describe for the jury what this photo of?
This is the bathroom of the van with several black household garbage bags on the floor of the shower.
States 42?
Another view of the bathroom from a little further away. Another photo of the bags in the bathroom. Here, the bags are numbered with placards that we use to identify our evidence items. So you're seeing 1 through 7. Here you're seeing items 1 through 8 laid out on butcher paper. Bags were taken out one at a time and placed onto butcher paper as we remove them and numbered them.
Okay. And is this how you refer to the bags moving forward, is by these numbers?
Correct.
Okay. States 46?
This is a 12-gauge shotgun that was located at the foot of the bed in the camper.
States 47?
This is looking at the head of the bed.
And so are these pillows?
Yes, these are bed pillows, the sheets, a blanket, a comforter perhaps, and then there was also a black duffel bag on the bed. This is a Glock firearm that was found underneath the pillows of the, I would say, front side of the bed. Again, standing at the foot of the bed, looking at it would be the left side of the bed.
Okay.
A more close-up image showing the Glock firearm.
Okay. And it's the 11 next door, next to it mean that it was labeled item 11?
Correct, evidence item number 11.
And was there a magazine in this firearm?
There was.
And I guess first, can you describe to the jury what a magazine is?
Sure, a magazine is what holds the rounds of ammunition in a semi-automatic pistol like this. So the magazine sits up into the grip of the firearm, and that's again where the cartridges are held.
Do you know what the magazine capacity was?
It was a 15-round magazine, so it would hold 15 cartridges, excuse me.
Okay. And were you able to tell how many rounds were in the magazine?
There were 9 in the magazine.
And was there a round in the chamber?
There was.
Okay. And so was the round, the 15-round magazine that was in the bullets, was in the firearm, was that labeled as 11A?
Yes.
I'm going to show you what has been marked as 79 and 79, state 79 and 79A. Are you familiar with what each of these is?
Yes.
Can you just describe to the jury what each one is?
Yes. State 79, which is marked in our evidence system as number 48, is the Glock firearm shown in the pictures that was found under the pillows of the bed. And state 79A, which is marked item number 53 in our evidence system, is the magazine and the cartridges that were included in the magazine and the one in the chamber.
Are you able to open
I can,
79? Okay. Yeah, if you can just show it to them. And were both of these items, the firearm and the magazine, the bullets, were those brought to the Vermont Forensic Lab for testing?
They were.
Looking at the bullets that were in the magazine, are you able to tell whether there's a head stamp on them?
Yes.
And can you tell the jury what that means and what they say?
Certainly. So the head stamp on the ammunition tells us the manufacturer and the gauge. So these are SIG 9mm Luger. So Luger is a style of bullet or a type of ammunition, and the 9mm is the caliber of the ammunition, and the manufacturer is SIG.
How many firearms total were located in the camper?
There were 6 total,
Okay. How many pistols or handguns?
2 handguns,
Okay. And this being one of them.
correct.
What was the second one?
Second one was a 9mm Taurus pistol.
Show you what's been marked as states 50. Can you tell us what that is?
Yes, that is a 9mm Taurus pistol that was found in a kitchen drawer.
Okay. Oh, I'm sorry, Judge. The state would move to admit 79 and 79A.
Any objection?
No objection.
They're admitted without
Thank you.
objection.
Where should I put them, Your Honor?
Looking at states 50A, can you tell us what this is?
Yes, so these are the 2 kitchen drawers opened, and the drawer on the right, you can see in the lower, in the front lower corner of the photo, there is the Taurus pistol in the leather holster.
Okay.
Another view of that, sort of more close up.
So this is where that second handgun was located when you searched the van,
Correct.
and that holster was on it.
Yes.
Can you tell the jury what this is?
Sure. This is I would say, a storage cubby unit that had been built into the van above the head of the bed.
Okay. And did you search these baskets?
We did.
And can you tell the jury what is in this picture?
Certainly. In one of the baskets contained miscellaneous ammunition and also a silencer or suppressor.
And was the silencer suppressor labeled as item 22?
I would need to refer to my report or an evidence list to be sure, but to the best of my recollection, yes.
I'm going to show you what's been marked as 52A. And would move to admit 52A, Judge, based on no objections.
Oh, okay. Any objection?
Objection.
52A is admitted without objection.
Can you tell the jury what this is?
Okay, so it was marked 22. This is the silencer or suppressor seen in the photograph that was in that basket with the ammunition.
Okay. And did you know, was the silencer sent to the lab for testing?
It was.
And did you notice anything of interest related to the silencer?
The items as they were collected were brought onto the command post where we have better lighting and a controlled environment to take better photographs. During the time when this was being examined and photographed and documented on the truck, there were red fibers, or at least a red fiber in the end of the silencer that were appreciated by members.
Okay. And were you able to collect that?
No, during the process of trying to collect it, we believe that it fell down into the barrel of the silencer.
Okay. So did you take a swab from the silencer?
We did take a swab of the silencer.
And was that labeled 22A?
Yes,
And did that go to the Vermont Forensic Lab for testing?
yes.
I'm going to show you states 53. I'll take,
Okay. Thank you.
can you tell the jury what's in this photo?
This is just in front of, so the bed made up the entire back of the camper, the rear of the camper. So just in front of that, looking down the camper on the left-hand side was like a couch area, if you will, 2 small chair type things. There was a space in between, so it's more of a chair than a couch, I guess, a seating area.
In states 54?
This is a photo from the kitchen area, again, looking to the back of the van, showing the bed.
States 55?
This is, as each layer of bedding was removed from the bed, further photographs were taken. So this is down to the mattress with like a mattress topper on it.
Okay.
This is the mattress outside what you see in the previous photo, the underside of what you could see in the previous photo.
Okay.
This is the bed, the shelf that the mattress laid on after the mattress was removed.
Just make sure to note the number you're talking
Yes.
about when you talk about this.
Thank you. So I'm looking at States 57.
States 57 shows the base where the mattress laid on top of.
Okay. And there's a close-up in the next photo, but was there something of interest that,
There is a red-brown stain on the 4th panel of wood up.
okay. States 58.
Yeah, so this is a red-brown stain on the panel where the mattress had been laying on the bed.
Okay. What was the significance of taking the photos of the mattress and then of the wood underneath?
So when we brought the mattress outside of the van and took photographs of both sides, it was pretty clear that a bleeding event happened on what ended up being the underside of the mattress, the way we found it, right? On the left-hand side, so the side closest to the inside of the camper, there was a significant blood stain there. While that stain was still wet, the mattress was then flipped, so the stain is more on the right side or the back side, towards the back of the camper.
Okay. And did you collect any swabs from the mattress?
We took a large cutting from the blood stain.
Okay, and did that get labeled as 17A, item 17A?
Yes,
And did that get sent to the lab for testing?
it did.
I'm looking at States 59. Can you tell us what this is a picture of?
So this is the floor area, and you see the driver's seat of the van and the contents behind the seat. There is a faded red toolbox of sorts that had a red-brown stain on it,
Okay.
as well as, very hard to see in this photograph, but you can see the handle of a saw that was also collected. There's the saw.
State 60, is that the saw that was in the previous photo?
Yes.
And State 61?
State 61 is a close-up view of the end of the saw with a red-brown stain on the end.
And was DNA swab collected from the blade, the reddish-brown stain on the,
It was.
and was that identified as 32A?
Yes, yes,
And was that also sent to the lab?
it was.
Tell us what this is a photograph of?
This is a photo of a garbage can on top of I'm not sure if it was a shelf or a refrigerator.
That's State 62. And State 63?
Inside the garbage can is this bottle, which when it was removed is a bottle of bleach.
State 64.
The bleach bottle.
And State 65?
This is the floor of the shower after the 8 bags were removed from the shower. There are red-brown stains on the floor of the shower.
Okay, and was a swab collected from the tub drain?
It was.
Was that labeled as item 36?
No, I believe those are 33.
The swab was also 33?
I believe so. If I could, I'd need to refer to my report to be sure. I believe 36 was a different swab of red-brown stains.
Okay. I'm gonna, just to be sure.
Yes, thank you.
You wrote several reports in this case. Would this be the van and processing report?
Yes, please.
So I'm gonna show you what's been marked as state 107.
Thank you.
Just refresh your recollection.
Thank you so much. So 33, as depicted by the placard, 33 was 2 swabs of the shower floor that are seen there.
Okay, thank you so much.
Yes.
Can I just go back to the bleach bottle for 1 minute? When this picture was taken of the Hannaford bleach bottle, was there a known significance at the time?
We believe that the van had been cleaned.
All right. State 66, can you tell us what this is?
This is a not very clear photograph of the contents in what would be the passenger side floor area. There's various items there, but the item of significance to us was the Swiffer wet jet mop.
Okay. And state 67?
Yes, this is a photo once the mop was removed out of that area.
State 68?
60 shows the bottom side of the Swiffer pad that is dirty with some red-brown stains as well.
And state 69?
This would be the side that sticks to the Velcro, so the upper side, but you can see that the red-brown stains have soaked through to the other side of the cloth.
And state 70?
State 70 is a bag that was also located in that area, shown a few photographs ago where the mop was. This is a garbage bag that contained a pair of gloves.
Okay. So this bag was not located in the shower, is that?
Correct. This was not in the shower.
In state 71?
Those are the gloves that were inside of that bag.
State 72?
This is the center console area of the van. And we're just sort of taking that photograph to show the area, and the next photograph gives you what we're actually taking a photo of.
State 73?
This ring was recognized by me as being Emily's engagement / wedding ring.
Okay. And how did you recognize that?
From my time earlier in the day going through social media posts, there's a photograph of Emily and Joseph on what appears to be their wedding day, and the ring is depicted in that photograph.
So state 74, is that just a closer?
That's a closer view of the ring, yes.
In state 75?
This is another photograph because on closer examination of the ring, there were red-brown stains on the ring.
And so state 76, is this the photograph that you located on Facebook?
That's one of the photographs where I recognize the ring, yes.
And so this is a photograph of Mr. Ferlazzo and Emily Ferlazzo,
Yes,
and she appears to be wearing that ring. Is that the importance?
yes.
Did you also go to the Bear Run condo in question?
I did. It was a few days later, but yes.
Oh, I think I already admitted them, so I'm gonna go. All right. State 77, can you tell us what this is?
So this is a photograph of the parking area. It is depicting the front of my truck, my cruiser at the time, as the parking lot was rather narrow, but a parking area that goes for the condos.
Okay. And state 78.
Another view of the condo.
And what was the significance of these photographs?
This was the condo that Mr. Ferlazzo's sister had rented for the weekend when Joseph and Emily came to visit them.
And were you also present for the autopsy of Emily Ferlazzo?
I was.
Okay. And where did that occur?
At the Office of the Chief Medical Examiner here in Burlington.
And do you recall when that occurred?
That occurred on the 20th of October, 2021.
Your Honor, if I may approach with states 122, which is the stipulation number 7. So, what is it?
Any objection to stipulation number number 7.
No, thank you.
And 122 would be the state exhibit number. Members of the jury, the state and defendant, Joseph Filazzo, have agreed that you may find certain facts. This is called a stipulation. 8 black garbage bags were collected on October 9th, 2021 by Vermont State Police Detective Sergeant Jamie Nolan during a search of the camper pursuant to a valid search warrant. The 8 black garbage bags were transported to the office of the chief medical examiner by Vermont State Police Detective Ben Katz. These bags were x-rayed by Dr. Shapiro at the office of the chief medical examiner on October 20th, 2021. Bags number 1 and number 2 did not contain human remains and were examined by Detective Sergeant Jamie Nolan of the Vermont State Police. Bags number 1 and number 2 were in the same condition at the time of their inspection as they were when collected from the camper on October 19th, 2021. Bag number 1 was logged by the Vermont State Police as CSST Van 1/CSST OCME, Office of Chief Medical Examiner 1. Bag number 2 was logged by the Vermont State Police as CSST Van 2/CSST OCME 2. Bags number 3, number 4, number 5, number 6, number 7, and number 8 contained human remains, and the contents were examined by Dr. Stephen Shapiro. Bags number 3, number 4, number 5, number 6, number 7, and number 8 were in the same condition at the time of their inspection as they were when collected from the camper during the search on October 19th, 2021. Bag number 3 was logged by the Vermont State Police as CSST Van 3/CSST OCME 3. Bag number 4 was logged by the Vermont State Police as CSST Van 4/CSST OCME 4. Bag number 5 was logged by the Vermont State Police as CSST Van 5/CSST OCME 5. Bag number 6 was logged by the Vermont State Police as CSST Van 6/CSST OCME 6. Bags number 7 was logged by the Vermont State Police as CSST Van 7/CSST OCME 7. Bag number 8 was logged by the Vermont State Police as CSST Van 8/CSST OCME 8. Chain of custody of these items is not being challenged. As with any evidence in this trial, you must decide what weight you will give this stipulation. And 122 is the exhibit number.
Thank you, Judge. And the state would move to admit photographs 81 through 91.
Any objection? 81 through 91 are admitted without objection.
Okay, so you said that the autopsy of Ms. Filazzo occurred on October 20th of 2021.
That's correct.
What was the first thing that you did in the autopsy?
All of the bags were placed into a transport bag. And the first thing that was done was that bag was documented and then opened. And then each bag was x-rayed.
Okay. What did you discover in the first bag?
In the first bag was a red throw pillow.
And for the record, I'm showing you what's been marked as states 81.
Yes, the pillow, as you can clearly see, appeared to have 2 bullet defects in it.
And was this throw pillow identified as item 1A?
Yes.
I'm going to show you what's been marked as states 80 and judge will take admission as states 80.
That's 80. Any objection, Ms. Johnson?
No objection.
It is admitted without objection.
Can you just describe for the jury what this is and the significance?
So this is the red throw pillow seen in the picture, along with the original packaging that it came in.
Was a sample of this throw pillow sent to the lab?
Yes, I believe there was a sample of it. Yes.
And when you saw this pillow in the first bag, did it look familiar to you?
It did.
And why is that?
There was another identical pillow on the couch sitting area of the van.
So I'm showing you it states 82. Is that the other matching
Yes,
pillow?
some very similar, if not identical pillow.
And what did you discover in the second garbage bag?
There was a bed pillow, which had a gray pillowcase on it. In between the pillowcase and the pillow was a projectile. And there was also a gray sheet, a fleece sheet in the bag.
Showing you what's marked as states 83.
So this is the gray pillowcase with the projectile on the pillowcase.
Okay. And was this projectile labeled as item 2A?
I would need to refer to my autopsy report if possible.
Would it also likely be on the evidence?
It would,
tag?
yes.
I'm going to show you what's been marked as states 108 for your recollection,
Thank you.
your autopsy report. And I'm also going to just show you what's been marked as 83A.
Okay. Yes, 2A.
So that is the projectile that was located between the pillow and the pillowcase.
Correct.
We've moved to admit states 83A.
Ms. Johnson, any objection to 83A?
No.
83A is admitted without objection.
And in states 84, can you tell the jury what this is?
This is a projectile that was located within the actual pillow, not the red pillow, the other pillow that was in the bag.
Like a bed pillow?
A bed pillow, yes.
And was that projectile labeled as item 2B or 2B, I should say?
2B.
I'm going to show you what's been marked as states 84A.
Ms. George, you need a pillow.
Yes, 2B.
Move to admit states 84A. Is it admitted, Judge?
I'm sorry,
Sorry, 84A.
any objection?
No objection.
84A is admitted without objection.
Show you what's been marked as states 85. And tell the jury what this is.
This is a cartridge casing, meaning a fired round of ammunition.
And show you what's been marked as 85A. And was this noted as item 2C?
C, yes. So it was also located in garbage bag number 2.
Okay. Move to admit states 85A.
Any objection, Ms. Johnson?
No objection.
85A is admitted without objection.
And can you tell us what States 86 is a picture of?
This is the gray pillowcase that was on the bed pillow located in bag number 2. This is the pillow that pillowcase was on.
I'm going to show you what's been marked as States 87A. Jury, what that is?
This is the pillow depicted in that photograph that was in the gray pillowcase.
And anything of significance you can still see?
There is a clear bullet defect in the pillow.
Judge, the state would move to admit States 87A.
Any objection? 87A admitted.
And on the back side of that pillow, and also depicted in States 88, what is that?
There, based on the x-ray, there was, the projectile we believed was in the filling of the pillow, so that's where I cut into the pillow to find the projectile.
Okay, thank you. States 89,
This is the fitted bed sheet that was also in bag number 2.
States 90,
These are 2 unfired rounds of ammunition, also located in bag number 2.
and States 91.
This is a projectile that was removed from bag 4.
I'll show you what's been marked as States 91A, and also item 4A.
Yes.
Can you just tell us again what that is?
Yeah, it's a projectile.
And that was discovered in bag number 4.
Yes.
State would move to admit 91A.
No objection.
Admitted without objection.
And was that item, that last item sent to the lab for testing?
It was.
What else was located in bag number 4, if anything?
Sorry. Emily's head.
Okay. And looking at that, were you able to determine Emily's identity?
Yes.
And how were you able to determine that?
I recognized Emily from photos.
I'm gonna enter stipulation number 8, Judge, States 123.
Any objection, Ms. Johnson? Stipulation number 8. Members of the jury, the state and the defendant, Joseph Palazzo, have agreed that you may find certain facts. This is called a stipulation. 8 black garbage bags were collected on October 19th, 2021 by Vermont State Police Detective Sergeant Amy Nolan during a search of the camper pursuant to a valid search warrant. The 8 black garbage bags were transported to the office of the chief medical examiner by the Vermont State Police Detective Ben Katz. These bags were x-rayed and further analyzed by Dr. Shapiro at the office of the chief medical examiner on October 20th, 2021. Bags number 3, number 4, number 5, number 6, number 7, and number 8 contain human remains. Those remains were identified as Emily Palazzo, date of birth, July 25th, 1999. Emily Palazzo's identity is not being challenged.
Excuse me.
As with any evidence in this trial, you must decide what weight you will give this stipulation. States Exhibit 123, admitted.
What did you discover in the 5th bag?
I'd like to refer to my report if I could.
Yes. And that's, remind me what number that is?
That is States 108. Okay. Bag number 5 contained a right arm and a left foot.
And what did you discover in the 6th garbage bag?
Bag number 6 contained the rest of the right leg.
And the 7th garbage bag?
And number 7 contained Emily's torso.
And the 8th garbage bag?
Left arm and right foot.
And did you also collect swabs from the remains found in these bags?
From the remains, no. A DNA card was collected to have a sample of Emily's DNA, but the handles of the bags had been swabbed on scene on the 19th.
Okay, I was referring to the DNA card. Can you tell the jury what that means?
Sure. During autopsy, because it's always standard protocol to have a DNA sample of a victim or a decedent on file. So a blood sample is taken, a drop of blood is placed onto a card, and that's called a DNA card.
Okay. And was that DNA card labeled as item 15? Are you able to, is it in?
Sorry, yes. Yes,
Okay. And was that sent to the Vermont Forensic Lab for testing?
yes, it was.
When you were examining the remains, did anything about a particular area of the body surprise you given what you knew about the investigation?
Yes.
What caught your attention or what surprised you?
Dr. Shapiro actually drew my attention when he was examining Emily's torso.
Okay. And so did you look for yourself to see what had caught his attention?
I did.
And what about the body did you observe?
Several stab wounds in Emily's torso.
Okay. And what were the sort of approximate location of these stab wounds?
Mostly upper chest. One particularly, which would have probably entered her heart.
And any on the backside of her torso?
I believe there were a few on the back as well.
And so did learning of this additional information during the autopsy lead you to search for anything additional in the van?
Yes, so because I was at the autopsy, my partner, Aaron McNeil, had shown up in the later evening on the 19th. So on the 20th, because I was going to the autopsy, he was sort of overseeing we thought we were wrapping up processing, but learning this information during autopsy, the focus then became collecting all knives found in the van, excuse me.
Okay, and so did you have Aaron McNeil go into the van and collect those knives?
He was still working in the van that following day, so we just sort of said, okay, we're now need to focus on any knives found.
Okay, thank you. That's all I have.
Thank you.
You ready?
Good afternoon, Detective Just a few follow-up questions. And for clarification, you attended the autopsy as an observer, correct?
As an evidence collector.
Okay, but you didn't really have any part of conducting the actual examination, correct?
Correct.
And just a few questions back to the Maple Fields encounter the afternoon, excuse me, of October 19th, 2021. You already testified that when you were walking with Mr. Filazzo to your vehicle, you had observed him seeming as if he might pass out, and you asked to put your hand on him.
Correct.
Do you recall testifying in a deposition on November 11th, 2022? No, sorry, November 29th, 2022.
I recall testifying in a depot, yes.
Okay. And in the deposition, You also described him at that particular point as he looked woozy. Do you recall that?
That would be accurate.
Okay. And you also described him as wobbling as he was walking. Do you recall that?
Yeah, that would be accurate as well.
Okay. And also in the deposition, you described him as looking pale and pasty. Is that accurate?
Yes.
Okay. As you were walking with Mr. Filazzo to your truck, did you ever tell him he was free to leave?
No.
Okay. But he was essentially in custody, correct?
No, not at that point.
So if Mr. Filazzo had tried to walk away at that point, though, you probably wouldn't have allowed it, correct?
I would not have allowed it.
I'm just briefly, when you arrived at the St. Albans Vermont State Police Barracks, there was not an interview room available at that time, correct?
Correct.
And Mr. Filazzo had to stand, everyone was standing and waiting in the hallway until the interview room cleared out, correct?
There were 3 of us with Mr. Ferlazzo at that time in a hallway. Correct.
Okay. And you had stated in your report, as well as your deposition, that you offered Mr. Filazzo a chair as well as some water because, as you stated, he appeared physically exhausted and barely able to stand. Is that correct?
Yeah, he was leaning against the wall.
Okay. I have no further questions. Thank you.
Thank you.
Okay. Ms. George.
No redirect, Judge.
Okay, thank you.
Thank you, Your Honor.
May we approach, Judge?
Come on up. Tomorrow so we're going to break for today. Tomorrow is a shorter day, but I'm going to ask you to get here a little early. I'm going to ask you to get here at 8:15. I'm hoping to start at 8:30. We're going to go until about 12:30 and then break for the day because we have some things in court I have to do independent of this case. And then we'll start again and might get through the evidence on Wednesday. That's at least the hope. We'll see how things go, but so far we're definitely ahead of schedule. All right. So we're going to release you for today. Same admonition, please, please, please don't talk to anybody about this case. Don't try and find out any information about it or read any news sources of any kind or social media posts. And with that, have a good night, and we'll see you at 8:30 tomorrow morning.
All rise.
Any other issues anyone wants to discuss outside the presence of the jury before we break?
No, Judge. Thank you so much.
Tomorrow, why don't you all get here 8:15 just to make sure there are no additional issues to take up before your first one.
And we'll start at 8:30. Okay.
Can you just ask who will be the evidence?
Yes, so.
The court is
I'd
asked
rather
to
you-
keep it. Okay.
Hey y'all, sorry about that. I had to go outside and get some food. All right, so this day is over. So I guess we're waiting for the jury to come in. Yeah, I had to go outside to get some food. Court is not done. That was previous day. So I'm just gonna play this small talk until they start at
Objected self-defense, right?
I agree.
until they start at 1 o'clock.
I agree, but.
I'm trying not to get overly
I don't-
creative.
I
So we
think
should be starting.
Citing all of these physics.
This is in
size,
Vermont. They're on
age,
Eastern time. We
gender,
should be starting.
physical
Court should be
strength.
starting in 45 minutes.
The issue is his perception of the circumstances.
And the reasonableness of it, not his perception, it's
Wait,
the
Dave, what?
reasonableness
All right,
of his
y'all, hold on.
perception and
Given
the
his-
accuracy of his
I need a
perception.
specific
his-
time
Who he
stamp
is.
to put
I
on.
think the case law clearly supports
Y'all
that,
give me a
that
specific time to
based
start
on
for day one. I'll put on
his
day one.
psychological.
Well, if you have another term you want to include
put on
in
day
the
one, but I
such
need a
as
specific
clause, why don't you think about that?
Because I'm
All right.
sure that.
But I didn't see, frankly,
day
obviously I'll
one, there's
state
probably
the
a
obvious.
lot of-
There was no expert testimony here regarding Mr. Filazzo's
This is day one.
mental
Right,
And he
this
puts
is day
them in a
one.
plastic grocery bag. And he eventually throws those things away somewhere at a gas station.
This is day one. I guess this is open. Y'all just want to see opening arguments.
Palazzo sends to Emily over Emily's phone over the weekend. The same phone that he turned off and put in a bag and threw away.
This is
From Saturday,
opening
1
arguments.
o'clock Until Monday at 10:30 in the morning, he sends 16 text messages to her phone, asking where she is, asking her to come back, getting angry with her for not answering his calls. Or
We want to
texts,
see her mom
and
testify.
eventually
Okay.
telling her.
So y'all are just
Doesn't
okay. So
deserve this
so
shit.
y'all definitely are the morbid law people. Y'all are definitely the morbid law people. Y'all are definitely the morbid law people because you want to see her mom testify. You are definitely a morbid law person. Let's see. No doubt. All right, so all of this is his interrogation. So this has to be her mom here then. This has to be her mom. I don't
Your
see anybody else who
testimony from
could
the
be her
medical
mom.
examiner about how Emily's body.
This has to be her mom, right?
And do you know David Bass?
Is this her mom?
Okay, who is David Bass?
He's my husband.
Okay. And how long have you been married?
Yeah, it's got to be her
5
mom.
years.
Okay. Where did you reside in October of 2021?
Okay, I'll leave it playing here
185
then.
Bay Hill Road,
I'm trying to get my
Northfield,
grub
New
on.
Hampshire.
And you resided there with David?
Yes,
Did you reside there with anyone else?
yes.
Who else did you reside there with?
My son Matthew and my daughter Emily, as well as Mr. Ferlazzo.
When was your daughter Emily born?
July 25th, 1999.
Okay. And when did Emily marry Joseph Ferlazzo?
October 10th, 2020.
2020? How long had they been dating when they got married?
Only a few months.
At the time that they got married, had you met Mr. Ferlazzo?
Yes.
How many times?
I only remember one time, but it may have been another time.
So did you know him well when they got married?
No.
When did they move in with you in Northfield, New Hampshire?
So Emily had moved back in April of 2021. She made that her legal address again. And then he moved in September 13th, 2021.
So Emily moved back in April. Where was Mr. Ferlazzo residing when she moved back in with you?
I'm not entirely sure if he was still in their Essex Junction apartment or if he was on the Lang's property.
Okay. Do you know the Langs?
No.
Okay. Do you know where they live?
Yes.
Where do they live?
Judge, can I interrupt for just a second and approach, please?
And
Let me ask you what the purpose of your trip was?
yes,
What?
I'm sorry.
Oh.
Okay. I think her breathing is picking up louder than the words she's saying. It's not easy,
okay.
but we'll keep going.
On my nose.
No, I think because it's a little louder now, you don't have to be quite so close.
Okay.
Okay. They're planning on going to a trip to Vermont.
Yes.
And what was the purpose of that trip?
The purpose was twofold. One was Emily was excited to meet her sister-in-law, Nikki. She hadn't met her yet. And the other was to celebrate their 1-year wedding anniversary.
Do you know how long they plan to stay in Vermont?
Until Monday.
And did they intend on coming back to New Hampshire on Monday?
Yes.
Did you see them leave?
No.
Okay. Did Emily seem excited to leave? To go on the trip?
She was excited to see her sister-in-law, but it seemed to be taking longer to get the bus ready. So she seemed, I don't know how to describe it. She wasn't upset, but sort of just, what's going on? When are we going?
Okay.
So,
Anxious to go?
yeah.
Okay. Did you speak to Emily once they had left?
Through Messenger.
Okay. Do you recall when the last time was that you heard from her?
It was about around 7:45 that night.
Okay. And that was through Messenger?
Yes.
Messenger. Did you speak to Joseph once they had left?
No.
So you didn't speak to Emily or hear from Emily on after 7:45 or 8 on Friday night?
Correct.
And did you hear from Emily at all on Saturday, the 16th?
No.
Did you hear from Joseph at all on Saturday, the 16th?
No.
Did you speak with Emily at all on Sunday, October 17th?
No.
Did you hear from Mr. Ferlazzo at all on Sunday, the 17th?
No.
Did you speak to Emily on Monday, the 18th?
No.
Did you hear from Mr. Ferlazzo on Monday, the 18th?
Yes.
Did he call you from Vermont?
No.
How did you happen to hear from him on Monday
He walked into our house
in New Hampshire?
in New Hampshire.
Do you recall when?
It was around 6 p.m.
Okay. And was Emily with him?
No,
Did you ask him where Emily was?
yes.
What explanation did he give you about why Emily wasn't with him?
That they had had an argument and she got out of the bus on Route 2. He drove away to a gas station to let her cool off. And then he came back, she was gone. He had then said that she had mentioned something about getting an Uber, so he thought that's what she did.
Okay. Did he tell you when this happened?
Saturday afternoon.
Did he tell you where the van, or I should ask first, was he in the van when he came to your house?
No,
What was he on?
he was on the Ducati Monster motorcycle.
Okay. And this was in mid-October, correct?
Yes.
Did he tell you why he wasn't in the van?
No.
Did he tell you where the van was?
I asked him 2 different times and he told me 2 different answers. One was New Haven and the other is at a garage of somebody, I believe, named Kurt.
Someone named Kurt? Okay. Were either of those locations that he gave you his friend's house in St. Albans?
No.
What did you observe about him when he arrived?
He was shaking. I interpreted that as he was cold because he had just driven from Vermont on his motorcycle.
Based on those observations, what did you say to him?
I suggested he take a shower and then we would talk more about Emily.
Okay. And before he took a shower, did he give you anything?
He gave me Emily's driver's license.
How did that happen?
He had put his hand in his pocket and pulled it out and seemed surprised that it was there and handed it to me. And I believe I asked him why he had it. And he said that they had gone to buy alcohol and Emily gave it to him just in case they needed to see it.
I'm going to show you what's marked as states 2. Okay. Recognize this?
Yes.
Tell the jury what this is.
That is my daughter Emily's most recent driver's license.
Is this the driver's license that you would want to see?
Yes. Yes.
I have no objection, but I am having a little trouble hearing.
Okay. States 2 is admitted without objection. Bring it up. And just do your best to keep that voice up. And Ms. Jantz, if you have continued, let us know so
Thank you.
we make sure you can hear.
Jurors are also having trouble.
Obviously, the jurors, you can raise a hand if you're unable to hear in the back as well, because we want to make sure everybody hears all of the testimony.
When Mr. Ferlazzo was at your house, had the police been contacted at all about Emily?
Objection. Unless she's going to testify that he told her one way or the other whether they had been contacted, I don't know how she would know. And it's a leading question.
We'll sustain it as asked. sustain the objection.
Were you aware of whether the police had been called?
Same objection.
Foundationally, I will sustain the objection.
Did Joseph tell you that he called the police?
He did not.
And did you call the police?
My husband, David Bass, called the police with me.
Okay. And what police agency did you call?
I believe we spoke to both the New Hampshire State Police and the Vermont State Police.
And did the Vermont State Police ultimately speak to Mr. Ferlazzo?
Yes,
And was he at your house when that occurred?
yes.
How long did Mr. Ferlazzo stay at your residence?
Until about 8 o'clock.
How long after speaking to the police did he leave your residence?
It wasn't very long.
What did he do while he was at your residence?
He took a shower. He ate the dinner that David had made for us. He obviously spoke to the police. He changed his clothes. Spoke to us, answered the questions that we asked him.
Do you recall what dinner he ate?
It was some sort of pasta and sauce.
And when he ultimately left, after speaking to the police, did he say why he was leaving?
Yes.
Why did he say he was leaving?
He said that he had work to do in Vermont. He had tattoos to finish.
Before he left, did he agree to anything related to his phone?
I believe my husband, David Bass, was able to get him to share his location. They shared their locations with each other. My intention was to help make sure that the sentiment was to make sure he got to where he was going safely.
And that was in Vermont.
Yes.
Did he leave on the same motorcycle that he arrived on?
No.
What did he leave with?
The red Jeep Wrangler.
And that was his Jeep?
Yes,
And it was at your house?
it was.
And how long had that Jeep been at your residence?
Less than a month.
Do you know whether he owned any other motor vehicles? Any vehicles, not motorcycles?
He owned the converted bus.
And I think, forgive me if you already answered this, do you recall what time he left your residence on Monday?
It was around 8 p.m.
And did you ever see Mr. Ferlazzo again after that?
No,
And did you ever hear from him again after that?
No.
Did you ever see Emily with a firearm?
no.
Did you?
Judge, these are leading questions. Did you ever see her with a firearm? Is a yes or no leading question.
There are certain, I'll overrule you.
Thank you.
To your knowledge, did she own one?
No.
Those are all the questions that I have to ask.
Okay, thank you.
Thank you, Judge.
Ms. Jantz, do you have cross?
Thank you. Good morning.
Good morning.
And I understand and appreciate how difficult this is for you.
Thank you.
It's obvious to all of us how deeply troubling and emotional this is for you. So I'm going to try and do my best not to upset you anymore. Okay. And are you picking? Am I being recorded?
I can't hear you, so I'm guessing they can.
You can't hear me, okay. I just was telling Ms. Bass that I appreciate how hard this is for her to appear today and talk about this. Prior to their, so I think you said you met Joseph once before she and Emily got married, is that right?
Yes.
And I think you said that your impression was he was quiet, is that right?
I don't remember if that's what I said.
You didn't dislike him, did you?
No, not at that point.
You liked him, didn't you?
I didn't know him at that point.
Well, you knew Emily liked him, right?
Yes.
And I think you said if she liked him, then you were willing to go along with that. Is that
Correct.
about right?
Yes.
So you had, prior to their marriage, you were not, you thought they were happy together. Is that fair to say?
Yes.
Did there come a point when you thought that they were having trouble as a couple?
Yes.
When was that?
The New Year's Eve, 2021.
New Year's Eve 2021.
Yes.
I'm talking about before Emily's death, which was October 2021.
So, sorry, October 20.
2020.
Yes, 2020.
Okay.
Thank you for clarifying. Help me.
That's okay. What did you see or observe that led you to the conclusion that their marriage might be having some problems?
So it was a phone call from Emily near midnight stating that she had been in a fight with him and that he had pushed her and she was crying. And then later she went into a room to be by herself away from him. And
Something she told you?
yes.
Okay.
And
in this same phone conversation?
yes.
Go ahead.
And then she recorded herself in that separate room with him on the other side talking to her.
Were they arguing?
She wasn't saying anything to him, but he seemed to be upset that she was in a separate room from him.
What did you hear that led you to that conclusion?
I don't remember exactly what was said.
And after that, were there periods of time when Emily was considering divorce?
Yes.
But as far as you know, that happened more than once that she talked about the divorce, right?
Yes.
But they always reconciled. Is that right as well?
Yes.
And you said that Ms. Joseph gave you Emily's driver's license in connection with the purchase of alcohol. Am I understanding that correctly?
Yes.
Can you guys hear me? They drank alcohol together, didn't they?
I believe so.
Vodka and wine. Is that your recollection?
I'm aware of the vodka. I'm not sure about the wine or any other specific types of alcohol.
And this was when they were living in your house, correct?
Yes.
Do you know of any other times when they consumed alcohol? And if you do, how do you know?
Yes. That night, the New Year's Eve night, Emily told me that she'd had some vodka.
Vodka? Was it your impression when they were living in your house that they drank to excess?
I didn't see them drink a lot at all.
At all? Okay. So how do you know that they drank vodka? while they were living in your house if you didn't see them drinking?
I didn't see them drinking excessively.
Oh, I see. Okay, thank you. Okay. So, prior to the day that they left your house to come to Vermont, you testified on direct examination that Emily was upset that it was taking so long for the camper to be ready. Is that right?
Yes.
What did you see her say or do that led you to that conclusion?
She seemed, how to describe it? Not necessarily frustrated, but confused as to why it was taking so long for him to get the bus ready. She said she thought that it was ready, but he kept doing different things in the bus and wasn't ready to go.
Okay, so you just said she seemed confused and frustrated. How did she express that? For
She
example,
told me,
She
she
told you.
said that she doesn't know why the bus isn't ready yet. I thought we were gonna go at this time and he's still doing things.
was she easily frustrated in your experience?
No, it depends on the mood.
On the mood?
Yeah, what's going on? Is she tired?
I'm sorry.
If she's tired,
She would be more easily frustrated.
sure.
I think that's normal.
Yeah.
Other than the phone call you've described to us where of New Year's Eve, did you ever see Emily and Joseph arguing?
When he or Emily were driving me places, when she was driving, he would do things like grab the steering wheel on her, change the station, poke at her body.
So I'm going to use a word. He was like heckling her. Is that right? Something to that effect, or is that too benign a word to describe what his actions were? Heckling.
I can say when observing that
Yeah.
situation, I was very concerned about our safety.
Okay. How did Emily react?
She was telling him to stop.
Okay. Was he laughing or did he, for example, do you think it was a joke?
I don't remember hearing him laughing.
Okay. Did you ever observe any marks on her body?
Yes.
Did you ever ask her how she got those marks?
Yes.
What did she tell you?
The gouges down her chest, she said that she acquired them from their dog. The arm bruise, the handprint bruise on the back of her arm, she would not tell me where it came from. And then there are many bruises on her thighs. She said that they came from rough sex.
Rough sex. Did she ever tell you that Joseph had physically abused her? Other than the phone call on New Year's Eve that you've told us about?
I don't recall.
So you don't recall, or she never did?
I don't recall.
Okay. You'd remember though, wouldn't you?
I would think so,
Yeah, because you remember the New Year's Eve call.
because it was New Year's Eve and it was a big deal.
It was a big deal. And she's your daughter. So you would remember if she'd ever told you about any other instance. May I have a moment? don't have anything else. Thank you.
Okay, thank you.
Thank you. Ms. George,
I don't have anything else.
thanks so much. Please be seated.
Good morning. Can you state your name and spell both your first and your last name?
My name is Kaylee Caderet. My first name is Kaylie. My last name is Cadorettet.
Ms. Cataract, before we get started, I just want to ask you to please keep your voice up because the jurors are having some difficulty hearing us
Okay.
today. Thank you. Ms. Cataract, what town do you live in?
I live in Brattleboro,
How long have you lived there?
a little over a year.
Where did you live before that?
St. Albans,
Where were you living in October of 2021?
St. Albans.
What do you do for a living?
I'm a police officer,
How long have you been a police officer?
about 6 years now.
What police agency do you work for?
I work for Wilmington Police Department. Wilmington Police Department.
Have you worked for other police agencies?
Yes, I have.
And what other agencies?
I worked for St. Albans before Wilmington.
And were you working as a St. Albans police officer in October of 2021?
Yes, I was.
Where did you grow up?
St. Albans.
Do you know people by the name of Sarah and Jason Lang?
Yes, I do.
How do you know them?
They are the mother and stepfather of one of my best friends from childhood,
And who is that?
Alex Giroux.
Where do the Langs live?
They live on Meadowbrook Lane in St. Albans.
Have you been to their home?
Yes.
Do you recall being at the Langs home in St. Albans on October 19th of 2021?
Yes.
Do you recall what day of the week that was?
It was a Sunday.
Why were you at the Langs home?
I was there just to spend time with Alex and his parents.
Do you remember what time you arrived?
I think I arrived around 7 p.m.
And when you arrived, who was there?
Alex was there, Sarah was there, and Jason was there.
At some point during the evening, did somebody else arrive?
Yes,
And who was that person?
Joseph Ferlazzo.
Did you know Joseph Ferlazzo at the time?
At the time, no.
Had you met him before?
I found out later that I had met him briefly before.
Was he alone?
Yes.
Do you see the person who you saw that evening in the courtroom today?
Yes.
Can you point to that person and describe where they are sitting and an article of clothing that they're wearing?
He's in the middle seat at that table and he's wearing a blue shirt.
Your Honor, if the record can reflect that the witness has identified the defendant.
So reflected.
Did you spend the evening at the Lang's house in St. Albans?
Yes.
What did you do?
We sat around the fire and visited and drank a couple beers.
Where is the fire located at the Lang's home?
Directly behind their house in their backyard.
Who was hanging out at the fire?
Myself, Alex, Sarah, Jason, and Joseph.
Did you see Mr. Ferlazzo's van parked on the property?
Yes.
Where was it parked?
It was next to the driveway, a little bit back. You could see it from where we were sitting at the fire.
How far away was it from where you were sitting by the fire?
Maybe 30 feet.
Now, you said that you had you had some beers at the fire. Who were you drinking?
Yes.
How much did you drink?
I think I had 3 beers.
Was Alex drinking?
Yes.
Do you know how much he was drinking?
I don't know.
What about Jason?
Yes.
And Sarah?
Yep.
Was Mr. Ferlazzo drinking?
Not that I recall.
Was anybody using drugs?
Yes.
Who was using drugs?
Joseph.
Do you know what drugs he was using?
It appeared to be marijuana.
And why did you think that?
He was smoking it out of a bong.
How do you know what a bong is?
Life experience and law enforcement experience.
Do you recall how much he was smoking or how often he was smoking?
I recall that he was, as I'd recall somebody sitting across from me drinking, but I don't know how much.
Did Mr. Ferlazzo appear high or under the influence to you?
No.
Can you describe Mr. Ferlazzo's demeanor during the evening?
He was very relaxed, casually engaged in conversation.
How long were you hanging out with him by the fire?
I think it was about 4 hours.
During that 4-hour period of time, were you talking with him?
Yes.
What were you talking about?
We talked about our jobs. We talked about the camper that he was renovating. He said that he was going to live out of it. Just small talk.
And while you were talking, you mentioned, did he tell you what he did for a living?
Yes, he said he was a tattoo artist.
And when he told you that he was a tattoo artist, did you recognize him at that point?
Yes.
And tell us about that.
A friend of mine had gotten a tattoo from him years before.
And was that when you made the connection of that you had previously met him?
Yes.
Did you tell Mr. Ferlazzo that you were in law enforcement?
Yes.
How did he react to that?
He continued to engage me in conversation very steadily for the rest of the night.
Around what time did the evening end?
I think around midnight.
And how did it end?
Myself, Alex, Sarah, and Jason went into their house, and Joseph went off in the direction of his camper.
As you were retiring for the night, did Mr. Ferlazzo say anything to you?
Yes.
What did he say?
A comment was made where he related something to Emily. He said, "Oh, Emily likes that." And I said to my friend Alex, "Oh, I didn't know that he had a wife."
Had he not spoken about a person named Emily in the 4 hours before?
No.
Did he tell you that he was married?
No.
Did he tell you that his wife had walked off on Saturday and he hadn't heard from her?
No.
Did he tell you that he had been texting his wife's phone and she hadn't been responding?
No.
I don't have any other questions, Your Honor.
Okay. Any cross, Ms. Jones?
Good
morning.
Checking to see if it's still morning. So you just testified that you, initially thought you had never met Joseph before, correct?
Yeah.
Had you actually met him when your friend had the tattoo previously?
I was with her when she
Okay,
had her
but
tattoo.
you had no memory of that at the time?
No, it was years before.
Okay. I think you testified that you yourself and I'm sorry, I forgot his name. Jason and Sarah Lane and their son, your best friend, were sitting around first around the bonfire, and at some point, Mr. Ferlazzo came and sat down. Is
Correct.
that correct? So it wasn't a situation where it was just you and Mr. Ferlazzo having, the two of you having a conversation. It was sort of a group bonfire.
Correct.
Okay. Do you recall giving a deposition on June 13th, 2023?
Yes.
Approximately, yeah. So you stated in your deposition that the conversation was very small talk type. Is that accurate?
Yeah.
I think that you also mentioned that Mr. Ferlazzo's dog was around, and so there was some playing with the dog as well?
I believe so.
Okay. then at some point he left, and you folks remained in the Lang's house, correct?
Correct.
All right. So I think that you had mentioned that and do you recall giving an interview with Detective Truex?
Yes.
And I believe also in the deposition, you stated that he seemed normal, and you had also mentioned that he hadn't mentioned his wife, but yet you were talking about small talk things.
Yes.
So, having not really interacted with Mr. Filazzo previously, you wouldn't really necessarily have a baseline or no way of knowing how Mr. Filazzo behaves typically in various situations. Is that fair?
That's correct.
Okay. So his normal behavior or abnormal behavior, there's nothing to compare it to.
He was calm.
Okay. All right. That's all I have. Thank you.
Thank you.
Any redirect?
No redirect. Thank you.
Thank you.
All right, y'all. So the jury should be coming in at any moment now. So I'm gonna just put it here. What was the point of that testimony? Oh, crap. I'm gonna have to restart this, y'all. Give me a sec. What was the point of that testimony? Was that just to show that dude was out here trying to get his freak on? Was that a freak on testimony, people? Oh, was this cookout after his wife was already killed? Sorry, y'all. I've been doing a million things, so. So forgive me. I'm going to go back and see if we have a volume. Can y'all hear this? Let me know if you can hear this because StreamYard told me that the volume was lost. So let me know if you can hear this. Verdict will probably not be today. I think they're doing closing arguments. I mean, if they do closing argument, no, because they have to do jury instructions. So I doubt it. It'll probably be tomorrow if it's a quick verdict because they'll do closing arguments today, I think. Both sides will tell their side, and then they'll need to give the jury instructions, which will take some time. Then the jury will probably have to deliberate for at least, an hour or more. Can y'all hear this? Yes or no? Because StreamYard gave me a message saying that it lost the audio. Closing arguments can last. I think there are statutory limits, but typically they can last to any time within the limits. Y'all can't hear this? Y'all don't hear the judge? All right. Bear with me 1 second. I'm going to restart StreamYard, y'all. Give me a quick sec. Give me a sec.
The term is much, I don't think that's actually right.
All right, can you hear it now?
Suggested that Judge Katz didn't quite get it right.
Y'all still don't hear it?
It wasn't as artful as it could have been. I think the terms have to be much more consistent.
Good. So They should be starting soon then. They should be starting soon. Miss Lily, you have a channel? Let's take a look. Let's go to Miss Lily's channel. So Miss Lily, I only see 2 videos on your channel. I see 2 shorts. I'll subscribe though. But I see 2 shorts. Well, I just subscribed to you, so you have another subscriber. All right. So now we are just now we're just waiting for the court to start. I guess, let me see. So y'all, what do y'all think is gonna happen? Let's talk about that a little bit while we wait. I kind of feel like from what I saw yesterday, I kind of feel like it's a wrap for this guy. I kind of feel like it's a wrap for this guy. Okay, Miss Lily says go to playlist. Yeah, I see playlist, but this is Miss Lily's channel. But are any of these videos you made, or are these playlists from these are other people's videos, right? Or did you make any of these? Miss Lily, you deep in the trials. You got to let me know which trials we should be watching next. You got to let me know which trial we need to be watching next. Cool. Well, let me know. Oh, you're on the Tiffany Dalton thing too, Miss Lily. You're not playing no games, huh? I didn't want to cover that, y'all. I didn't want to cover the Dalton thing because I was already covering YSL, which includes Fonnie, Hilton, and Love. And I felt like if you also cover the Dalton, like I was mainly covering that. So I'm like, if I also include the Dalton thing, it's gonna seem too I don't know. There's one demographic profile that all of those people fit. And I was like, nah, I don't want to be the channel of only covering that, if y'all feel me. If y'all see what I'm saying. So, yeah, I know the Tiffany thing is crazy. Let's see what happened right before they wrapped up here. I'll keep it open on my other screen for whenever they actually get the jury in. I'll keep it open. Yo, the one thing that strikes me about this courthouse is that it seems like it's so much more chill back and intimate. Doesn't this look like it's so much more intimate than the YSL courthouse? I mean, it seems like there isn't that much space separating people. This guy looks like he could just walk out, get up and walk out and go for a stroll down the road if he wanted to. You know? Yeah, nah, exactly.
Just gives you
LTK,
everything
exactly.
you've asked for before.
So I'm up to, I finished 19, no objection.
Yeah, it looks like it really does look like an
I'm on
office
page
meeting.
20.
Exactly.
20 I want to talk about because I want to see if there's any basis for an involuntary. I included it because you asked for it, I think, but I'm not convinced that you're really asking for it. It's pretty hard. I don't know how you get away from the intent piece, given
All of this is really important.
Interview statements and his testimony yesterday. It wasn't. There's nothing. The intent was to, I think, as he described, to shoot her.
I would agree to remove the involuntary manslaughter.
Okay. And you support that. Is that correct, Ms. George?
Yes.
Yeah, this judge is chill.
We put the presumption of innocence twice in page 21.
We said about
Oh, was it somebody got killed, Lou, at a courthouse
Because
there,
that's
was it, or
where,
what?
Peggy initially put it, I said put it.
This is about presumption of innocence with regard to degree of murder.
Oh, wow. Okay, I didn't know that.
What are we talking about?
Why are we doing it again?
So,
sorry,
that
what are
happened
we
in
talking about?
Olive Branch, Mississippi last week. A guy was in bond,
Was
drove
this
himself to
specifically
court, but got
requested?
slapped with some years and took off for a stroll. Oh my gosh. That is wild.
It was included in the defense request as well.
Okay.
That is wild. That would be infuriating too if you were the victim. Slim, am I seeing? Yeah, I'm seeing your messages, Slim.
To get rid of.
I don't see that you said anything for the last.
On the verdict. Get rid of 5. Page.
Oh, okay, Karen Reed. Yeah, so
Well, are we getting rid of involuntary manslaughter?
Yes.
yeah, I said let's do Karen Reed now. At that point, I thought that
No, I was
Karen
talking to
Reed's
Dana about
trial
striking
was.
certain things.
I thought that Karen Reed's trial, her new trial, was coming up in January, but then I saw that they had pushed it back to April. So that kind of, I don't know, kind of brought my motivation down a little bit because I thought we would be able to run, watching the trial right into the new trial, kind of just seamlessly take the old trial into the new trial. Now I feel like if we watch it, like let's say we start watching it next week, we get through it, then we're gonna have like a several month break before the new trial starts. But maybe there'll be motions and all that kind of stuff in the meantime that can keep us up. So I do want to get that. Seems like it's the biggest trial outside of YSL. Seems like Karen Reed is the biggest trial, it's the most time, it's the most watched, most attention grabbing trial outside of YSL. So I think we could, if y'all want to just go through it, I think let me see. How many days of trial were there? How many days of trial? How many days of trial were there for Karen Reed? Let's see. So it started on April 16th and it ended on July 1st. How many days in court? Let's see. It's 35 days of court proceedings. Only to come back to a hung jury. No, I don't have that there live right now. This is what I have right now. So we can leave it on here just in case. But no, they're not live currently. Not really sure. I mean, I know that the judge said for the jury to be there at 1 o'clock, so it looks like they're getting started a little late. Miss Lely, seriously, you never heard of Karen Reed? Seriously? Lou is up there in Baltimore. Lou would probably have the most information, not Baltimore, Boston, excuse me. Lou's up there in Boston and would probably have the most information about Karen Reed. Oh my gosh, y'all, Miss Lely's never heard of Karen Reed. Karen Reed has got to be, after YSL, probably the most high-profile trial. PIW, I'm watching it live right now. How is that? How are you watching it live? Let's see. Hit the live button. Here's the chat. You can see the chat from Law and Crime. The chat, the time on the chat mirrors the time that we have right now. Yeah, I'm on Law and Crime right now too. Isn't this day 5? It started streaming 4 hours ago. Are you talking about Karen Reed? Oh, you talking about Karen Reed, Slim Life? Oh, you're talking about Karen Reed. Okay. We're talking about two different things, is what it is. Okay, got you. Okay, I see what you're saying. Yeah, okay. I honestly, I couldn't even. We'll stick with this, but we will come to the Karen Reed and we'll go through all that and we'll see her motions. I see what you're saying. I thought you were talking about the current trial was live with the closing arguments, but you're talking about Karen Reed. My mistake. Yeah, so I wouldn't even, I mean, I haven't even been following Karen Reed in order to make sense of all the motions. So we'll get there. We'll get there when it's time. Unless y'all just want to pop over there and watch the motions for the moment until this kicks on. Guess we could do that. Because this one, who knows how long this is going to take. We can just get a sense for what it looks like in court and all that stuff. But even the Karen Reed looks like it's on a break or something. Let's see. All right. Well, let's just watch. I guess we'll just watch that for a while. Because we're still waiting for
Thank
that.
you very much.
We'll do a deep dive into Karen Reed.
I do. Good morning, Dr. Russell. Good morning. Okay, the defense is calling Dr. Russell as a witness. Jim, can I have the exhibits? Will counsel need the exhibits for examination of this witness, or can I have them with me and look at them?
Your Honor, whatever your preference is, we will abide by that. We may want to publish some at
Sure,
appropriate time.
that's no problem, but I can keep the notebook. That's not a problem.
Oh, yeah, that's intended for your use, Your Honor.
Okay, all right, thank you. All right, go right ahead, counsel.
Your Honor, if I may, a couple of matters before Dr. Russell testified, with Your Honor's permission.
Okay.
One will take 15 seconds and the other will take maybe 3 minutes.
Okay, is it something that Dr. Russell can remain in the courtroom for?
It is.
Okay.
And
Sure.
if at any point I'm incorrect in that assumption, I'm sure you will tell me.
Okay.
First of all, the first order is I want to thank the court for granting my permission.
All right, y'all, we
before the
have court. So
And I'll
just as we get started with this guy, we have this guy. So I'm going to just keep it here now.
2021 CR 8967. Mr. Palazzo is here with his attorneys, Ms. Jantz and Ms. Johnson, and the state Ms. George and Ms. Adams. I have sent what I consider the final version. I haven't looked at your email. Did you have any problems, Ms. Adams, with the jury form?
Not with the
I
verdict
saw
form.
that you
Nope.
sent it. Does the defense have any issues with the jury verdict form?
I just saw it, Judge.
All right, I'll go forward. I'm not going to deal with that now. I
That's fine. We can
don't
talk about
think
that.
you're likely to, so if you do, I don't think it'll take very long.
Yep.
Are the parties ready to proceed with closing arguments?
Yes, Judge.
Yes.
Okay. Let's bring in the jury.
She wants us to stay here all May. I'm going so nervous that perhaps I was like, I'm just going to stay for like 3 months. Somebody always said that. Oh, okay. So, do you want to go?
All right.
Please be seated. Good afternoon, everyone. I'll note the presence of all 16 members of the jury, and I'll ask my usual questions. Has anyone learned anything about this case outside of the courtroom since we adjourned yesterday from the proceedings? I am seeing 16 shakes of the head no. Did anybody read any accounts of this or discuss this case with anybody else since leaving the courtroom yesterday? Again, seeing shakes of the head no from all 16 members of the jury. It is now time for closing arguments. We'll start with the state. Ms. George.
Thank you, Judge. Good afternoon. In October of 2021, Mr. Ferlazzo and his wife, Emily, made a plan to come to Vermont for a weekend for their 1-year anniversary. You heard from Emily's mother that Emily was excited. She was looking forward to meeting her sister-in-law, Nicole. She was in a good mood and she was looking forward to the trip. They drove up here in their van with their dog from New Hampshire on the evening of Friday, October 15th of 2021. They arrived in Vermont at the Bear Run condos at 7:20 p.m. They parked at a condo complex on Bear Run in Bolton. They met with Nicole for about 15 minutes out in the parking lot inside the van with a plan for Mr. Ferlazzo and Emily to meet them inside the Airbnb to catch up, watch Netflix, and hang out. But they never did. And we know that Emily sent her last Facebook message to her family at 8:13 p.m. We know that Mr. Ferlazzo sent a text message to his sister Nicole inside the Airbnb at 9:39 p.m. Hey, we're going to take the night to rest, smiley face. You still drink coffee? We'll see you tomorrow morning. Shortly after, Emily's last location data from her Facebook is logged as 10:14 p.m. Instead of going inside and spending time with his sister, Mr. Ferlazzo and Emily argued. They argued because Mr. Ferlazzo had brought Emily on their 1-year anniversary to the very same condo complex that his ex-wife lived. They argued because Mr. Ferlazzo seemed to believe that he didn't have any obligations to be monogamous with his wife, be faithful to her, and she told him she was done. She told him she did not want to be with him, that she could not do it anymore, and that she wanted to leave. And 1 minute after midnight, Mr. Ferlazzo turns off his phone. Done arguing, Emily laid down in bed while Mr. Ferlazzo stayed up and stewed. He became enraged at Emily while she lay in bed scrolling on her phone with her head on her pillow. Mr. Ferlazzo sat on the couch thinking, planning. For what he told police was 5 to 10 minutes. For at least 5 minutes, Mr. Ferlazzo sits on the couch and stews. By this time, Mr. Ferlazzo has a plan. He's made a decision. He has decided that he needs to stop her, that she is not leaving him.
I don't even know. Like, I just know that I sat down and was. I don't know, something inside my head, just I remember feeling really warm, and I remember feeling blurry, and I don't know. Something inside me said enough is enough.
Something inside of him said, enough is enough. But instead of walking away from Emily, going into his sister's Airbnb, out of the van, instead he executes his plan. He got up from the couch. He went to the closet. He grabbed this Glock 19 with this silencer. He walked over to the bed. Emily's head was resting on this pillow. He picked up this throw pillow from the couch. He jumped onto the bed. He put this throw pillow over her face, and he shot her once and twice, directly into the left side of her head, killing her. Both of those bullets exited her skull on the right side of her head and came to rest inside the very pillow that her head was laying on.
When you jumped on her, did she say anything to you?
Something like, are you fucking kidding me? You gotta be fucking kidding me.
And did, what was her reaction to you?
It was just like that. Okay. Just jumped on her. She said, are you kidding me? You gotta be fucking kidding me.
Did she try to fight you or anything like that? And how long did it have to take? Was it between when you jumped on her and when you fired the first shot? And how about the second shot? So I don't want to put words in your mouth or anything. I'm just trying to understand. So essentially, correct me if I'm wrong, you jumped on her and bang bang like that. Is that how it happened?
And I think you shook your head no, but when Seth asked you if she tried to put up a fight, did you say yes or no? There was no fight? Okay.
The evidence presented in this trial shows that Emily posed no threat to Mr. Ferlazzo. And in fact, his story that she had a gun was directly contradicted by the fact that both of the pistols were his. Emily did not have a gun. His story that he remembers Emily's body falling after he killed her is directly contradicted by the physical and forensic evidence. Dr. Shapiro told you that her head was resting on something when she was killed. And immediately after killing her, rather than calling 911, any police agency, his ex-wife, or his sister, who was just yards away from him, Mr. Ferlazzo instead shuts off Emily's phone because, in his words, quote, he wasn't going to use it and she wasn't going to use it. After he shut off her phone, Mr. Ferlazzo puts a Market Basket shopping bag over Emily's head, tied a garbage bag around her neck, used his 6-foot, 200-pound body to carry her 5'1", 130-pound body into the shower. He bagged up this bloody pillow, bagged up this red throw pillow. He bagged up this bloody pillowcase, this bloody sheet. He then put her shoes, her glasses, her wallet, and her phone in a plastic grocery bag, but was careful to keep her ID. He put new sheets, a new blanket, and new pillows on the bed, and he turns his phone back on at 1:35 a.m. Then he turns it off at 2:10 and back on at 3:39 a.m. Then he gets back in the very bed he just killed his wife in. And just a few hours later at 7:48 a.m., while his wife's body is in his shower, he texts his sister, "I can't sleep. Any interest in going for breakfast?" And even makes a recommendation on where to go. "Maxie's has really good breakfast, exclamation point. I just French pressed some coffee. Have you had coffee yet?" And off they go to Maxie's, where Mr. Ferlazzo has eggs and a mimosa. Then he drives his van from Bolton to St. Albans, parks the van on the property of his best friend. And rather than telling them that Emily's in the van, that he killed her, that he had to kill her, he tells them she took off. And then he sets up shop and starts to give his sister a tattoo. But not before sending Emily's phone a text message. "Whatever," exclamation point and angry face. "I'm going to spend time with Nikki while I can," exclamation point. "Call me." And 3 hours later, he finishes his sister's tattoo. And an hour after that, he goes out to eat again, this time at Twigs, a gastropub in St. Albans. He eats dinner, he has drinks, and he gets a ride back to the Lang residence, and he again sleeps in the van with Emily's body still in the shower. And the next day, he goes out to Burlington with his sister, he gets coffee, and again, he goes out to eat. And again, he says nothing to Nicole about what he did to Emily. And after gallivanting around downtown, he heads back to St. Albans, and on his way, he stops at Hannaford to buy bleach. Because despite him continuing with his life as if nothing has happened, he does have a mess to clean up. That night, he hangs out with friends around a campfire. Two of his best friends and an off-duty police officer. He engages in small talk. Doesn't mention Emily once. Doesn't even mention that he has a wife, as if she just doesn't exist. You heard testimony that the campfire wraps up around midnight when Mr. Ferlazzo gets back into the van, and while Emily's body lays feet away from him, he sends her phone another text message. The same phone that he turned off after killing her because she wasn't going to need it, and the same phone he threw away somewhere between Bolton and St. Albans. "This is far enough!" Exclamation point, exclamation point. "Get your ass home!" Exclamation point. "I gotta go back to New Hampshire. Are you coming back?" And amongst all of these activities, he decides that he needs to make her body easier to carry, easier to move, and easier to discard. Mr. Ferlazzo uses this serrated saw and dismembers her arms, her legs, her feet, and her head. He dismembers them from her torso. The same torso, absolutely riddled with stab wounds, including one striking her heart. 3 different knives had her DNA on them. At least 3 different knives were used to stab her heart one time, her abdomen 8 times, and her back 9 times. Then he puts each piece of her body in garbage bags. And on Monday morning, before leaving for New Hampshire to get his Jeep, which he told you he needed in order to bury Emily's body in the woods, he just can't help himself. Knowing full well exactly where she is and what he has done to her, he texts her phone one last time. You're an asshole. I don't deserve this shit. You're an asshole. I don't deserve this shit. Ms. Adams told you in the state's opening statement that this case and this crime is about ego, Mr. Ferlazzo's ego, and Mr. Ferlazzo's nearly 42-year-old ego being unable to accept his 22-year-old wife disrespecting him. That ego believed it was his right to cheat on Emily, to have relationships with other women, whether she liked it or not. That same ego believed it was his right to follow Emily one day when she wore her hair a different way and he didn't think she was being truthful to him. That ego was so inflated that even after shooting his wife in the head 2 times, stabbing and dismembering her body, bagging her up and discarding her like trash, he didn't tell his sister because he didn't want to make a bad impression with her boyfriend. So inflated that he didn't tell his sister because he'd promised not to, quote, dump his drama on her. He considered killing his wife drama. An ego so inflated that after killing her, taking her life because he didn't like the things she was saying to him, because she didn't want to be with him anymore, he calls her an asshole. He tells her that he doesn't deserve this. The state submits that it is Emily, and only Emily, that did not deserve this. All of the credible evidence presented by the state during this trial, the witness statements, the physical evidence, the forensic evidence, was checked and verified. The details of her death, the details of the weekend, of the dismemberment, the trip back to New Hampshire was all corroborated, checked, verified, proven beyond a reasonable doubt. We are confident that you will find that Mr. Ferlazzo killed Emily and that that killing was unlawful. There was no legal justification for it. It was willful. It was intentional, it was deliberate, and it was premeditated. And the state requests that you find him guilty of first-degree murder.
Ms. Jantz.
Thank you, Judge. I do plan to make this copy because this is in my way. Don't need it. What I say to you now and what Attorney George just said to you is not evidence. We're just giving you our spin on what we hope that you will conclude after your deliberations. It's up to you and only you to decide what the evidence shows. Not what I say, not what she said. You are the finders of fact, not us. There's been some conflicting evidence in this case. Some undisputed evidence. You've seen the video of what Mr. Filazzo Joseph told the police on the day he was arrested and detained. You know that in that video, and as he told you yesterday, he hadn't slept for multiple days, hadn't eaten. He says multiple times, my mind is scrambled, I'm not thinking clearly. But there is a roughly 2.5 hour recorded statement of what he tells the police happened. One of your jobs is going to be to decide if that was the whole story. If he was able, because of lack of sleep, the events that had transpired over the weekend prevented him from being clear and rational. You heard him tell you yesterday he has no memory whatsoever of that interview. None. He said it was like watching himself if he'd been at a party and been blackout drunk. He's seen that video 3 times now. He told you yesterday that he was revolted by his apparent detachment in describing the events of what happened over that weekend. And you saw him on multiple occasions express emotion in talking and thinking and remembering what happened. The detachment that he described, his demeanor, is part of his habitual. He said he was a closed person, very private, didn't like to express his feelings. And it's something he learned from childhood, something he learned in the course of his work as a tattoo artist, how to compartmentalize feelings, emotions. He told you as a tattoo artist, he'd learned that because it hurts, you make small talk with people and distract them from the pain that they're experiencing. This is just habit for him. It comes across, as he described, as revolting detachment, but it's his way of coping. What he told you yesterday is not what he told the police. He explained to you that his memory of what happened ended at some point that weekend. He remembers the events now. He remembers the events leading up to him shooting Emily. He remembers some of the events of Saturday, what he did. He doesn't remember much, if anything, of Sunday, Monday, Tuesday. He told you that after he had had an opportunity to sleep for a couple of days, he came to and he started having nightmares and remembering things, bits and pieces. And even as he talked to you yesterday, he said his memory is fragmented, very fragmented. And he is struggling to understand what happened and why. What he told you yesterday is that over the course of their relationship, Emily had become physically abusive to him. The reasons the state would have you believe is that the state would have you believe that he's an egomaniac. It's up to you to decide if you saw any evidence of that in his demeanor or his testimony yesterday, that he shot her because she disrespected him. He told you clearly about how many times she had hit him with objects, with cell phone, with her fists, with a laptop, with a wine bottle, gave him a black eye once, and he never hit her back. He said, I would take her arms and restrain her. Until she calmed down and say, we don't hit, we don't hit. They even went to a counselor together to address issues in their relationship. He said, I grew up with domestic violence and I didn't want to bring a child into a relationship like that. That was his experience of interacting with Emily when she became frustrated and acted out physically against him. He told you that that weekend they were coming up here to see his sister and to celebrate their anniversary. They got here, they were both happy to be coming, both excited, and on a dime, she flipped. I don't want to be here. F you, F your family. I'm done. He's not denying that he sent texts to his sister. He's not denying much of what the state's evidence shows. He knows that and told you, yeah, I lied. I lied because I didn't want to I didn't want to tell my sister because you may or may not agree with his explanation. She didn't want his drama in her life. You heard the state say killing his wife was drama. Well, you have to put yourself in his shoes and his thinking. But in any case, that was his explanation for why he didn't tell Nikki about what he had done, that is shooting his wife in the head. So that weekend they come up, they get into an argument. He told you clearly that she had been muttering and angry, and when he put on the candles, she was angry about that, and she picked up one of the candles and started hitting him. Hit him in the head, hit him in the arms, hit him in the torso, kicked him in the groin. He was able to stop that attack. He took the candle away from her, and then he took their dog out, Remy. It was raining. They went out for a walk. He had also told you earlier that he thought he saw coyotes and was afraid potentially about bears. And that's why he told her, get your Taurus and keep your peace with you. And he kept his Glock with him. There's no dispute that the guns were his. That doesn't mean she didn't use it. He said she preferred the Taurus because the barrel was shorter, or the handle. He used the Glock. That was hers, that was his. Legal ownership is not the issue. So they both had access to their guns that night. He comes back in from walking the dog. She's on the bed, scrolling through her phone, muttering, and he pours himself a drink, one of many that he had that night, many. Vodka and Red Bull. At some point, so he dries the dog off, dries himself off, and at some point decides, okay, now I'm going to get into bed. In order to do that, he has to climb across Emily. Emily says something, fuck you, something like that. He picks up the red pillow, which was right on the little couch they had next to the bed, and this pillow, swats her in the head with it. She turns to him and says, that's it, you're dead. That's it, you're dead. She elbows him in the groin. I had that backwards. First, she elbowed him in the groin. Then he picked up the pillow and swatted her. Then he saw, and she said, that's it, you're dead. He saw her start to pick up the gun and shoot him. And you heard him tell you, I was terrified. I knew she was going to shoot me. That was his belief based on circumstances of that evening, what she said to him, the history of their relationship. He truly believed that she was going to shoot him and that he had to shoot her with the Glock that was already in his hand in order to save his own life. That's what he told you yesterday. It's not what he told the police, but that's what he now remembers happening. He also told you, I felt a wave. This he did tell the police. I felt a wave come over me. I was hot. I couldn't take it anymore. I felt blurry, loss of focus. All of that contributed to his decision, and it was a decision to shoot her. Then what? Then what happens? Well, he has some memory of sitting beside her body. He's told you a couple of times, I was talking to her at various points over the next couple of days. This is a man who was somewhat, if not heavily intoxicated, also smoking marijuana, just experienced a trauma, and is grasping, what do I do now? What do I do? When he talked to you about this, you saw him break down and become emotional and cry. This is not someone who is a cold-blooded murderer. He cared about his wife. You heard him describe their early relationship as euphoric and magnetic. He was in love with her. He kept telling her, this is not how we treat each other. You don't hit people. But on this night, he truly believed that she was going to shoot him. And that's why he shot her. So over the course of the rest of that night and into Saturday, he made attempts to prevent anyone knowing what had happened to Emily. He doesn't deny sending some of those texts. Some of them he doesn't remember. Some of them he does. And he told you, I lied. I know I lied from what he can remember. He was intending to try and go back to Pennsylvania to help his grandmother. You can decide whether or not you think that was a good enough reason for what he did, but that was how he was thinking at the time. He also said, I wanted to give her a burial. He has no recollection of stabbing her. None. None. The medical examiner told you there's no way of knowing when those injuries were inflicted, except that they were not immediately following death. Similarly, the dismemberment, they also were not immediately following her death. This is not an easy case because on the one hand, you have verifiable evidence of what happened. But what you don't have is the why. Mr. Ferlazzo gave you the why yesterday. He explained why he did what he did. Your biggest job is going to be to decide, is he lying now just to get away with it? Is what he told the police in that interview the whole truth? He told you he has only partial memory of the events that followed, and he admits, I shot her. He knows, he's admitting that. That's not what this case is about. This case is about why did he shoot her? Ego, or someone who had been pushed to the point where they could no longer tolerate being hit. And I know, he's big, a man, 20 years older. She was a little girl. You heard him tell you that she hit him and hurt him each time. She hit him with a bottle, hit him in the head with a wine bottle, hit him in the head with a big Yankee Candle. That hurts. You can do that however small or the discrepancy in your size. And he didn't hit her back. Not once. The judge is going to instruct you on the rules of the law in this case, and it's not my job to do that. Your job is to assess what you heard him say yesterday, how he appeared, what you think about whether he's lying or not. That's your job. I don't envy you because I think it's a hard job, but that's what you will be asked to do. What do you believe is the truth? What he told you yesterday or what he said to the police? I think that you will find him not guilty of first-degree murder and acquit him on the grounds of self-defense. Thank you.
Ms. George, do you have a final summation?
Mr. Ferlazzo claims that he doesn't remember what he told police, that he doesn't remember being in the interview with police, and that he doesn't remember much of the night he killed her, and that his memories were not full at the time and are still fragmented. Luckily for Mr. Ferlazzo and for all of us, every single word that Mr. Ferlazzo said to the police about what happened to Emily was recorded. The reason that Trooper Cody turned on his body camera when he called Mr. Ferlazzo. The reason that Detective Voris did the interview in a room equipped with video and audio. The reason that Detective Voris made sure to have an extra recorder on his body when he went into different places, went to the breaks, went to the holding cell, just in case. The reason was all to make sure that everything Mr. Ferlazzo said about what happened to Emily was recorded and that we would all be able to refresh his memory. You all heard every word that he said to the police just days after he killed Emily. We played you every video, every recording. You have the transcripts. There are no secrets here about what was said or done. There are no mysteries. And immediately after signing the Miranda warning with Detective Voris, Joseph was ready to talk.
All right. So Joe, is it fair to say that you have an idea of what we want to talk about? Yeah. All right. I'm here to talk to you. Like, you don't have to beat around the bush. Okay. I'm sure you already talked to Spencer. I fucked up. Like I said, like I had a fucking lapse and did something that I can't undo. So here we are.
And less than 2 minutes after that,
So I came to Vermont. I was living in New Hampshire for like the last 2 months with my wife and her family. And I came to Vermont. We were supposed to have like a weekend away, like vacation, do some camping, like have some fun. And like as soon as I like put the vehicle in park, like my wife went completely berserk, like completely psychotic. And I shot her. That's first close to that. And now here we are. you know about what time? Saturday evening? No, no. Saturday morning. I think I was thinking. It was like, yeah, it was Saturday morning.
The state believes that the interview, the recordings, and the transcripts of the same all show that Mr. Ferlazzo was ready, he was willing, and he was able to give a coherent, a voluntary statement. You saw for yourself how he interacted with police throughout this interview, and you saw for yourself how he presented on the stand. You heard him outline in the interview with police in great detail what led up to shooting Emily twice in the head, and never, not once, did he say that Emily was a threat to him, that she had a gun, that he thought she was going to kill him. In fact, what you heard him say repeatedly when asked multiple times was that she had stopped fighting.
Can you describe Emily when you shot her? Like, what was she doing? She had stopped fighting and she had gone and laid down. And then jumped on top of her. And I shot her. How many times? Two.
She had stopped fighting, she had gone and laid down. I went and jumped on her and I shot her in the head. The physical and forensic evidence shows that Mr. Ferlazzo did not act in self-defense. Just days later, he had no injuries, no bumps, no lumps, no bruises, no scratches, no burn marks from this alleged burning candle that was wrestled over during this interaction that he testified to yesterday. The physical and forensic evidence shows that this was willful, that he intended to do it. His actions were deliberate. They were not provoked under any circumstances, and they were premeditated. He planned to kill her during that 5 minutes, and he executed that plan. Mr. Ferlazzo's statement to police is detailed, it's thoughtful, it's thorough. At times you see him correct himself if he gets a detail wrong. He goes out of his way to correct it with police. He's given opportunities to warm up, to sleep, to eat, to drink, to smoke. He was given numerous breaks. He had time to contemplate and correct inaccuracies, fill in the details when police asked for them.
And while this was, while she was in bed, where were you when I was sitting right here on this little couch, the right couch on that. Sure. I think we had asked where the Glock was currently, but where did you get it from? It was in the closet. Where's the closet? This is the closet. Okay. I was on the couch. Okay. I just like got up and grabbed it and shot it.
At no point during his statement does he ever say anything about Emily being a threat to him. At numerous points, you heard him talk about the feeling that he had before he did it, that he felt warm, and he specifically described that feeling as rage, how he wanted to stop her, and how he made a decision to do that.
I remember sitting there on the couch, just trying to like, it was raining. remember I was just watching the rain. It was like, when I was on vacation, and I was just trying to enjoy myself and stay out of the rain. And I just kept trying to relax, and she just kept trying to unfurl my face. And then it was just like, I just felt this weight come over me.
What did that make you feel like? You talked about it before, like you felt like a warm sensation in your body.
I think it was loss of focus, rage, heat.
Were you feeling angry or were you feeling sad or how were you feeling?
Pushed, fed up.
Pushed and fed up. In defense counsel's arguments, they said that it will be up to you to determine whether or not Mr. Filazzo on the stand yesterday was telling the truth or if he was lying to get away with it. Making up a story now to get away with it. That will be up for you to decide. But the state would just highlight that Mr. Filazzo testified to a history of abuse, being assaulted by Emily numerous times, having black eyes, bumps, bruises. But not a single witness got on the stand during this trial and corroborated any of that. No friends that they lived with or hung out with saw any of this alleged abuse. Nobody saw these bruises. The only witness that got on the stand and testified to seeing bruises was Adrienne Bass, Emily's mother, who testified that Emily had bruises on her, who said that Joseph was taunting Emily while they were driving once, so much so, and poking at her so much so that Adrienne feared for their safety. Adrienne told you that at that New Year's Eve event, Emily called her on the phone and she had locked herself in a bathroom and Adrienne could hear Mr. Filazzo yelling at her on the other side. That's the evidence that you heard. Further, again, Mr. Filazzo testified that Emily had a gun, a detail never mentioned until this trial. The detail that Mr. Filazzo now says he left out of his interview with police, the reason, the why he killed Emily, arguably the most important detail for a self-defense claim, the most important detail that most people would have led with, is now the detail that he wants you to believe over everything else. He wants you to believe that detail so much that you acquit him of this crime. But not so important that he didn't tell his sister, he didn't tell his best friend, he didn't tell the police. Specifically, he didn't tell Trooper Cody, he didn't tell Detective Voris, he didn't tell Detective Richardson, he didn't tell Detective Truex, he didn't tell Detective Nolan. A detail so important that he only knows this detail exists because it came to him in flashbacks. This is not a flashback. This is not a merry-go-round. This is reality. And in reality, there is not a single piece of evidence to corroborate this one detail. The truth in this case is not complicated. The truth is simple. I fucked up. I made a mess. I cleaned it up. We believe that the evidence shows beyond a reasonable doubt that Mr. Filazzo killed Emily and that he did so willfully, that he did so intentionally, that he did not do so in self-defense, that it was deliberate and it was premeditated. And we ask that you find him guilty of first-degree murder.
Judge, may we approach, please?
Folks need a break, or are we ready to hand out?
No, because I had sent the court something,
We have one last detail to deal with, then we'll bring it in quickly and go into the closing jury instructions, and then you'll get the case. Okay, but we'll take a quick break.
All right.
The pages have changed.
I see that. So, and it would be a lot easier if I had the hard copy, or if I could look at a hard copy.
We have 21 of them, are on there.
You can sit down.
So is that it?
Oh, please, everyone sit down.
He's about to run for it. I wouldn't be surprised if Cuz ran for it. Probably be a better idea than. But what now, jury? They have enough time to do jury instructions still. They probably go ahead and do the jury instructions now.
Okay, now I know where are you ready?
That's what I was saying yesterday.
12, first paragraph.
Well,
So as it now reads, to find Mr. Filazzo guilty of first-degree murder, you must find beyond a reasonable doubt the killing was not done under great provocation or sudden passion that would cause a reasonable person to lose self-control and act without thinking, as further defined in the remainder of the charge.
right, we already dealt with that, I thought.
Okay, no, I think that's fine.
Okay.
Okay. I still am asking, I did object.
Yeah, you've got, I mean, unless you want to repeat it.
No.
You objected that you wanted the full.
Well,
thing that's repeated under second degree, repeat under first, I think is what you said.
so I do object for the reasons stated, and I also object to the language of reasonable doubt.
Okay. Are we ready for the jury? Can't promise to move.
Oh, I thought we were taking a break because he's not here.
Oh, he's not here. Okay, we're not ready.
Yeah.
Yeah, you can do that.
Dang. So short break, jury instructions. Yo, you could get a verdict from this today. If they come back, let's say they come back at 2:30, 2:45. It takes an hour to give jury instructions max. I'm only saying max because, you know, you don't have a whole bunch of instructions. Then deliberations, yeah. Then they'll go into deliberations, which could be, shoot, they could come back in 2 hours. You know, they might just get in there and say, let's take a vote. Who thinks he's guilty? Everybody. All right. We'll wait in here a few minutes and act like we were doing something. And then it's time for him to go to jail. So yeah, jury instructions. I'll let me see. I always like to have something playing. So we'll just play the last few minutes of this lady. I guess this is the prosecutor. Y'all want to see his lawyer again?
Is that the state would have you believe that he's an egomaniac. It's up to you to decide if you saw any evidence of that in his.
What? I was busy, y'all, so I didn't really get to see. The state would have you believe that he's an egomaniac. I mean, you just make your own decision. Like, she's not even going to say, no, he wasn't. Oh, my gosh.
Demeanor's testimony yesterday that he shot her because she disrespected him. He told you clearly about how many times she had hit him with objects, with cell phone, with her fists, with a laptop, with a wine bottle, gave him a black eye once. And he never hit her back. He said, I would take her arms and restrain her. Until she calmed down and say, we don't hit, we don't hit. They even went to a counselor together to address issues in their relationship. He said, I grew up with domestic violence and I didn't want to bring a child into a relationship like that. That was his experience of interacting with Emily when she became frustrated and acted out physically against him. He told you that that weekend they were coming up here to see his sister and to celebrate their anniversary. They got here, they were both happy to be coming, both excited, and on a dime, she flipped. I don't want to be here. F you, F your family. I'm done. He's not denying that he sent texts to his sister. He's not denying much of what the state's evidence shows. He knows that and told you, yeah, I lied. I lied because I didn't want to I didn't want to tell my sister because you may or may not agree with his explanation.
All right, looks like we're back.
She did.
No sound yet, though. Let me see. I can't imagine that they're going to deliberate more than just, I mean, he guilty, but I wouldn't had let her try my case. Nah, I mean, you have to understand that the way he acted on the stand would at least be in part due to the coaching that she gave him. So while I saw him on the stand, I'm like, this guy was not prepared properly, or he was just totally incapable of doing what he was supposed to do. Because no way he should have got up there and said that stuff. No way he should have gotten up there and said what he said. His lawyer definitely did not look like she was ready to. I mean, she wasn't ready to defend him herself. If you want a jury, what would you vote? First degree intentional. I want to hear. We got to hear what the jury instructions are. So I do have the sound on, right? Yeah, sound is up. They just don't have any sound in court. I'm not convinced that he I have to hear the jury instructions before I can answer that question. I'm not sure yet what first degree intentional or what have you, or what they're going to say. Based on the jury instructions, I can say. Did he plan he was just going to go in there and kill her? If she was asleep, if the evidence is that she was still asleep, then it's hard to say that it could have been anything but that. Because frankly, if she was already asleep, then they couldn't have had like an argument first or what have you, right? So I would say if the evidence says she was asleep when he killed her, then it would have to be first degree. Premeditated murder. So let's listen to the jury instructions to see how the judge explains each charge. I agree with you, Dis. He shouldn't have gotten up there. I don't know. Do I think he brought her up there just to kill her? I never thought about that till you just asked the question. Yeah, why don't we have any sound? Can y'all hear anything?
And yeah, you can consider a jury.
All right, the sound is on, but yeah.
I agree, but
So why don't we do this? I won't send in initially. I'd rather get the jury started, and we'll get them. But I'm not inclined to put anything about passion or any of that. They've had those instructions. Each one is getting a copy of the instructions. They're taking it with them to the jury room. They'll have the definitions in there.
I just thought it was confusing because it's inconsistent with the instructions.
I don't think it's inconsistent. I think it just doesn't repeat the instructions.
Well, because your instruction is on page 12 that in order to find the guilty, killing is not done under the provocation, etc. And that's not in the other form.
Why don't you bring in your jury?
Just
I wonder. Great.
The sound in there is crazy bad.
All ayes.
Please be seated. Ladies and gentlemen, it's now time that I read jury instructions to you. You'll note that each of you has a copy of the jury instructions. You're free to read along with me. I'll be saying them out loud, so if you prefer just to listen, you can do that. But if it's helpful to read along, that's fine too. You'll be able to take a copy of these instructions into the jury room with you when you begin your deliberations. Members of the jury, now that you've heard the evidence and the arguments, I must instruct you on the law that applies to this case. You must follow the laws stated in these instructions. You must determine the facts based on the evidence that is presented in the case, and you must apply the law that I give you in these instructions. You must not single out any one instruction as stating the law. You must consider the instructions as a whole. You should not concern yourself with the wisdom of any rule of law or any opinion you might have about what the law should be. You may not base your verdict on bias, prejudice, or sympathy. Do not consider consequences. In your deliberations, you are not to consider what happens after your verdict. Under Vermont law, all matters after the verdict are solely the responsibility of the court. The charge. The state has charged Joseph Filazzo with first-degree murder of Emily Filazzo as follows. That Joseph Filazzo in the county of Chittenden at Bolton on or about October 16, 2021, willfully, deliberately, with premeditation, with intent to kill, unlawfully killed a person, to wit, Emily Filazzo, by shooting her twice in the head. Mr. Filazzo has pleaded not guilty to the charge. On or about. You will note that the charge alleges that the offense was committed on or about October 16, 2021. The proof need not establish with certainty the exact date of the alleged offense. It is sufficient evidence in the case proves beyond a reasonable doubt that the offense was committed within the period of the date alleged. The charge is not evidence. The fact that Mr. Filazzo is on trial is not evidence against him. Likewise, the charge that the state has filed is not evidence of Mr. Filazzo's guilt. You are not to be influenced by the fact that the state has brought this charge against him. The burden is on the state to prove that Mr. Filazzo is guilty. Presumption of innocence. Mr. Filazzo is presumed to be innocent of the charge. This is called the presumption of innocence. Although Mr. Filazzo is accused, he is innocent at the beginning of the trial. This presumption of innocence stays with him throughout the trial and during your deliberations. The presumption is itself a piece of evidence which you should consider in Mr. Filazzo's favor in deciding whether to find him guilty or not guilty. The presumption of innocence means that you must find Mr. Filazzo not guilty unless, after careful and impartial consideration of all the evidence, you are satisfied beyond a reasonable doubt that he is guilty. Evidence. Your duty is to determine the facts from the evidence. The evidence is the oral testimony of the witnesses and the exhibits which have been introduced into evidence. Any testimony which I have stricken from the record or excluded from the case is not evidence, and the comments and arguments of the attorneys are not evidence. Furthermore, I do not intend to indicate one way or another as to how you should decide this case based on my rulings I have made or anything I have said. The attorneys have a duty to object to questions or answers which they believe are not admissible. You may not hold it against either side. if an attorney feels it is necessary to make objections. Circumstantial evidence. There are two types of evidence from which you may find the facts of this case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances which may tend to prove or disprove an issue in the case. For example, if a witness were to tell you that he or she had seen fresh cow tracks in a field, the observations of a witness would be direct evidence, which, if believed, would point to the presence of cow or cows on that property. This inference to be drawn from the observations would be circumstantial evidence that there were cows on that property. The law does not require that Mr. Filazzo's guilt be established by direct evidence alone, that is, by testimony of someone who actually saw Mr. Filazzo commit the alleged act or offense. One or more of the essential elements, or all of the essential elements, may be established by reasonable inference from other facts which are established by direct evidence testimony. Circumstantial evidence alone may be sufficient proof of the commission of a crime upon which to find a defendant guilty. The law makes no distinction between the weight to be given to direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should consider all of the evidence in the case and give it such weight as you think it deserves. Credibility of witnesses. You are the sole judges of the evidence. The credibility of the witnesses and the weight to be given to the testimony of each of them is up to you. In considering the testimony of any witness, you may take into account their ability and opportunity to observe, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the testimony of the witness considered in the light of all the evidence in the case. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. Two or more persons witnessing an incident or transaction might see it or hear it differently. In weighing the effect of a discrepancy, consider whether it pertains to a matter of importance or to an unimportant detail. You may believe all the testimony of any witness, believe it in part and disbelieve it in part, or you may reject it altogether. You do not have to accept the testimony of any witness, even if it is uncontradicted. It is for you to say what you will believe and what you will disbelieve. Credibility of witnesses, police officers. In this case, you have heard testimony from police officers. You should consider such testimony in the same way that you consider any other testimony in the case. In evaluating the officer's credibility, you should use the same law you apply to the testimony of any other witness. As with any other witness, you may consider the officer's testimony in light of their training and experience. You should not give either greater or lesser weight to the testimony of a witness merely because the witness is a police officer. Expert witnesses. You have heard testimony from expert witnesses. An expert is a witness who has extra knowledge, skill, experience, training, or education about a particular subject. The value of an opinion given by an expert witness depends on their ability and upon the facts they use as the basis of their opinion. If the facts used by the expert are proven by the evidence, and if the expert is highly qualified, and if they are impartial, then their opinion may be of great value. On the other hand, if the expert's opinion is based upon one or more facts that are not supported by the evidence, or if the expert is biased or not qualified, then their testimony may be of little or no value. As with any other witness, you may accept all or part or none of the expert's testimony. You may give the expert's testimony whatever weight you think it deserves and consider it together with all other evidence. Defendant as witness. Mr. Palazzo has taken the stand and testified in this case. He has the right to testify if he decides to do so. You are to weigh his testimony the same way you weigh the testimony of any other witness. Defendant's statement. You heard testimony and viewed evidence that Mr. Palazzo made statements to Detective James Boris concerning the incident involved in this case. You must determine whether Mr. Palazzo made those statements and whether he made them voluntarily. Before you may consider any alleged confession, you must find that the state has proven beyond a reasonable doubt that the confession was voluntary. In other words, that it was the product of a free and deliberate choice rather than coercion or improper inducement. In assessing voluntariness, you should consider the totality of the circumstances under which the statements were made. You may consider such factors as the location, the other persons present, Mr. Palazzo's emotional state, and his personal characteristics. You may consider the statements to be voluntary if they were the product of Mr. Palazzo's free and rational choice. If you find that Mr. Palazzo's statements were not voluntary, then you may not consider them at all during your deliberations. If you determine beyond a reasonable doubt that Mr. Palazzo's statements were voluntary, then you should give them whatever weight as you think they deserve under the circumstances. Number of witnesses. The fact that one side may have called more witnesses than the other side is of no significance. Your task is to evaluate the credibility of the witnesses and to weigh all of the evidence. Exhibits. The exhibits which have been introduced are evidence, along with the testimony for your consideration. The court officer will take the exhibits to the jury room, and you may examine them in your deliberations. When you reach a verdict, you should return the exhibits to the court officer. Two kinds of exhibits, the magazine and live ammunition exhibit, and also the video and audio recordings, including Mr. Palazzo's recorded statements and the PowerPoint of the geolocation evidence, will not be in the jury room. To view these exhibits, please give a note to the court officer, and they will be played for you or viewed by you in the courtroom. Stipulation of fact. The state and Mr. Palazzo have agreed that you may find certain facts. These are called stipulations of fact and have been admitted as exhibits. As with any evidence in this trial, you must decide what weight you will give these stipulations. Use of electronic devices. Your verdict must be based solely on the evidence admitted during the trial. During your deliberations, you must not seek any information about this case from any outside source, including but not limited to television, newspaper, radio, cell phones, iPhones, smartphones, social networking sites, or any site on the internet. You also must not communicate by any means about your deliberations with anyone who is not a fellow juror. This includes tweeting, texting, blogging, emailing, posting information on a social networking site or other website, or any other means of communication at all. Juror note-taking. During this trial, you have been provided with pen and paper, and some of you have taken notes. As I explained at the beginning of the trial, all jurors should be given equal attention during the deliberations regarding of whether or not they have taken notes, regardless, of whether or not they have taken notes. Any notes you have taken may only be used to refresh your memory during deliberations. You may not use your notes as authority to persuade your fellow jurors as to what a witness did or did not say. In your deliberations, you must rely upon your collective memory of the evidence in deciding the facts of the case. If there is any difference between your memory of the evidence and your notes, you may ask that the record of the proceedings be read back. If a difference still exists, the record must prevail over your notes. Personal knowledge or experience of juror. In deliberating upon your verdict, you are not expected to put aside matters of common knowledge or your own observations or experience of the general affairs of life. You may use matters of common knowledge or personal observations or experience to evaluate the evidence presented at trial. You may use the knowledge and experience which you possess in weighing evidence and testing its credibility. However, a juror having special knowledge of a subject may neither state this knowledge to fellow jurors nor act upon it themselves in arriving at a verdict. You must not tell your fellow jurors about matters which are based on special knowledge concerning an issue in the case on trial, which did not come from the evidence received in the courtroom in this case. Burden of proof. The state bears the burden of proving Mr. Palazzo's guilt beyond a reasonable doubt. This means that the state must prove each of the essential elements of the charge beyond a reasonable doubt. This burden of proof remains on the state throughout the trial and never shifts to Mr. Palazzo. Mr. Palazzo does not have to prove that he is innocent. He is not required to call any witnesses or to present any evidence or to testify in his own behalf. Reasonable doubt. The state's burden is to prove Mr. Palazzo's guilt beyond a reasonable doubt. There is no precise definition of reasonable doubt. The state does not have to prove guilt beyond all possible doubt. A reasonable doubt is a doubt based on reason and common sense, which comes from a fair and rational consideration of the evidence or the lack of evidence in the case. It is not a vague, speculative, or imaginary doubt. Mr. Palazzo may not be convicted based on suspicion or conjecture. If you have a reasonable doubt, you must find Mr. Palazzo not guilty, even if you think that the charge is probably true. If after you have considered all the evidence and these instructions, you have a reasonable doubt about Mr. Palazzo's guilt, then you must find him not guilty. On the other hand, if you are convinced of Mr. Palazzo's guilt beyond a reasonable doubt, then you must find him guilty. Essential elements of the charged crime. Again, the state has charged Mr. Palazzo with first-degree murder as follows. Joseph Palazzo in the county of Chittenden at Bolton on or about October 16th, 2021, willfully, deliberately, with premeditation, and with intent to kill, unlawfully killed a person, to wit, Emily Palazzo, by shooting her twice in the head. Every crime is made up of essential elements. Before Mr. Palazzo can be found guilty of the charge, the state must have proven each of the essential elements beyond a reasonable doubt. In this case, the essential elements are that on the date and at the place alleged, one, Joseph Palazzo; two, caused the death of Emily Palazzo; three, the killing was unlawful; four, Mr. Palazzo's killing of Ms. Palazzo was willful; five, his killing of Ms. Palazzo was deliberate; and six, his killing of Ms. Palazzo was premeditated. The first element is that Joseph Palazzo is the person who committed the alleged acts. The second essential element is that Mr. Palazzo caused the death of Emily Palazzo. The state must have proven that Mr. Palazzo's acts produced Ms. Palazzo's death in a natural and continuous sequence, unbroken by any efficient intervening cause. You must conclude that Ms. Palazzo's life ended by means other than natural causes, accident, or suicide. You must also conclude that, but for Mr. Palazzo's acts, Ms. Palazzo's death would not have occurred. Here, the state alleges that Joseph Palazzo caused the death of Emily Palazzo by shooting her twice in the head. The third essential element is that the killing was unlawful. The term unlawful killing means that Ms. Palazzo was killed without legal excuse or legal justification. Legal excuse or justification ordinarily refers to such things as self-defense or legal necessity. A killing may be justified where a person acts in self-defense. Here, the state must have proven that Mr. Palazzo did not act in self-defense. The fourth, fifth, and sixth essential elements require the state to have proven that Mr. Palazzo's killing of Ms. Palazzo was willful, deliberate, and premeditated. The mental state or intent with which a person does an act may be shown by the way in which they express it to others or by their conduct. In determining Mr. Filazzo's mental state or intent, you should consider all of the surrounding facts and circumstances established by the evidence. The fourth essential element is that Mr. Filazzo's killing of Ms. Filazzo was willful. A willful act is one which is knowing and intentional. You may find that the killing was willful if Mr. Filazzo killed Ms. Filazzo on purpose and not accidentally, carelessly, or unintentionally. The fifth essential element is that Mr. Filazzo's killing of Ms. Filazzo was deliberate. An act is deliberate if it is carefully considered. Mr. Filazzo must not have acted out of sudden impulse, but rather after deliberating for a period of time, however long or short. Deliberation is the act of thinking about and considering the reasons for and against an act or course of conduct. A person may think about killing over a period of months or over a period of seconds. Either period of time may be enough. The issue is the extent and quality of the deliberation, not its duration. Although also it is not enough to show that Mr. Filazzo had enough time to deliberate, the state must have proven that he actually thought about killing Ms. Filazzo before he did it. The last essential element is that Mr. Filazzo's killing of Ms. Filazzo was premeditated. A killing is premeditated if the actor thinks about it and plans it for some period of time before acting. Premeditation differs from deliberation in that it involves planning how to do an act, in addition to thinking about whether or not to do it. No specific amount of time is required. As with deliberation, a person may plan a killing over a period of months or over a period of seconds. Both may be premeditation. The issue is the extent and quality of the premeditation, not its duration. Again, it is not enough to show that there was enough time for premeditation. The state must have proven that Mr. Filazzo actually thought about killing Ms. Filazzo and planned it before he did it. To find Mr. Filazzo guilty of first-degree murder, you must find beyond a reasonable doubt that the killing was not done under great provocation or sudden passion that would cause a reasonable person to lose self-control and act without thinking, and as further defined in the remainder of the charge. The state bears the burden of proving all of the essential elements. If the state has not proven each of the essential elements of the charge beyond a reasonable doubt, then you must find Mr. Filazzo not guilty of first-degree murder. However, if the state has proven all of the essential elements beyond a reasonable doubt, you must return a verdict of guilty. Self-defense. Evidence has been introduced bearing on the issue of self-defense as justification for the use of deadly force by Mr. Filazzo. The state bears the burden of proving that the use of deadly force was unlawful. A use of deadly force committed in lawful self-defense is lawful and not a crime. Here, the state must have proven beyond a reasonable doubt that Mr. Filazzo did not act in self-defense. He has no burden of proof on this issue. A person has the right to defend himself when he is attacked or when he reasonably believes he is in imminent danger of being killed or suffering great bodily harm. A person in that situation has the right to use only such force as is reasonably necessary to repel the attack or the perceived imminent danger. A use of deadly force is justified by self-defense if, 1, Mr. Filazzo reasonably believed that he was in imminent danger of being killed or of suffering great bodily harm, and, 2, Mr. Filazzo's use of deadly force was reasonably necessary to repel the perceived threat. The right of self-defense does not require that the person actually be assaulted, but Mr. Filazzo must have believed that he was in imminent danger of great bodily harm, and his belief must have been reasonable under the circumstances. His expectation of harm must have been based upon fact and not on some imaginary fear. Furthermore, if he honestly and reasonably believed it was immediately necessary to use deadly force to protect himself from an imminent threat of death or serious bodily injury, the law does not require him to retreat. Self-defense requires that Mr. Filazzo must have had a reasonable fear of imminent harm. In deciding this issue, must consider what he knew about Ms. Filazzo at the time. You may consider their relationship history, including any aggressive or hostile acts by Ms. Filazzo, and any other evidence you consider relevant, including who started the confrontation. When assessing the reasonableness of Mr. Filazzo's fear, you may consider the individual characteristics of Mr. Filazzo and Ms. Filazzo, such as their respective size, gender, age, physical condition, strength, stamina, courage, and assertiveness. Self-defense permits only the amount of force that is reasonably necessary to repel the perceived harm. A person may use the amount of force that reasonably appears to be necessary under all of the circumstances known to them at the time. In this case, you must decide whether Mr. Filazzo reasonably believed it was necessary to use the amount of force that he did use. When a person has reasonable grounds to believe that an assault is imminent, he need not wait until it actually occurs before he may resort to self-defense. Once the issue of self-defense appears in the case, the burden is on the state to prove beyond a reasonable doubt that Mr. Filazzo did not act in self-defense or that the force used by Mr. Filazzo was excessive under the circumstances. Mr. Filazzo is not required to prove that he acted in self-defense. Again, all of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of first-degree murder beyond a reasonable doubt, then you will be done with your deliberations, and you must return a verdict that Mr. Filazzo is guilty of first-degree murder. Self-defense and lesser included offenses. If you conclude that the state has failed to prove beyond a reasonable doubt that Mr. Filazzo did not act in self-defense in the killing of Ms. Filazzo, then he acted lawfully and cannot be found guilty of any lesser included offense, and your deliberations are over. If you decide that the state has not proven each of the essential elements of first-degree murder, then you must consider whether Mr. Filazzo is guilty of one of the lesser offenses, or if you are unable to agree upon a verdict concerning the charge of first-degree murder, after all reasonable efforts to reach a unanimous verdict, then you may move on to consider the lesser offenses. Lesser included offenses. The lesser included offenses to first-degree murder are second-degree murder and voluntary manslaughter. There is no involuntary manslaughter in this case. The first three elements for all of the lesser offenses are the same as the first three elements for first-degree murder. Namely, the state must have proven that Mr. Filazzo, one, that it was Mr. Joseph Filazzo, two, caused the death of Emily Filazzo, and three, the killing was unlawful. However, for lesser offenses, the state need not have proven that the killing was willful, deliberate, and premeditated. The mental states are different for each of the, and again, that's an error of the two lesser offenses. As you consider the mental state of the lesser offenses, you must also consider whether Mr. Filazzo's mental state was influenced by extenuating circumstances, such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. Second-degree murder. The first lesser offense for you to consider is second-degree murder. If you reach the point of deciding whether or not the state has proven the lesser crime of second-degree murder, you must consider whether the state has proven the following essential elements beyond a reasonable doubt. That on the date alleged and at the place alleged, one, Joseph Filazzo, two, caused the death of Emily Filazzo, three, the killing was unlawful, four, in causing the death of Ms. Filazzo, Mr. Filazzo acted with an intent to kill or an intent to do great bodily harm, or a wanton disregard of the likelihood that the death or great bodily harm would result. And 5, when he caused the death of Ms. Palazzo, Mr. Palazzo's mental state was not influenced by extenuating circumstances such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. The first 3 elements are defined in the same way as they are for first-degree murder. The 4th essential element of second-degree murder is that in causing the death of Ms. Filazzo, Mr. Filazzo acted with 1, an intent to kill, or 2, an intent to do great bodily harm, or 3, a wanton disregard of the likelihood that death or great bodily harm would result. As you consider Mr. Filazzo's mental state at the time of the killing, you should consider all of the facts and circumstances. And you must decide whether the state has proven that Mr. Filazzo acted with at least one of the 3 mental states. A person acts intentionally if he or she acts purposely and not inadvertently because of mistake or by accident. You may find that Mr. Filazzo acted intentionally if it was his conscious objective to cause death or great bodily harm to Ms. Filazzo. The term great bodily harm means bodily injury, which involves a substantial risk of death, serious permanent disfigurement, or long-term loss or impairment of the function of any part or of an organ of the body. As used here, a wanton act is a reckless act done with extreme indifference to the probability that someone would die as a result. It is more than extreme negligence. The state must have proven that Mr. Filazzo was actually aware of the risk of death or great bodily harm, and that he ignored the risk. In determining Mr. Filazzo's state of mind, you should consider all of the surrounding facts and circumstances established by the evidence. The last essential element of second-degree murder is that when he caused the death of Ms. Filazzo, Mr. Filazzo's mental state was not influenced by extenuating circumstances such as sudden passion or great provocation that would have caused a reasonable person to lose self-control. Even if the state has proven the first 4 elements of second-degree murder, the presence of sudden passion or great provocation could mitigate the killing without justifying it altogether. Any person who is assaulted with violence or with an act of extreme insult may be provoked to a sudden impulse or anger which cannot be resisted until the person cools off. Words alone do not establish an act of extreme insult. If this person attacks their assailant and causes death, the killing may be found to be the result of anger or heat of passion. A killing is voluntary manslaughter and not second-degree murder if Mr. Filazzo was adequately provoked, did not have enough time to cool off, and in fact did not cool off. And if his inability to cool off within that time was reasonable under the circumstances. As used in this charge, the term sudden passion refers to such passion as would cause a reasonable person under the same or similar circumstances to act rashly and without reflection and deliberation. Sudden passion means that Mr. Filazzo acted or reacted from emotion, not from reason. Great provocation refers to a degree of provocation that would cause a reasonable person to lose self-control and to act without thinking. A mere annoyance or irritation is not enough. Words alone, no matter how offensive, insulting, or abusive, are not enough to reasonably provoke the use of deadly force. If there was sudden passion or great provocation, but not enough time passed between the provocation and Mr. Filazzo's alleged acts to allow a reasonable person to cool off, then the acts cannot be said to have resulted from sudden passion or great provocation. As the last essential element of second-degree murder, the state must have proven that when Mr. Filazzo committed the acts that killed Ms. Filazzo, his state of mind was not influenced by sudden passion or great provocation that would have caused a reasonable person to lose self-control.
Judge, I think Dana has page 18.
Yeah. Page 18 is missing.
The next page.
Thank you, Danny.
Are you also missing page 18?
I have 18.
None of us do.
You don't have 18.
We do now.
Huh. All right, I get why. Okay. All of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of second-degree murder beyond a reasonable doubt, then you will be done with your deliberations and you must return a verdict that Mr. Filazzo is guilty of second-degree murder. If you decide that the state has not proven each of the essential elements of second-degree murder, then you must consider whether Mr. Filazzo is guilty of one of the lesser offense, or if you are unable to agree upon a verdict concerning the offense of second-degree murder after after all reasonable efforts to reach unanimous verdict, then you may move on to consider the other lesser offense of voluntary manslaughter. I'm going to ask each of you to cross off "and involuntary manslaughter" that exists there. If you have a pen, or at least do it in the jury room. And it was also on page 14. And please cross it off on the bottom of 14, second line after lesser included offense. And on the next page, it says 3 lesser offenses. There are only 2 lesser offenses. That was a mistake the court made. Voluntary manslaughter is a lesser offense than second-degree murder. It is an intentional, unlawful killing of another human being committed under extenuating circumstances that mitigate but do not justify the killing, such as sudden passion or great provocation that would cause a reasonable person to lose self-control. A killing is voluntary manslaughter as opposed to murder if Mr. Filazzo lost control because of the sudden passion or great provocation, if he did not regain control before the alleged killing, and if a reasonable person in the same situation would not have regained control within the same time. If you reach the point of deciding whether or not the state has proven the lesser charge of voluntary manslaughter, you must consider whether the state has proven the following essential elements beyond a reasonable doubt: that on the date alleged and at the place alleged, 1, Joseph Filazzo; 2, caused the death of Emily Filazzo; 3, the killing was unlawful; and 4, in causing the death of Ms. Filazzo, Mr. Filazzo acted with intent to kill, or an intent to do great bodily harm, or a wanton disregard of the likelihood that the death or wanton disregard of the likelihood that death or great bodily injury harm would result. The first 3 essential elements are defined in the same way as they are defined for first-degree murder and second-degree murder. The 4th and last element of voluntary manslaughter also contains the same 3 mental states that form the 4th element of second-degree murder. The state must have proven that in causing the death of Emily Filazzo, Mr. Filazzo acted with 1, an intent to kill, or 2, an intent to do great bodily harm, or 3, a wanton disregard of the likelihood that death or great bodily harm would result. You must apply the same definitions I have given you, and you must decide whether the state has proven Mr. Filazzo acted with 1 or more of these 3 mental states. At the same time, you may find that the degree of crime is reduced from second-degree murder to voluntary manslaughter if Mr. Filazzo's mental state was influenced by sudden passion or great provocation. The state bears the burden on this issue. If the state has proven the 4 elements that are the same for second-degree murder and for voluntary manslaughter, but if the state has not proven a lack of passion or provocation, then the state has proven voluntary manslaughter, but not second-degree murder. In other words, the presence of sudden passion or great provocation can reduce the crime, the degree of crime from second-degree murder to voluntary manslaughter. However, if the state has proven the 4 essential elements of voluntary manslaughter, the presence of sudden passion or great provocation does not reduce the degree of crime below the level of voluntary manslaughter. All of the elements of the offense must have been present at the same time. If the state has proven each of the essential elements of voluntary manslaughter beyond a reasonable doubt, then you will be done with your deliberations. You must return a verdict that Mr. Palazzo is guilty of voluntary manslaughter. Presumption of innocence. This is a different take on it. When considering the degree of unlawful killing that might be involved in this case, the presumption of innocence plays 2 roles. First, Mr. Palazzo is presumed to be innocent of any crime. Second, if you find beyond a reasonable doubt that Mr. Palazzo committed an unlawful killing, then you must give him the benefit of any reasonable doubt in deciding the degree of the offense. In other words, you must apply the presumption of innocence and weigh it against the evidence at each step of your deliberations. Nevertheless, if all of the evidence weighed along with the presumption of innocence convinces you beyond a reasonable doubt that Mr. Palazzo is guilty of one of the higher degrees of unlawful killing, then you must find him guilty of the highest degree of offense that has been proven beyond a reasonable doubt. Verdict. Your verdict will be one of the four possible verdicts: not guilty of any crime; 2, guilty of first-degree murder; 3, guilty of second-degree murder; or 4, guilty of voluntary manslaughter. Concluding remarks. Jury deliberations. Your verdict must represent the considered judgment of each juror. To return a verdict of guilty or not guilty, you must all agree. Your verdict must be unanimous. You must consult with one another. You must try to reach an agreement if you can do so without sacrificing your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. Do not hesitate to re-examine your views and change your opinion if you are convinced it is wrong. But do not surrender your honest opinion as to the weight or effect of evidence solely because of the opinions of your fellow jurors or for the mere purpose of returning a verdict. If you need to communicate with me, you should send a note to the court officer signed by the moderator. You should not tell anyone how the jury stands numerically or otherwise until after you have reached a unanimous verdict and you have been discharged. Even then, you need not speak to anyone about this case unless you want to. When you have reached a verdict, tell the court officer that you have reached a verdict, but do not tell the officer what the verdict is. You will then be brought into the courtroom where I shall ask you if you have reached a verdict and if you have, what it is. And in this regard, you will get a special verdict form on which to write it, which I'll describe in a minute. So before I talk about the moderator's duties, I can't know the moderator until I know who the jury is. And this is the sad time because you have all given such careful attention to the case that I must excuse 4 of you. So what I'm going to do, I'm going to go into chambers with the attorneys, and I have a little app on my phone that randomly selects. I've put in the numbers 1 through 16, and I push it 4 times. And wherever those numbers are, those will be the people who are excused. It's random. I am going to ask the first 2 people that I excuse, I'm going to ask you can go home, but I'm going to continue to admonish you not to discuss the case. In the unlikely event that the other 12 lose a juror for any reason during deliberations, I want the other 2 jurors to be ready to take over, and that can't work if in fact you discuss the case with anyone. So with that, I'll excuse us. We'll bring the microphone in. It will be on the record, but we'll turn off the like a sidebar, okay? And we'll be back very shortly. I ask you all to just remain seated, or if you need to stretch, to stretch. All right, sadly, I told you I had to just, juror number 2, Mr. Carpenter, you're excused. Yourself on Dana. Thank you. at this point, I'm going to appoint one of you as moderator of the jury. The moderator acts as a chairperson or foreperson. It is your duty to see that discussion is carried on in a sensible and orderly fashion, to see that issues submitted for your decision are fully and fairly discussed, and that every juror has a chance to say what they think upon every question. Where ballots should be taken, you will see that it is done. I'm going to keep members of the jury, I want to thank you for your attention throughout this case and these instructions. Ms., do you want to approach Ms. Jantz for any reason?
Just about the verdict form. Oh, yes. Thank you.
I shall now swear in the court officer. Mr. Provost, you solemnly swear that you will keep this jury together in some suitable place until they are agreed or discharged by order of the court, that you will suffer no person to speak to them concerning the cause on trial, nor will you speak to them yourself about the same, unless by order of the court, or to ask them whether they are agreed under the pains and penalties of perjury.
I do.
Okay. The jury is now excused to deliberate. The court officer will bring in the exhibits that we've referred to already that can go in there with you. And again, if you need to review any of the videos or anything else that's only in the courtroom, write a note and we'll make that happen.
All right.
Anything else right now?
Just with respect to the verdict form that I said did not include any mention of passion or provocation because it's in the instructions, but the fact that it's not on the verdict form, I think is confusing. The verdict form asks them only about the essential elements of the charge and doesn't include the language about passion or provocation.
It doesn't include intent. It doesn't include premeditation. It doesn't include any of the charge language because it already had been instructed. This is at this point just naming the charge, and it does it for all three of the charges. So we'll note your objection, but we'll leave unless there's any further objection, we'll leave the form as is. Okay, we're excused for now. Obviously, it's good to hang around. Are you going to stay around here, Ms. Jantz? Okay.
All right, y'all. So should we just keep the stream open? Y'all let me know what we want to do. I imagine they won't come back in less than an hour. Either way. I'm on my walking pad, getting my steps in. So I'm going to be here for a while anyway, but what do y'all want to do? Let me know. I don't know for sure if we'll get a verdict today. You want to flash back and watch his testimony from yesterday, y'all? Yeah, I'm getting my steps in twice. I want to do an hour. I did 30 minutes this morning. Do another 30 minutes now. Y'all, I'm going into the new year. I got to get some pounds up off me before the new year. I'm not trying to have the New Year's resolution be to get these pounds up off me. I want to go into the new year. I want to drop about a good X number of pounds before the new year even hits. So yeah, your boy is doing it now instead of later. All right, we'll go watch his testimony from yesterday. Let me cue it up. Give me a second. It's quite disturbing. Do y'all want to watch? Let me see. We'll watch even when his lawyer, because he got brought up by his own lawyer, which was not a good idea. Let's see where they pick up. Okay, we'll start here. Y'all can't hear? It's not on mute. I can hear it. I can see y'all saying no sound, but I can hear it. I don't know what the problem is. It's not on mute. Look, hold up. Look. Look at the sound. See? The sound is on. Did y'all see that? So can you hear it now or no? If not, I'm gonna have to maybe reset. No? Yeah, it's not playing sound. Oh man. It's gotta be StreamYard. All right, give me a second. It's gotta be StreamYard, y'all. Give me a second. Sorry.
Immediately like open up the door, open up the roof hatch, open up all the sliders and get some fresh air within the cab. So yeah, it was kind of smoky in there, and she was upset about the smoke.
That's StreamYard. Sometimes it does it. I don't know why.
Well, there was a bit of arguing about that. And I suggested that, just step outside and get some fresh air until the thing blows itself through. And there was still light, and I suggested that we take advantage of the last light of the day. And so where it's located is on technically, there's 3 peaks at the Bolton Valley Mountain Range. It's like Woodland, Vista, and Timberline. So we were on the Timberline peak, and I suggested we go down. If you hike a short way down, there's a drop off, and you can get the last light of the valley over the trees. So I suggested that we hike down to the drop off and take some photos and post them up on Roaming Rosie, our social media.
And what did Emily say or do?
She was very angry about the smoke, and she started arguing about it, how pathetic it was, and that the whole thing just was turning into a shitty situation or something like that, is what she said. Then what happened then? Yes, she said she did not want to go hike down.
Did this conversation happen inside or outside the camper?
This one, it started outside and then worked its way inside. And I was like, you seem like really, really hostile, is what I said to her. And I'm like, what's going on? Like, the drive there was fantastic. Like, we're singing along to the radio together. We're talking about how we're going to like start our trip and go meet the rest of my family. And she's all smiles. And then next thing I know, she's like throwing stuff around. And,
Like what?
there was like a basket that had some bottles of alcohol and some candles, and there's like a bunch of throw pillows and Remington. Remington was like sitting with her, and she like threw her off. So I was like, yo, like maybe just like pour yourself a drink and relax. We brought stuff to make drinks. We brought marijuana. I was like, yeah, just have a smoke, have a drink. And we finally made it on vacation. Like, just try to take that in.
Then what happened?
Well,
Well, let me ask you specifically, did she have a drink?
I made drinks for myself. And I thought that she was, earlier, Dr. Shapiro said there was no alcohol in her system.
So, don't comment on that, please.
Okay.
Did she have a drink?
I saw her drinking.
Okay, what?
Must have just been Red Bull.
Okay,
But I was having Red Bull vodkas. That's what I was,
that's what you were drinking.
yeah.
So you had a drink, and your recollection is that she had a drink?
Yep.
And was there any conversation going on while you two were having a drink?
Yeah, so there was conversation because I was like, yo, you're really hostile. Like, what's going on? Like, it can't just be like the smoke cleared out. Like, why are you so hostile? And she said that. She's like, well, I have a dilemma. And I was like, what do you mean you have a dilemma?
Your Honor, I'm going to object to the hearsay.
Well, why don't you come up and why don't we hear what the proper
So you started telling us a little bit about the specifics of what Emily may have said, but without going into specifics, you told, we saw in the interview that she was saying hurtful things to you. Is that a fair statement?
I saw that in the interview, yes.
And is that your recollection of what you were hearing?
From watching the video,
No, I don't want to know what you saw in the video. I want to know what you remember.
from what I remember of our conversation,
Yes.
well, I started telling you about our conversation, but then there was an issue with it, so I don't know what to do.
Let's answer questions and we'll take up whatever issues there are.
Okay. All right, yeah. So we had gotten to the point where there was a discussion of a dilemma. And when I inquired about it, she showed me on her device that she had typed a very lengthy, in the Notes app, there was like a multiple page, I don't know what you call it, but it was labeled dilemma. So I was like, okay, well, it seems like you have something to talk about. But then she deleted the note.
You saw that?
Yeah, she deleted it and she said, I'm not going to talk about it. So
How were you feeling about this conversation? How did it make you feel?
it made me feel like it was pages and pages. So it made me feel like she had something that needed to be expressed. And when she deleted it, I was like sort of shocked that something that took that much effort wasn't going to be brought to my attention.
What happened next?
At some point, I texted my sister. We were supposed to meet up. So there was a bit more argument about how pathetic the bus was and how shitty the trip was, and
Let me ask you this. You started saying you texted your sister.
yes.
What did you text to your sister?
I asked her when she was gonna be showing up, because we were eager to meet her, something to that effect. I can't really remember what I texted to my sister, but it was something to like, when are you gonna be here? We're here.
And so did your sister meet up with you?
Yes, she did.
Where?
She came to the condo and parked next to Rosie and came into Rosie.
Was she alone?
No, she wasn't. She was with her boyfriend, Ariel.
Okay. And was Emily in Rosie with you?
Yes, she was.
So how long was Nikki there? And Nikki and Ariel?
Nikki and Ariel came and stayed for, I would estimate, a half an hour.
Okay. Did Emily participate in conversation with your sister?
She greeted them, introduced herself, and then she sort of just sat quietly on the edge of the bed, not really engaging in any kind of conversation.
And you and your sister, you talked?
Yeah, we were just catching up on sort of current events, what was new with her, how it was great to see her. And then the introduction of Ariel, I had never met him before. So just trying to get a little backstory on how those two got together.
So I think you said that, I don't remember what you said. How long was she in the camper?
I would estimate a half an hour.
And what happened after that?
She invited us to come to their Airbnb. And then she left Rosie and went into her unit.
And what did you do after that? After Nikki left?
After Nikki left,
Yep.
I made another drink, had some more to smoke, questioned Emily on if she wanted to join. There was Nicole had said that they were going to watch Netflix, so that was like that was one of the options. I think she also said like there were some board games or something like that in the unit, so we could play cards or board games or watch Netflix and just hang out. So
Okay.
I asked Emily if she was interested in just going and having a kickback with Nikki and Ariel, and she said no.
So she didn't go with you?
No, she said she did not want to go in.
So you went into Nikki's Airbnb?
No, I did not. No, I did not. I told her that I wanted to go in because we came to spend time, and it started an argument, and there was a time where we were talking about she had made a new acquaintance in Vermont, and
Are you talking about a conversation you had that evening in camp?
yes, this is a conversation with Emily.
And this is after Nikki left?
Yes, Nikki left, and I invited Emily. I was like, let's go hang out with them, and she said, I don't know if I want to. She said, I don't know if I want to. She's like, this is pathetic. This is not what I want to be doing. I want to go. She had met someone, and she told me about using.
Your Honor, again, we're getting into hearsay, and I also don't know what the relevance is of this.
Yeah. Okay.
So the conversation you had, did it lead to an argument?
Yeah, there was an argument because she wanted to go hang out with her friends, and I told her that she came on the trip, and she told me earlier that day, she said she was here to meet my family, to hang out. So I was very confused. Well, now you say you want to leave, but we just got here. So.
So what did you do next?
Well, I told her I was going to go, and then there was, she started saying some very hurtful things and some very threatening things if I was to go and leave her to her solitary. Yeah, that was the next thing that confused me, was why are we getting threats all of a sudden?
Do you have any idea about what time of night this was?
This could have been somewhere, I'm going to estimate around 9 p.m.
So what did you do after that?
Well, I told her if you want to go, then go. I don't want you to be unhappy. If you don't want to be here, then don't be here. But up until now, you said you wanted to. So, I just need a moment. Well, what happened is I ended up staying in the bus with her.
What was she doing?
Well, she was having a fit, really. She was cussing and saying how shitty it was and how shitty I was for not giving her money to go have an Uber and like leave the vacation. And
what were you doing?
I was on vacation, so I made another drink and I had some more to smoke. And
And just to clarify, you were drinking vodka and Red Bull?
yes, ma'am.
Okay.
I remember dancing. I think I put some music on and I was just dancing with Remington. Yeah, just trying to enjoy the moment. Really, that's what I remember doing.
And what happened?
Well, I just need a second. So at some point, I remember she had grabbed her device, her phone, and I think she was just like scrolling.
Scrolling?
Yeah, I think she was just like scrolling around. I'm not sure what exactly sites or what apps she was using. So, but yeah, I was just doing what I came there to do. I was just enjoying the scenery, like watch the sun go down. Spend some time with Remington. I kept asking her, like, if you want to talk at all, like, please talk to me. Like, there was pages and pages that you wrote, so it sounds like we should talk. But she didn't.
And then what happened?
Well, there was points where I would take Remington out to to do go potty or do her business, and
Let me interrupt you.
yeah.
Was it dark by this time?
Yeah, it started to get dark. That's what I was remembering, that it was starting to get dark, and I was getting concerned about taking Remy out. So I did like a rearrangement of the firearms, because I started carrying the Glock outside. It has tritium sights on it, so you can see in the dark. And that was I had seen some what I believe to be coyote. I like shone a flashlight and I saw a couple sets of eyes in the dark. So Remington's a pretty small dog, and I just wanted to be able to protect her. So
the Glock is a gun that you typically carry?
I don't typically carry that gun unless, I take it hunting, but it's not like a concealed carry. I will open carry it in a situation similar to what I just described, where I'm just taking the dog out to do her business. We were up on the top of the mountain, so I actually used to live there, so I've seen you know, I've seen bobcats, mountain lions, fox, coyote, you know, and they're brazen. Like I remember carrying groceries up those steps and actually having a coyote like confront me. So I just wanted to be able to protect Remington.
So let me ask you, did you purchase that Glock?
Yes, I did.
Did it have a silencer when you purchased it?
When I purchased it, it had a threaded barrel to equip a silencer. I ordered the silencer the day that I purchased it, and it came in weeks later.
Okay. And there were other firearms that were found in the camper. Were they
Yes.
all registered to you?
Yes, I think there were 6 firearms. Yes, there were 6 firearms in Rosie.
And prior to knowing you, do you know whether or not Emily had any experience with firearms?
She might have had some experience, but when her and I started going target shooting, it seemed like she was still fairly novice.
And it was mentioned in testimony earlier that a Taurus was found in the camper.
Yeah, there's a Taurus 9mm pistol.
Was that Emily's gun?
And that was the gun that she liked to use the most because it has a small grip.
Okay. So I interrupted you. You said you took Remy out and saw what you thought might have been coyotes, and you came back into the camper.
Yep.
What did you do or say then?
Well, I came back in and I put the Glock in the sock bin. And
Where's the sock bin in relation to the bed?
the sock bin is like in the we'll call it a closet. But it's
So
just
is
like
that at the foot of the bed?
it's at the foot of the bed. It's like an opening where there's like a rod for hanging some clothing and so I set it in there.
Did you put the silencer on it at that time?
It had the silencer on it
Okay.
from, I mean, I guess the last time that I cleaned it, which was months prior, I don't remember the last time the silencer was off of it.
And did you say anything at all to Emily about the coyotes?
I did. I said, oh my God, I saw 2, and that means like if you see 2, there's like a whole pack. So I was like, yeah, like they're probably looking at Remington like, she's a small dog. So I was like, I bet they're like thinking she's like a snack. I was like, not today.
Did you say anything to her about you arming herself with the Taurus?
Oh, yeah. At one point when I went out, I took Remy out for a little stroll, and I said, "You got the Taurus. I'm taking the Glock." So she had access to that. She also had access to the shotgun, which was still out at the time, but she didn't favor its large. She favored the smaller pistol.
Okay, so going back chronologically, you come back in after seeing the coyotes.
Yeah.
You talk about her taking the Taurus, you get the Glock and put it, where do you put it?
I put it in the sock bin. It was at the base of the bed and like the opening of what would be like a closet space.
What did you do then?
Same kind of thing, just continued to have some drinks, and it started getting dark, so I lit some candles, lit some incense. Yeah, just kind of I did what I like to call like aisle yoga. So there's like a not a very wide aisle that runs down the middle of the bus. So I was just doing some like it's like half yoga, half dancing. I had some music on. I was just stretching and enjoying myself.
And what was Emily doing?
She was scrolling away on her phone, on her device.
Was she on the bed?
Yes. Yep.
Was she talking to you at all?
She was sitting on the bed. No, not much. Not much. You know, didn't really show a whole lot of interest in what was going on outside. You know, just sort of like looked up from her device, like when I talked to her, and then just sort of.
Okay. So she's sitting on the bed scrolling. You're doing your yoga, dancing, and drinking.
Yes.
And you had lit some candles and incense. What happened next?
Well, there was. There was a point where Emily went from like sitting, she was sitting up kind of like cross-legged, and then she went to like laying on her side, still just like scrolling away, just looking at her device, and then at one point she lashed out and started cursing at me about the candles being lit.
What did she do, if anything?
Well, she was, you know, she was cursing. You know, I don't know. It wasn't really, in my opinion, it wasn't really bright, but she was cursing.
I mean, the lighting wasn't overly bright.
Right. I didn't turn any of the, we had like battery powered LED lights, and none of those were on. It was just candlelight. So
Let me interrupt you there, just to ask you about, there's been testimony that Emily's phone was powered off and so was yours at some point that evening. Why was that?
we turned our phones off to conserve battery life because we didn't have the ability to plug in.
Okay,
So
so that's why.
yeah,
All right, so you didn't think it was overly bright in the camper?
no, I didn't think it was overly bright. I think there might have been 5 to 7 candles lit. So
How many?
5 to 7 candles lit.
Okay, of varying sizes?
All the candles were about the same size, like a large,
Like a
sort of
Yankee candle?
Candle, yeah.
Like, so you're
Yeah, gesturing,
about,
whatever it is.
to me, it looks like about,
7, 8
how many,
inches.
you're saying about 7 or 8 inches tall?
Yes,
And what's the diameter?
possibly like a 4-inch diameter.
Okay, so 7 or 8 of those large candles.
Right. Yeah.
And what happened?
After her telling me to turn the fucking candles off, and I said, it's not that bright. Like, you could always just roll over. She got up and ran at me and grabbed one of the candles. And it was like all I could do to like grab the lid of it and like put it on top of it. And she like pulled it away and started swinging it at me and hitting me with it.
Where?
She hit me in like my neck and head and in my arms. You know, I was like blocking. I think she might have like hit me in the chest. But I like wrestled the candle away from her and like put it back on the counter. And then there was like a flurry of punches and kicks that she started punching and kicking me. And
Where?
in my shoulders and arms, my forearms.
Closed fist?
Yeah, closed fist, trying to punch my face. And I had to restrain her. I had to like physically grab her by her arms and like hold her arms down. And she kept kicking. She actually kicked Remy. and I like sort of turned myself sideways and I like pushed her back to the side of the bed. And I told her that, you know, that we're not your punching bags. And
You said what?
I told her that we weren't her punching bags.
We weren't.
Yeah, she kicked Remy, and she was kicking me and punching me, and I pushed her back, and I told Remy, I was like, "Yo, we're gonna take a walk."
So you know I've asked you this question before. When she hit you with the candle, did it hurt you?
Yeah, I don't know what that thing weighs. Probably like 2 pounds or something. It's a heavy candle, and it hurt.
And after you took the candle from her, you just told us that she continued to hit you and
Yes.
kick you. And
Yes.
did that hurt?
Yes, yes, she hits hard.
And then you restrained her arms and pushed her to the side of the bed.
I did. I held her arms down, and I like turned my hip sideways. She had kicked me in the groin, so I was not trying to have that happen again. So I like turned sideways and sort of like just sidestep and like pushed her back. And I said, "All right, like, you know, we're not your punching bags here. Like, I'm like, no more hitting." And I said, "You're gonna stay on your side. I'm gonna stay on my side." And then I like, you know, I looked at Remy and I was like, "You know what? Let's just go outside." And so I grabbed a couple things. I grabbed the Glock. I grabbed Remy's leash, and leashed Remy up, and we went outside.
And when you went outside, what was Emily doing?
I don't know. I told her.
Let me rephrase that question. You said you pushed her to the side of the bed and told her what you've already
Yeah.
described to
I
us.
said, "You stay on your side, and I'll
What
stay."
did she do anything after that?
I don't know. I went outside.
Did she stay on the bed? When you left, was she on the bed?
She was like leaning against the bed when I left, and I grabbed my stuff, took off outside, and on the way out, I said, "You know what? Like, just wherever you want. Like, just be wherever you want. Like, I'm stepping out." Yeah, Remington and I stepped outside, and you know, she. When I say she, I'm talking about Remington. Went and, you know, did her business. So when I came back inside after letting Remy out, Emily was on the bed, and
What did you do? Well, I believe you told us earlier it had been raining.
yes, it was actually, yes, it was raining outside. So when I came back in, Remington and I were wet. So I grabbed a towel and dried Remy off and dried myself off, and I came back in. And
Where was Emily?
she was on the bed. I think she was like scrolling on her phone. And
So what did you do?
I made a drink. I came in, I put my stuff down. I came in, made myself a drink, and had some more to smoke. Asked her if she was up for talking about why exactly she had a fit about the candlelight. And I don't know what she was saying. She was saying something, but it was just like she was just like muttering. So I couldn't really hear what she was saying.
Okay, then what happened?
Well, at some point there was I just need a minute. Yeah, there was yeah, there was some muttering from her, and then I don't.
After there was muttering from her, what do you remember doing next? You.
Well, some time had passed. I think there was like another drink involved. And then at some point, I had decided to go climb in bed, and
just to be clear, your side of the bed is at the back of the bus, correct?
right, yes, it is.
So in order to get to your side of the bed,
Yeah,
what did you have to do?
Your Honor, leading.
there's
What did you have to do?
yeah, to get into the bed. So to give you an idea, like the bed is very high. There's a lot of storage, and then there's a mattress, and then she was laying on top of it, so it was very high. So you have to climb onto the couch and then across her side of the bed to get into my side of the bed.
So did you say that you decided to try and get into bed?
Yeah, I decided to get into bed.
And did you take the Glock with you?
Yeah, I drained my drink, and I grabbed the Glock off the counter, and I
And what was Emily doing?
she was laying in bed.
And where, if you know, was the Taurus?
The Taurus was under her pillow.
How do you know that?
That's where it was the last time that I had saw it,
When was that?
earlier that day.
Okay. That evening or that day?
That day.
Okay.
It was there all day.
Okay, so you take the Glock
Yes.
that already has the silencer on it, correct?
Yeah, it had a suppressor on it.
And what do?
I climb into bed, and as I'm climbing across Emily, her mutters turned into shouts, and I you have to so you have to climb over the person to get to, if this is my spot and this is her spot, this would be her. You have to climb over her to get to here. So I was climbing over her, and she shouted, "Fuck off." And she threw an elbow at me, and elbowed me in my groin.
Did that hurt?
Yeah, it hurt. It was right to my genitals.
Did you say anything when she said fuck off?
I didn't say anything when she said fuck off. I got hit in the groin, and I said, no more hitting. And so we had a bunch of throw pillows that we lined around the bed, the top of the bed where we slept. So one of the throw pillows was right there, and I swatted her with the throw pillow, and I said, "Stop hitting." And that's when it happened.
What happened?
She said, "That's it. You're dead," and she threw her arm under her pillow, and she pulls her hand out with the Taurus. And
How were you feeling?
I was feeling horrified. Just
Were
like,
you afraid?
I was terrified. Like there was as soon as I saw that, I just felt like this wave of heat, just like red hot. And she started pushing her body up in an instant, and I'm like, no, 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 no. And I don't know, she wasn't stopping. And I had my I was holding my Glock, and she started just coming up at me, and I just fired.
Why?
She was going to shoot me.
And you were afraid?
Very.
You fired twice.
That's
Do you
right.
remember firing twice?
All I remember is feeling three things. It was I felt like it was boom, 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 and it was two shots, and then her body dropping.
That's what you remember.
That's what I felt. Yeah.
That's what you saw.
Yes.
But I asked you what you felt.
Yeah. Oh yeah. 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 I felt just horrified. And yes, it was terrible.
Did you shoot her because you were angry?
No, 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 no. Yeah, it was like she wasn't gonna stop, and that was the only way. It didn't didn't have to be like that.
Is there a question?
I'm giving my witness time to recover. He's having some difficulty. Okay, so are you ready to continue?
Maybe just a moment.
So, Joseph, okay. What happened after you shot her?
I yelled at her, I said, "Are you fucking kidding?" And why the hell would you do that?
Did you know she was dead?
I picked her up.
You're asking for a sidebar, ask for it, but don't come up here.
May we approach briefly?
Yeah.
Very briefly. Okay. You picked up her body, then what did you do? You've already told us that you were yelling at her.
Yes.
What did you do?
I shook her.
You shook her?
Yeah.
Why?
Well, I wasn't sure if she was dead. She just fell lifeless and she was gone. Like,
Okay. What did you do after you shook her? You confirmed in your mind that she was dead. Is that what you're telling us?
yes.
Then what did you do?
I threw the pistol on the couch. I grabbed the other pistol. I threw that on the couch.
Let me back you up. What pistols are you talking about?
There's a Glock pistol and a Taurus pistol.
So the Glock is yours, and that's the one you used to shoot her. Is that right?
That's correct.
And the Taurus was hers.
That's correct.
And they were both on the bed? Is that what you said?
Yes.
What did you do with them?
I threw them off the bed onto the couch.
Did you remove the silencer from the Glock?
No.
Okay. So you threw the two guns onto the couch.
Yes.
Then what did you do?
I slid off the couch and I slid off the bed and I was like, I remember like touching her hair and touching her back and talking to her. And I was,
Did you have anything more to drink?
later on, I had some more to drink. Yes.
So what you're telling us is you sat beside her body for some
Objection, Your
period
Honor.
of time?
He has not testified to any of that.
Yes. For some time I sat.
So wait.
Oh, I'm sorry. I'm sorry.
Wait.
There's a series of leading questions, Ms. Jansen.
Yes, I've been told. So what did you?
Wait till I finish. So
Oh, okay, sorry.
No more leading questions, all right?
Well, we're just setting some foundational things, Judge.
I'm sorry. I'm having a hard time.
So
Where are
without my putting words into your mouth, what did you do next?
I sat with her body, and I touched her hair. I touched her back, and I talked to her. And
Do you have any idea what time of day or night this might have been?
this was probably after 2 a.m., which would be Saturday morning. Saturday morning.
Then what did you do then?
At some point, I lifted her up again, and I was inspecting her, and I just saw like a lot of blood like coming out of her head, and I was like, oh my god, like. So I went and I had some plastic bags, so I went and opened a plastic bag and I put it under her head so she would. I didn't know how much blood was going to come out, so it was like a catchment, and I sat there for some time, just like maybe like 10 or 15 minutes, just like sitting there. And there was I don't at some point after that, I think I like slid off the couch onto the floor, and I called out for Remington, and she has like a small doghouse underneath one of the couches, so I checked on her, and I sat with her, and at some point I grabbed the vodka and continued drinking.
Let me stop you
Okay.
and ask you. You're testifying today about what you remember. When did these memories come to you?
My memories came to me sometime after the event. I was detained by the police, and I was put into a cell, and I want to say it was like at some point, maybe like I'm estimating, like a week or 2 weeks, probably closer to 2 weeks later, after being in the cell. I don't know, like I had an experience. I know that this is going to sound strange, but I had an experience. I don't know if anyone's ever like been on a merry-go-round, where you're on it and everything's just spinning, but that's what I was experiencing. It just felt like everything was spinning, and then the ride finally came to like a stop, and then there was like a bit of clarity where like there wasn't as much like distortion.
So what you're telling us today about what you did after you shot Emily, are those memories that came back to you later on?
Objection. Again, Judge, another leading question.
Sustained.
When did those, what you just told us, it was a couple of.
Yeah, it was a couple of weeks. I was having flashbacks. I finally started to. I felt very separated. And what I mean by that is like I feel like my mind and my body were on two different planets, and I had finally like rested and started to like feel clearer about things, and I was trying to understand what happened, and trying to put the pieces back together, and
So let's continue with what you remember happening, and we're in the early hours of Saturday morning, right?
Yeah.
What do you remember next?
Early Saturday morning, I sat with Remy, and we mourned together, and we were just like so scared and confused, and yeah, I remember drinking from the bottle, and then I remember the sun coming up, and yeah, I remember the sun coming up, and then at some point, I made the call to get some coffee together. So
So you remember making coffee?
Yep. I remember it being sun up, and I remember making some coffee. I had a French press and some coffee grounds and made some coffee. And took Remington out. Drank some coffee, and then it was just, I don't know, like I was just like, I was really shook. So I just I was having a hard time focusing, you know. I just remember like my mind was like working in loop or something. Like I just kept seeing it happen over and over. It's terrible.
Are you telling us that you saw yourself shooting Emily?
Objection, Your Honor.
No.
Wait until the judge rules.
Oh, sorry.
You can answer.
No, I just remember like the sensation of like her body dropping, and I remember like picking her up and her just like falling, just lifeless.
And that's what you remembered?
Yeah.
You were, I think you said over and over.
Yeah, like intermittently just interrupting everything.
What, if anything, do you remember doing on Saturday?
On Saturday, I reached out to my sister. I was reaching out to see if she was awake, if she had her morning coffee yet, to see what her plans were for the day. And I don't know if she asked me or if I asked her about eating, because the next thing that I remember is we went to eat some breakfast.
You remember that?
I have like a couple flashes of like getting in her car, somebody's car, Ariel's car, I don't know whose car. I remember getting in their car. I remember like being at the restaurant. I don't really remember specifics.
Do you remember telling her anything about where Emily was?
Yes. Okay. Yeah, I do remember she asked, is Emily joining us? And I lied and told her that Emily was still sleeping.
Why did you lie?
We talked about how their trip was for their vacation, and that she didn't want us to bring our drama to their vacation. So I didn't want to dump that on her.
So your testimony is that you didn't tell her that you shot Emily because you were honoring her request not to bring drama?
Yes. Yes, I didn't want to bring the drama to her vacation.
Okay. What else did you do on Saturday that you can now remember?
After breakfast, there was talk about her. She wanted a tattoo, and I said I'd be happy to give you a tattoo. So we made plans to meet up. Oh, you know what? I think at some point I took a shower. Yeah, I took a shower. Yeah, I think after breakfast I took a shower in her Airbnb. And
So you remember her asking for a tattoo and you agreeing to do that, right?
yes,
What else do you remember happened on Saturday, if anything?
took a shower. I went and I had to pack Rosie up for a trip. And after the events the night or the morning, the events of the morning, Emily was lying on the bed. So I had to do like a cleanup. I had to clean up some things and move some things around and sort of pack everything up to move the bus. And yeah, I collected some items, and like I said, I packed things away so they wouldn't move around during transport. And I moved Emily from the bed onto the floor of the shower. And then
Any idea what time of day this happened?
I want to say midday.
So after you had breakfast, took a shower, came back, you cleaned up. Is that what you're telling us?
Yes.
Then what else, if anything, do you remember about Saturday?
Saturday, I drove to Sarah and Jason Lang's. They were letting me use a room as a studio where I was doing some tattooing, and there was I want to say maybe like an hour and maybe like an hour and a half drive up to St. Albans from Bolton. So I drove. I drove through Jonesville. I stopped at the river where we used to go swimming. I threw some items into the river. I drove to.
When did you remember all of this?
This is all stuff that I'm just putting back together. I feel like everything, all my memory is very fragmented. Like it's just like pieces of a puzzle, and I'm just trying to put the puzzle back together. So I didn't remember until we started trying to figure out why everything happened and how everything happened.
Okay. So you drove up to St. Albans, is that right? To the Langs.
Went to the Langs.
What happened then, if you remember?
I parked Rosie, and I went to speak with Sarah. She was home. I think Jason was working.
What, if anything, did you tell them about where Emily was?
They, well, Sarah was there and she asked, where's Emily? And I lied to her and I told her that Emily had left to go hang out with some friends. Yeah, she was talking about going to hang out with her friends, so I just sort of like ran with that information and just told Sarah that she was hanging out with her friends.
What do you remember happening next?
Well, at some point, my sister and Ariel showed up at the Langs. Yeah, she brought me my phone. And
What do you mean she brought you your phone? Wasn't it with you?
no, I asked her if I could use her electricity at her Airbnb and leave the phone charging, and she could just bring it with her. So she brought me my phone, and we talked about doing a tattoo, and I remember doing like a sketch out of the tattoo. I remember feeling like really, really angry. Not with my sister, but just like the events that happened, it just kept like rolling over in my head. And I was just so angry, like thinking like how anyone could push me to that. Like I just never thought that was possible. And yeah, just like really out of focus. And
We've heard testimony from other witnesses that you appeared very calm and natural. You remember hearing that?
I do.
But you're telling us that that was not what your emotions were.
I was falling apart inside. Outwardly, yeah, I think I'm a very closed off person. I'm a very private person. And I do drink and use THC to excess. I mean, not anymore. I've been sober for 3 years, thank God. But out there, it was pretty bad. I was drinking and I was smoking almost all day, and it definitely helped to like just keep me numb.
But are you telling us that in general, you're a closed off person?
I mean, I don't really show outwardly like how I'm feeling or what's going on with me.
Okay. And it's been commented before that, and we've also seen it on the interview, you were able to go from showing emotion to having small talk just like that. How is that possible?
I mean, the interview, the video is hard.
We're going to talk about that in more detail. I'm just asking you about
well,
flipping
so
the switch and
yeah, a lot of times I've been working with people for a long time, and I usually will start talking to someone to get them to open up about themselves.
And you're talking about working as a tattoo artist.
Yeah, working as a tattoo artist and a piercer. What I do, it hurts. It hurts people. Like tattoos hurt, piercings hurt. So as a distraction, I will get people to talk. And once they're distracted enough, then I will do the procedure. And typically they're they're not focusing on the sensations, so they can be still. I don't know if anyone has tattoos, but you can't move around. It's permanent marks. So if you move around, if you want the word Bob, it might come out saying Bub. So you don't want to move around a lot when you're getting.
So is this your explanation of how you're able to engage in small talk?
Yeah, I just get people talking.
This is a habit that you've developed.
Yeah, it lets me focus on what I'm doing without having to worry about them.
Okay, so you said you were drinking a lot and smoking a lot at that time over that weekend.
Yes.
And we were talking about what you did on Saturday. And what else, if anything, do you remember from Saturday?
Saturday, the tattoo for Nicole happened, and then Nicole, Ariel, and myself went to get some food and some drinks, and I believe they drove. They drove. I got in their vehicle, and we went to Twigs, and I remember having like a snack, and I remember having multiple drinks, and leaving. Well, really, I remember them dropping me off back at the Lang's place.
Okay.
I don't remember a lot of the conversation or I felt very distracted and very just, yeah, I was going through some pretty emotional stuff.
What do you mean by that?
I don't know. I can't really explain it. It's like the first time anything like this has happened to me. So like I couldn't focus. But what I do remember is them dropping me back off at the Langs, and I remember going back into Rosie and just sort of seeing the state of affairs in there. And
What does that mean?
Emily was deceased, and there was blood, and it was bad. And
Did you sleep that night?
no, I got a blanket, and I covered him, and I sat with her and talked with her, and yeah, the three of us just sat together, and yeah, we just cried, and
You cried.
yeah. Remington was it was like she knew what happened, and it was like she was crying too. You know, she was like whining, and
So that's Saturday night.
yep.
Do you have any recollection of Sunday?
Well, I remember drinking. I remember sitting on the floor, like holding Em's hand.
You there.
Uh-huh.
Did you have all of this? What were you drinking? Was it still what you told us before, vodka and Red Bull?
No. No, I believe that was Saturday night. So I remember drinking red wine and gin.
Was this alcohol that you already had purchased and had in the bus?
Yes.
It's a lot of alcohol.
Yeah, I had a real problem. And I didn't want to feel, I didn't want to be in my emotions like that. And I drank, and then I remember the sun coming up on Sunday, but I don't really remember Sunday.
Okay. Do you remember anything happening on Monday?
All I remember is from there on is just like flashes of things and just really like distorted.
Let me ask you specifically, do you remember going to the Basses on Monday?
I remember like a flash of being on the road, like riding there. I remember a flash of seeing Adrian's eyes.
Why did you go to the Basses?
So that was that Monday? I had I found out that I went to the Basses,
What
and
do you mean you found out? What do you mean you found out?
well, I read a transcript.
Okay, so I'm asking you if you have an independent memory or recollection of going to the Basses.
All I remember is like seeing Adrian's eyes, and then after that, I remember having like a sensation of like hugging Spencer and like falling into his car.
Okay. Oh, very sporadic memories.
Yeah. It's just there's no like memory reel. It's just there's a piece here and a piece there, and nothing lines up, and I can't.
We'll take our afternoon break now.
Okay.
I want to talk to the parties for a moment. Before lunch, your estimate was you were going to be another hour. It's been, we're working on, it's been a little over an hour and a half.
Now, things that I was planning to cover later on.
How much longer do you think your direct will be?
Half an hour, 45 minutes.
Yeah.
45 minutes-ish.
I'm not holding you to an amount to cross, but do you think we would finish cross today? If you start at 3:30 or 3:45? Again, there's no need to say yes.
I don't know.
Okay. All right, and we'll talk about tomorrow, but I think we're probably looking pushback, maybe pushing back closings, certainly till at least Thursday afternoon and maybe Friday morning, but we'll see how things go, depending on what further evidence there might be. All right? Okay, thank you.
Thank you. multiple occasions over the course of the weekend, right?
Right.
Please be seated. We're back in the matter of State versus Joseph Palazzo Jr. After our mid-afternoon break, all members of the jury are present, and we'll continue with direct examination. Ms. Jan.
Thank you, Judge. So, there's a couple of things I want to talk about. You've admitted that you lied on multiple occasions over the course of the weekend, right?
Right.
Do you remember the things you've already testified that you lied to your sister, you lied to the Langs?
Yes.
Any other lies that you remember telling?
No.
Do you remember sending text messages to Emily's phone over the course of the weekend?
I do remember sending messages when I was with my sister. She brought up Emily, and I was like, "Oh, I'll send, I'll text her, see where she's at." And
Why did you do that?
that was another lie. I did not want to tell my sister what happened.
And when you were at the Basses, do you remember having a telephone conversation with a law enforcement officer from Vermont?
No.
You don't remember that? Okay. Why were you lying to all these people about where Emily was?
Well, so it's like this. I had talked to my grandmother about coming to Pennsylvania to help get her out of her home and put her into a safer home, either like a one-story home or like an assisted living. And Emily and I were going to go to Pennsylvania to help make that process happen. And if I would have told people, then the police would have been called, and I would be detained, and I would not be able to help my grandmother get her life together. So I wanted to move forward with my plans, even though what happened made it impossible.
So your testimony is that you lied because you wanted to get back to Pennsylvania to help your grandmother move.
Yes.
Why didn't you just go back to Pennsylvania instead of hanging around all weekend?
Well, so I took the opportunity to be with my sister, as I hadn't seen her in years, and I asked her what she wanted to do, and she told me what she wanted to do. So I spent time doing that. I was catching up with my friends, the Langs, and spent time with them. I asked them what they wanted to do, and hung out with them. And yeah, that was why I was. I didn't. I don't know. My everything sort of just like got turned upside down. So I spent time with the people that were around, and
Do you remember inflicting any stab? Do you remember inflicting any stab wounds into Emily's body after she was dead?
No.
Do you remember cutting her up?
I have one flash of memory where I cut into her leg with a knife, and then I stopped. It made me sick, and I remember being sick, like nauseous and vomiting, and that's all I remember is being sick.
Just once?
No, I drank. I drank and got sick multiple times. But I don't remember any other part of that incident.
I want to talk to you a little bit about your taped interview with the police. At the time you talked to them, when was the last time you had slept? So you talked to them about 2:30 roughly on Tuesday afternoon. Prior to that, when was the last time you slept?
We left for our trip Friday, so Thursday night into Friday. I woke up Friday morning.
So Friday morning was the last time you slept before you were interviewed by the police. Is that what you're telling us?
Yes, I woke up Friday morning, somewhere about 7:30. Yeah, we slept, and we were in New Hampshire, and we slept in her bedroom.
You've seen your recorded interview a couple of times, right?
I have.
And do you remember Detective Voris asking you more than once, where did you sleep that night? Do you remember seeing that?
I saw the video of it. I don't remember. I don't have memory of that. I don't have access to a lot of my memories at this point. I only have what I've seen on the video.
Okay. You saw on the video that you said to him, I slept on the bus more than one, in response to more than one question. Do you remember seeing that?
I saw that on the video.
Yeah. But your testimony is that you were essentially, you hadn't slept.
Can I ask you not to read the witness?
Yes, certainly, Judge. Yep. The first time you saw the video, what was your reaction to seeing yourself and hearing what you said?
It was revolting. My reaction was disgust. I was revolted to see and hear. I was like so like depersonalized, like disassociated. Just I don't know how to. It was revolting to me to watch that video.
The first time you saw the video, did you remember participating? Do you have memories of that interview?
No, it's no. When I watched that video, it's like I don't know if anyone here has ever gone blackout and then come to and found videos and photos where that you just can't explain. But that's how it makes me feel. Like I see myself on the video, but I I don't remember being there.
You don't remember being there. You don't remember anything that you said. I think you told us earlier that, several weeks after you were detained by the police, you started having flashback memories. Is that right?
Yes, I did.
And what's the first thing you remember? Were these in dreams, or how did these come about?
Well, after recovering, there was
What do you mean recovering?
there was a period where I wasn't sleeping, and I felt like, I don't know how to say this, but I felt like I don't know, like I was broken in two. Like I was, my body and my mind weren't the same, and it took some time. I was having a lot of nightmares, and I was having poor sleep. So once I finally felt rested and realized where I was trying to figure out what had happened that had gotten me there. And that's when I was able to read the affidavit from that interview, the video interview, and none of it made sense to me.
And so when did you first remember that, as you testified today, Emily was going to shoot you?
When I was arrested and I was thinking what happened, that's when the memories started coming to me. It was like those same kind of flashbacks that I was having, but like the pieces started kind of like coming together a little bit more. And it's frustrating because there's some memories there, there's some memories that aren't there. So this whole process has been kind of strange, picking up new pieces and trying to put the thing back together. And yeah, I've never experienced anything like this, so it just makes me feel like I have some very strong feelings about it. And yeah, I just need help putting the puzzle back together.
So I don't think I went over this with you, but you have no criminal record, do you?
No.
And so you had no experience being
Objection, Your Honor. Can we approach?
So here's the question for you. To explain to these people why you didn't tell the police everything you've told us today. That, as you've explained, you shot Emily because,
Again, just ask the
yes,
question.
fine. Why didn't you tell the police that?
I don't remember talking to the police.
That's at all. Much of the information that you provided to the police corresponds with, was corroborated by other means, like where your phone was and with whom you met. The only thing that is missing from that interview is that you didn't tell them that you shot her in self-defense. And your explanation is what?
I didn't remember talking to the police. You know, the memories came to me as they came to me, which was, as I said before, like after I had rested and I felt like I could use my mind, then I was trying to figure out what exactly it was that happened, and that's when all the flashbacks started coming back, and then I described it to you guys.
So your answer, to summarize what you said, is you have no memory of the interview.
I watched the video of it.
And your memories came back in fragments weeks later.
Yeah, some of them are still, like, I'm seeing stuff still, you know, as we're doing this, that just is foreign to me, so.
Is foreign to you?
Yes.
I may have a moment, Judge.
You may.
I have nothing else. Thank you. State these one.
Ms. Adams.
Thank you.
The truth is that before leaving New Hampshire, you stopped at Market Basket, right?
I did see that, yes.
That's the truth,
I saw that on the PowerPoint.
and it's the truth.
I don't remember it, but yes.
And you spent $60.43 at Market Basket.
Is that what happened?
It is what happened.
Okay.
Do you agree with me that that's what happened?
I don't remember it, so if you have fact that says that, then I agree with you.
And you left New Hampshire around 3:45 on Friday. Is that the truth?
Yes, that's what the geolocation thing provided.
Well, Mr. Filazzo, you testified today that you left New Hampshire on Friday afternoon, so you remember that.
I don't remember the exact time.
And you stopped in Andover for gas,
Yes,
and you spent money on gas, $27.09,
okay, I'm agreeing with you.
and you stopped in Lebanon.
Is that correct?
That's the
I
truth. You
don't-
stopped in Lebanon.
Okay.
All right, you're welcome.
Right, go ahead.
Okay, thank you. You got to Vermont, and you stopped at Crossroads Beverage in Waterbury.
I did see that on the PowerPoint, yes.
And you spent some money at Crossroads. You got some gas, $40.
Okay.
And you bought a bottle of liquor at the liquor store, $22.40.
Okay.
And then you went to your sister's Airbnb,
Yes.
parked in the parking lot,
Correct.
and you got there around 7:20 on Friday night.
Yes.
And we can all agree that at 7:20 on a date in the middle of October, it's dark in Vermont.
Yes.
And your sister was still in Burlington,
Yes.
and you texted with her,
Yes.
and she and Ariel stopped by the camper to talk when they got back.
That's correct.
And you guys discussed plans to go and watch Netflix inside.
That is correct.
But you changed your mind and didn't go watch Netflix.
That is correct.
And you texted Nikki at 9:39 and said you weren't coming in. Is that correct?
I don't remember sending the text, but you have it there in front of you, so,
And you said to her, I'll see you in the morning.
all right,
And you said, you still drink coffee?
all right.
Said that to your sister?
That was what I said to her? That's, you have that?
Would you like to see the text?
I don't remember the text. I don't remember the text exactly, so if you have them, then,
Do you want to see them?
I mean, I don't have to. If you're gonna read them to me, then we can do it this way, or,
So you've testified that Emily was mad when you got to Bolton,
she was angry.
and she was mad about Jolene.
I would believe so. She never said anything about that to me, so I don't know if I should speculate on that or not.
Well, Jolene's your ex-wife,
Correct.
and Jolene lives in the same condo complex as your sister's Airbnb.
That's also correct.
And
approach.
so Jolene lives in the same condo complex as your sister's Airbnb.
Correct.
And that was the first thing that came up when you put the car in park, was Jolene, correct?
She was never brought up.
You sent a text message to Jolene on the 17th. Do you remember texting Jolene?
I don't. I
And
don't.
you were texting about wishing that you could have seen her when you were in Vermont.
Okay.
And you said to her that you couldn't see her because it was the first thing that came up, and I said I wouldn't. I want to take Bear for a walk with Remy. She only turns around to kick me to the curb. It's no big deal. I spent the day with my sister. It was awesome. Remember sending that text?
I don't.
So Emily's mad at you. You guys argue, is that correct?
Yes.
And she's rebuffing you.
Yes.
She doesn't want to dance.
No.
She doesn't want the candles on.
Correct.
She just wants to go to bed.
She didn't say anything to me.
She went and laid down in the bed.
Yes.
She's facing outward, scrolling on her phone,
Yes.
and she's saying hurtful things to you.
She was muttering something.
She was saying things like, I don't want to be with you. This is stupid.
She was saying that she didn't want to be there.
She was saying, you're pathetic.
Yeah, she said this was a pathetic trip.
You told police that she was grumbling a bunch of shitty, hurtful things.
That's what I said.
And that's what you remember.
I remember her muttering some things. It was inaudible things.
You're sitting down on the couch, correct?
When?
When Emily's saying these hurtful things to you. You're sitting on the couch.
No.
You're in the bed.
No.
You're standing in the aisle.
Yeah, I was doing some.
You're yoga dancing.
Yes, that's correct.
And you say that you light some candles,
Yes,
and Emily doesn't like the candlelight.
that's correct.
And she tells you to put them out.
That's also correct.
And you don't put them out.
No, I don't.
And she gets up and she grabs one of these candles,
Yes.
these big Yankee candles,
Yes.
glass,
Yes, ma'am.
heavy.
Very.
And she starts hitting you in the head with it
Yes, ma'am.
and in the body.
Yes, ma'am.
And you're able to grab onto her and get the candle away from her.
That's correct.
And that is over. She goes and lays back down.
Yes. Well, actually, I didn't see her lay back down. I grabbed the puppy and went outside.
When you came in, she was in the bed,
Yes.
and you are trying to relax,
Yes.
trying to enjoy your vacation,
Yes.
and you make a decision,
What decision?
the decision that you need to stop this.
I was having some drinks and smoking.
You decided enough is enough. I'm going to put an end to this.
No.
You got up. You
From-
got up from the couch where
I
you were
was-
having your drink.
I wasn't on the couch.
You told the police that you got up.
I don't remember talking to the police.
You heard yourself tell the police that you got up.
I saw a video.
And you
I was-
heard yourself tell the police that you got up.
I saw the video.
Did you hear the video?
I heard the video.
And you heard yourself tell the police that you got up.
That was on the video, yes.
And you heard it.
Yes.
And you got your Glock.
Are we talking about the video?
I'm talking about what happened. You
Right.
got the Glock
Correct.
and you put the pillow over her head.
I hit her with a pillow at one point.
The pillow was over her head when you shot her.
That is correct.
And it was over her head when you shot her the second time.
That is correct.
And when you realized that you had just shot your wife, you didn't call 911.
No.
You didn't go and get your sister.
No.
You had another drink.
I sat with Emily for a while before drinking more.
You actually put a bag over her head.
I put a bag under her head.
Mr. Ferlazzo, you put a bag over her head.
I put a bag under her head.
You tied a bag around her neck.
When at some point there was the next day I had to move her body from the bed to the floor of the shower, and I wrapped the bag around her head and tied a bag around her neck to
You
move
remember doing that.
to move her body.
You remember doing that.
I remember you saying it.
You remember doing that.
I remember putting a bag under her head.
You cleaned up,
Yes,
you picked up her shoes,
yes,
you picked up her phone,
yes.
you shut her phone off.
Her phone was off.
You told the police that you shut her phone off.
I told Emily to turn her phone off.
You shut her phone off after you shot her.
Her phone was off. She shut it off.
You put her wallet in a bag.
No,
You told the police that you put her wallet in a bag.
I don't remember talking to the police.
I understand that, Mr. Ferlazzo, but you've listened to the video and you've heard your words. So you told the police that you put her wallet in a bag, correct?
I did see the video.
And you heard you utter the words, "I put her wallet in a bag."
I don't remember that.
You heard
Oh,
yourself
the
say
video
those
from
things.
on the video?
Yes.
I saw the video. Yeah.
And you heard yourself say, "I put her wallet in a bag."
Yes, I did. Yes, I did.
And you heard yourself say, "I shut her phone off."
Was that on the video too?
You watched the video.
Yes.
You were here with us.
Right.
And you heard yourself say, "I shut her phone off."
Yeah, the video is disturbing to me to watch. There's a lot of it that doesn't make any sense to me. So I don't do a good job on focusing on the details of it.
I understand it is disturbing, but we heard you say, "I shut her phone off." Did you hear that?
I do recall the video saying that.
And the person on the video who was saying that was you, Mr. Ferlazzo.
Yes.
And you told the police,
I'd like very brief to approach.
so Mr. Ferlazzo, you told the police that you shut Emily's phone off. Is that correct?
From the video? Yes. I said that on the video.
And you told the police that you shut her phone off because she wasn't going to be using it anymore.
Like I said, I don't remember the video. It's hard for me to focus on the details of it. So if that's what happened, then my recollection is different.
So if that's in the video, you said that.
if that's in the video of
You're
me.
not contesting that that was
I'm
some
not-
other person
I'm
in the
not
video.
definitely, no, I'm not. That's, there's a video of me saying a bunch of stuff on the video.
And you put the bloody pillow in a garbage bag,
Yes,
and you put the red throw pillow in a garbage bag. Yes?
yes,
You flip the mattress over.
yes,
You put new sheets on the bed.
yes,
You put new blankets on the bed.
yes,
Put some new pillows on the bed.
yes.
And you never called the police.
I did not.
After you shot Emily, you continued to text her phone, correct?
Yes,
And you continued to call her phone.
yes.
And this was the phone that you turned off.
I didn't turn her phone off. She turned her phone off.
This was the phone you put in a bag.
I didn't put a phone in a bag.
This was the phone that you threw away somewhere.
Yes,
You texted her when you were at the Langs on Saturday.
yes,
You texted her when you were out to dinner with your sister. Yes?
did I?
You testified on direct that you texted her when you were out with your sister at dinner.
I remember texting her. I remember Nikki bringing my phone, and I remember texting her. I don't remember texting her at dinner.
You testified when Attorney Jantz was just asking you that when you were out at dinner, Nikki was asking about Emily and you texted her.
That was when I was at the Langs.
You weren't eating dinner at the Langs, you were eating dinner at Twigs.
I remember texting Emily's phone. I remember texting her phone at the Langs house. I don't remember texting her phone at dinner.
You texted her at the Langs house, that is correct.
Right,
And you did text her when you were out to dinner with your sister Nikki.
I did?
You called her multiple times,
Yes, that's what it showed on the phone record.
and this was the phone that was shut off,
Yes,
and the phone that was somewhere in the garbage or in the river.
yes,
And you texted her throughout the weekend.
that's what the records say.
And you called her throughout the weekend.
Yes,
So Saturday morning, you decide to make coffee.
yes,
You don't call the police on Saturday morning.
no,
You don't tell your sister on Saturday morning.
that's correct.
You bring coffee to your sister.
Yes,
You go take a shower in her Airbnb
yes,
because Emily was in the bathroom of the RV.
I moved Emily from the bed to the shower floor, the bathroom of the RV.
Yes, we are back, y'all. Yes, we are back. We are back, people. So this, I believe, is about to be the verdict. Unless he's about to dismiss everybody to go home. We're about to see. We don't know for sure that this is the verdict. Yo, they got a dog in court? Hey, they don't play in Vermont. Oh, well, I guess Glanville had a dog in court too. Huh? I guess dogs are welcome in court. But this, her dog is chilling. So let's see if this is a verdict. Is Miss Lily here? Don't tell me Miss Lily's not here. Law and Crime says it's a note. Okay. Maybe it's not a verdict. Let's see. Note from the jury. Okay, so we're here to see a note. Okay. So it's not, maybe not a verdict. It's maybe the jury saying, yeah, we could take longer, or we could just go ahead and send this guy to the electric chair. You said Remington was a little dog. That dog didn't look small to me. I wouldn't call that a small dog, so I don't know. Yo, so you saying this? What you wrong about, Miss Lily? Lady said Remy had a little dog house. Yeah, that's not Remy. Remington, excuse me. It's not Remington. Remington will be smaller than that. You said Remington's a small dog. That dog's like, yeah.
It's common. Me too. I want to know what they're trying to question. So he'll tell us.
All right, we're back in the record in State versus Joseph Palazzo. It's about 5:40. There's a note from the jury. We've marked Court's Exhibit 1. It reads, Mr. Court Officer, may we please have a copy of the testimony with Joseph Palazzo being questioned by the defense? And it's signed the foreperson. We, of course, can't give a copy of the testimony. I will let them know that they can hear the testimony, but that would take 4.5 hours. So we'll see whether that is what they're really asking, or they want to narrow the request, or what they wish to do. But at this point, I'm not going to do any. I'll let them go back and tell us what they want. If they want the whole thing, they'll get the whole thing. They'll get it tomorrow, because I'm not going to do it tonight. As I mentioned, I really need to leave it around 6 tonight. So I'm going to bring them in now and explain we don't have copies, that we do have it in they can listen to it, but we certainly can't do that tonight. And if they still want to hear the whole 4.5 hours, they get to hear it. If they don't, then we'll see what they want to do with it. Okay?
Yes.
So y'all, you know how they always say you never know what a jury's thinking. We thought this would be, yo, let's go in here, let's drink a cup of coffee, let's act like we're doing something, let's let's act like we took our time, but we all already know we're gonna convict this dude of. Maybe we're gonna debate whether it's first degree or second degree. Right? First degree or second degree. Maybe there's a debate about which degree of murder does he get. But so maybe they're trying to determine if it's first degree or second degree. That could possibly be it, Some people might be saying, well, it's first degree. Some people might be saying, well, it's second degree.
Please be seated. We have all 12 members of the jury present. We have the jury's note marked as Court's Exhibit 1 that reads, may we please have a copy of the testimony with Joseph Filazzo being questioned by the defense and signed by your foreperson, Ms. Reno. I don't know if you want a transcript. We don't have that. So if you want to hear the entire testimony, we can do that. The defense portion was about 4.5 hours. Or if there's more selective pieces that you were more focused on, that can be up to you. So we'll let you discuss that and let us know if there's something, whether you do want to hear the whole thing, that's perfectly okay. We won't do that today. We would do that tomorrow. In fact, whatever you want to hear, we'll probably do tomorrow because today we need to retire by about 6 o'clock. So and that the court has other things, unfortunately, it has to do this evening. So we can either, I think it would be good if you just at least had a little time to see if you exactly what you want, given this note and given the fact that we don't have a transcript of it. And if you know that, we can get another note. So if we're going to produce anything, we'll have it ready in the morning. Okay? So we'll ask you to retire and see if you want to do anything further.
May I answer? We do know the specifics that we'd like, so.
Okay. Why don't you write in a note so that we have it specifically and then get it back from you? Okay? Just so we have a record of it. Why don't you hang around? Just say we'll be, I assume, a couple of minutes.
All right, y'all, let's just wait. I think they'll probably read this in court because he just said, I will let you hang around. So let's just wait and see what the jury says, and then we'll wrap it up. Yeah, I think for sure that they're probably talking to each other about whether it is first degree or second degree. Some people might even be on the manslaughter side. I'd be very surprised if they were trying to consider self-defense. Like, I would be shocked. From the testimony that I heard, I would be very surprised if anybody on that jury is like, no, he could have been defending himself. Yeah, I mean, it would be surprising if it were manslaughter as well. But still, murder, first and second degree murder and manslaughter, when compared with the self-defense, which is the other possibility, those three are at least in the same kind of category. No, Tat, there's no verdict. The jury wanted to hear a part of his testimony, but the judge can't get it loaded up today. So they're going to tell the judge in a note what part of his testimony they want to hear. And then the judge is going to get it loaded up for tomorrow. So they'll be back. Yeah, they might give him second degree murder. I mean, I didn't hear anything that he said that would indicate to me that it was anything less than first-degree murder. He did try to establish a pattern of abuse. I can kind of believe that she might have hit him before. I mean, that doesn't really change my calculation of first or second degree murder because she was in the bed at that time. I mean, it's not like she was up and out and threatening him with the gun and stuff or anything like that. I mean, she was in bed. So I think this seems like a first degree murder situation, but they might be trying to determine between first and second. He was charged with first degree murder, I believe, right? Yeah, because if he wasn't, he couldn't. So he's charged with first degree murder. He's charged with first degree murder. That's the only thing I can think, but it's going to be interesting to hear if they read in court what part of his testimony they want to hear about. Juries are interesting, though. You know, you get 12 people in there and they start talking and somebody says, did he say this? And everybody else is like, that's that, you know, if y'all remember with the YSL trial, when they wanted to hear the songs, we all thought, oh man, are they trying to analyze the songs in light of the facts and blah, blah, blah. And it turned out, no, there was somebody who was, I mean, according to the jurors, there was somebody who spoke English as a second language and they just wanted to hear the songs back. Maybe they didn't understand it at first or something. So you kind of really never know what's going on with jurors in their minds. Somebody might have thought that they heard him say this and everybody else is like, no, he didn't say that. And they're like, yeah, I'm pretty sure he did. No, he didn't. All right, well, let's just ask for the transcript so we can verify. This is somebody's life on the line. We need to be sure. Let's ask for the transcript so we can be absolutely sure of what he said. And then, you know, so that's probably something like what's happening right now. Well, Ms. Flins, remember, they don't get to watch it back like we do. So they don't have the same experience of the trial that we have. They're there in person. They're trying to take notes. They're trying to do a good job when somebody's life is on the line. They don't get to go home and review everything. They don't get to just freely fast forward, pause, talk to their friends. They don't get to talk to their friends about it as it goes on. So they just have a totally different experience than we do. And I mean, if anything, it should prove that part of your experience of something is like who you're with, what the conversation is, you know, all of that stuff influences. I don't think they're going beneath second degree murder. I don't think they're giving them manslaughter, and I definitely don't see any chance at all of not guilty. Like, I just don't see that. So that would be very surprising. I think they're going to say they have to communicate that to his lawyer in case she wants to object. I mean, I'm sure it would be overruled, but I'm thinking they have to communicate it. So I think they will read it. Whether we get to hear it or not, it's another story. I don't know what they're talking right now, LTK. Yeah, if they read into the transcript, I think. I mean, we heard in Fulton, we heard all of the jury questions. So I don't see why we wouldn't hear him here. The judge did not go over any of the possible sentences. If y'all are asking what kind of time does he face, Yeah, I did get my steps in. I did. The judge did not go over the possible sentences, like how much time he's facing, so we don't know. I mean, it's a long time. Second-degree murder is certainly going to get you a lot of time. First-degree murder is going to get you behind bars for probably for life. So this is the kind of guy you don't want on the street, people. This is the kind of guy. A lot of times you think about a guy who you don't want on the street, and you think of a thug or somebody's going to rob you or steal from you or whatever. Yeah, okay. Maybe. Yes, absolutely. I'm not even going to say maybe. Yes. But this is the kind of guy who you don't want on the street as well, because he's the kind of guy who could do it again. He is the type of guy who could do it again. This is the kind of guy who could do this again to another person. He is the type of person who has a problem. And no, you do not want. No. All right. So we gonna turn on it?
Court's Exhibit 2 is a note saying, may we please review the defense attorney questioning Mr. Filazzo. The specific time period we would like to review is when the defense is asking Mr. Filazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast.
That's fine. My only request is that I may have asked him about that on more than one occasion, and I want to make sure that they hear all the testimony he made. So I don't.
We'll see what
That's
we can
my
do.
request. He may have testified about it on more, as you know, as you just
Somebody in
said,
your
4.5
staff
hours.
should have notes of the events, I would think.
I don't have any timestamp, and I don't have. The court's in the best position to review the
See what we can
4.5
do.
hours.
We're not going to do this tonight.
I'm sorry?
We're not going to do this tonight,
Okay, no, I know that.
but
I'm
we'll
just
look,
asking,
we'll
they've
look
asked for a
through what we've
specific
got.
time period, and I'm saying that it may, he may have testified about this time period on more than one occasion over the 4.5 hours. And I want to make sure they hear all of his testimony.
All right. That would include any texts he wrote. I think you would have talked about that too. I don't know if you did initially.
I may have. Could the court read their note again, please?
Yeah. The specific time period, I'm going to just read part of it.
Yeah.
Specific time period we would like to review is when the defense is asking Mr. Filazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast.
Until breakfast, okay. So that narrows it down. My request, I will just say again, is that he may have testified about that time frame more than once over the course of the direct testimony, and I want to make sure they hear all his testimony about
I've heard you.
Thank you.
Okay.
Judge, ready to go.
Let's get them in because we'll tell them we'll try and get it in the morning. Probably ask him to get here around 8:30, but let's get him in the courtroom.
So y'all, yeah, Nishi, the jury can decide on first or second degree murder or manslaughter. They can decide any of those three, or they could decide not guilty. So he can be guilty of first degree murder, second degree murder, or manslaughter, or he could be not guilty. The judge made it very clear that they have those 4 options. The jury wants to hear the entire series of events, though, that happened with him and his wife. So they're basically, it sounds like they're unsure. Like, what's the difference between one or two? I would go back and play it, but I'll Google it. Give me a sec. Give me a sec.
Please be seated. We have your more specific note, which reads, it's Court's Exhibit 2. May we please review the defense attorney questioning Mr. Filazzo. The specific time period we would like to review is when the defense is asking Mr. Filazzo to recount the events of Friday night from around the time period after Nicole and Ariel leave the camper until breakfast. That gives us a pretty clear idea. It will take us a bit of time to get that, which suggests to me it's probably a good time to adjourn for the day and let you come back fresh tomorrow. We'll, in the meantime, try and get the testimony that you are requesting. It may be not all in one chunk. There may be other things, so it'll take a little time to see if there are places other than in one full period where it is, or whether there's other times that time period is discussed. So in the meantime, have a good night tonight. Please, most important now, not to discuss the case with anybody or to look at any media or any device which might broadcast this. It's critical that you just discuss this case with each other and learn nothing else about the case except what you already know from the evidence in the courtroom. Okay, so good night. I'll leave it to you, 8:30 or 9. Would you like to start? 9 o'clock. All right, we'll see you then.
All right, y'all, I'm gonna wrap it up. Let me just say quickly here that let me just answer Miss Lely's question. Yeah, they're going home. It'll probably be a verdict tomorrow, y'all. They looks like they're gonna have to review quite a bit of testimony too. So probably, what would you say, at least an hour's worth? If it's a 4-hour direct, they're probably gonna be looking at half an hour to an hour worth of testimony. So let me say this real quick. Miss Lely, and for everybody else, I Googled this, but we can review it tomorrow from the judge's instructions. The difference between first-degree murder and second-degree murder in Vermont, not talking about the penalty, just talking about what's required. In first-degree murder, it is required that there be premeditation. And in second degree murder, it is, so first degree murder is premeditated and deliberate. Premeditated means you planned it, even if for a moment. So this is probably, they're probably trying to decide between first and second degree murder. And I was thinking this earlier too, because I'm like, did he plan it? Or did he just decide on a whim to go kill her? See, if he didn't plan it, if he just, he's just sitting there, man, she gets on my nerves. Oh my gosh, man, I can't, you know what? It's over. And he just goes and kills her. That would be more like second degree murder because he didn't plan it. But if he goes and gets the gun, puts the silencer on, and then goes and kills her, that would be more like a first degree murder because even if he planned it for like 30 seconds, that would be more like first degree murder because that's premeditation. So So it really would come down to, does the jury believe that he planned it, even a very quick plan? Yeah, that's the 5-minute thing. Exactly. The 5-minute thing is where the prosecution is trying to convince the jury, no, this is where he started to plan, and so I think they're probably trying to decide, yeah, he killed her. Yeah, it was murder. Was it an actual plan, or did he just spontaneously make that decision? If he just made it spontaneous, he might get the 2nd-degree murder. If he planned it even for a little while, even for 30 seconds, then it would be 1st-degree murder. And it seems like there's some gray area there. I mean, he put a pillow over her face or a blanket or something, so I think they're probably deciding between those two things. All right, y'all, I'm about to go. See y'all back tomorrow. Y'all know how we doing it. Thank y'all for being here all day. So Andre, he did the cleanup and stuff after. He did the texting and stuff after. That would be after the murder. Now, can they take that into account and say that he had planned to do all that before the murder? I don't know. I don't know. I'll see y'all tomorrow, y'all. Have a good evening. Appreciate y'all.